right, we are back on the record on this file. I do want to reflect for a moment that this is kind of an unusual case. The petition was filed September 1st, and we did have a hearing that same day. We welcomed Ms. Frederica Gavin on the file from a tribe out of Alaska. At the end of the day, she had requested for us to give her some more time to review the allegations in the petition. So we adjourned to the 13th of September. And at that time, there was discovered to be Ms. Gavin as a contradiction or a conflict, I should say. And we had the president of the tribe join us for a few minutes. But again, there was a request for more time to allow the QEW that was anticipated to take over also as the caseworker to appear, and for Ms. Thomas to be able to appear as well. So here we are today on the 25th, back on the record on the same case. I've allowed Ms. Thomas some time to talk with our newest representative for the tribe, as well as the president. And I've spoken with our attorneys that we have in-house here as well about the case. And as I understand it, there may be a petition coming alleging that the father in this case will also be indicated as a respondent. Neither the father nor the mother has appeared today, unfortunately. We do have some of the attorneys, however, so let's go to appearances.
Lead Heist, lawyer guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Ms. Fullerton.
Amy Fullerton for the department.
Michael McFarland representing mother, who is not present, Your Honor.
Have you heard from your client?
I have. She called me. I returned her call. Her number is not accepting calls.
Well, thank you for that update. We'll look for any additional updates on the locations of the parents. Any comments on the, actually, we need to introduce our tribal representatives. If we can have your names for the record, please.
Kiera Melton.
I'm sorry. Kiera,
Kiera
right?
Melton. Yeah.
Will you spell it for us one more time, please?
Kiarahmelton.
Thank you so much. And you are the anticipated qualified expert witness, as well as the thinking you'll be the caseworker from the tribe, is that right?
Yeah, the equal coordinator.
Thank you, I appreciate that. All right. Mr. President, would you like to introduce yourself? Can you hear us okay? Perhaps Ms. Thomas, you could tell us a bit about his role. I know you were able to speak with him.
Yes, Your Honor, my understanding was that Ms. Melton would be the case manager worker, but that she would not be testifying as relates to the qualified expert witness. That would be Mr. President, and I believe the first name is Percy, but I'm not sure on his last name, but that he would be our expert witness. That is my understanding.
Good afternoon.
Good afternoon. Hello. Could you give us your full name and spell it, please?
Yeah, Percy Ballard Sr. I'm the president of Native Village Buckland, and I will be doing the corporate expert.
Okay. Is your first name Percy?
Yeah, Percy.
Thank you. And how do you spell your last name?
Ballard, B as in boy, ALLOT. Senior. Okay.
Thank you. Okay, got it. All right. Comments for the record on the sidebar or the case, Ms. Thomas?
Thank you, Your Honor. I was able to speak with the tribal members that are present with us today, representatives. And it was my understanding that there was support for the removal from mother, because our petition specifically referenced making efforts to get the child back with her father. since then, there have been allegations made against father, and we are going to file a petition naming him as a respondent today. And so I discussed with the tribe representatives adjourning this one more time so they could have an opportunity to review the new petition and whether the removal is still appropriate according to their standards.
As I understand it, an ICPC request for relative placement is also pending. Are you familiar with that?
That is my understanding. There are paternal grandparents in Alaska and another relative, I believe, in California, and I can confirm that with Ms. Fullerton if she is sworn in.
Well, before we do that, any comments on the sidebar, Mr. McFarland, Ms. Heist?
I believe that's covered. I take no position though without a client.
I just informed the court that I visited with the child and her needs are being met in her current placement.
Thank you. All right, we've had a development. It appears we've had Ms. Carla Collier join us. Okay, I have someone logged in from Carla Calyer. Would you please introduce yourself?
Hello, I'm here. I'm sorry I've been having technical difficulties this morning, Your Honor.
All right, and your name is?
Carla Collier.
Thank you, welcome. We'll make some time for you to speak with your attorney, but you should know that members of the tribe have appeared today, and it looks like there's going to be a request to move the hearing one more time for further investigation. But we'll give you some time to talk to Mr. McFarland in a moment. Okay, Ms. Thomas, you wanted to hear from Ms. Fullerton?
Yes, Sharon, I believe that she can testify as to the ICPC progress.
Very good, Deputy Ames.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Fullerton, how are you familiar with this matter?
I currently supervise Cameron Kuzik, and he is the assigned investigator to this case.
And have you also worked closely with him during the investigation of this case?
Yes, ma'am, I have.
And as you've heard, there have been, or can you please provide us an update as to whether ICPC packets or inquiries have been sent out for this file?
Yes, ICPC packets were prepared for both a paternal aunt who resides in California, as well as the paternal grandparents who reside in Alaska. And both ICPC packets were sent on 9/19.
And do you have any estimate, or can you give us any information about that process and how long it might take?
I really cannot speak on that, other than that I do know that it will probably take at least 6 months.
And do you have any update on the whereabouts of either parent?
My understanding in speaking with a foster care worker is that Miss Collier is currently living at a campground in Kentucky. We had a scheduled family team meeting last week that she did not show up for. My understanding is that Dad, Mr. Thomas, is possibly incarcerated in the state of Washington, but I can't be 100% certain that he is indeed lodged. However, he has been charged with a couple of counts of CSC.
Thank you. And have the grandparents or the paternal aunt and paternal grandparents, have they been invited to participate in any of the family team meetings or anything like that, to the best of your knowledge?
No, that is our intent. We wanted to have separate family team meetings first with both mom and dad. to just kind of go over some ground rules. And then our plan was to move forward with having meetings with both the grandparents and the aunt and uncle, or the aunt, I should say.
Okay, thank you. Your Honor, I have no further questions of Ms. Fullerton as it relates to the ICPC process right now.
Questions?
I do. For the record, what is ICPC? I'm sure my client does not know the abbreviations. I may not either, quite frankly.
It's our interstate compact. They're the agency that's responsible for doing all licensure of relatives outside of the state of Michigan. And it's actually every state in the country utilizes ICPC in order to streamline processes for transferring children across state lines.
When you said my client did not appear for the family team meeting, it means she did not participate because obviously she's out of state and could not appear, correct?
Well, it was a Zoom FTM. Ironically, she had been reminded of the FTM and did not show up, but about 45 minutes after the scheduled FTM, she did put a message on a group chat on Facebook that we use at our agency that didn't really have anything to do with the FTM or why she missed that.
Okay. And how do you know that the interstate study is going to take 6 months?
I don't know that to be the case. However, in my experience, that's typically, it takes upwards of 6 months, but perhaps it can be shorter. I do know that Mr. Thomas's parents in Alaska, I believe, were studied for the last situation where Uta was in care. So I don't know if that may affect this case, and maybe it will not take as long. But I do know that they also have other grandchildren in their care, but are still willing to care for Uta.
Nothing further.
Ms. Heist?
No questions, thank you.
All right, Ms. Fullerton, is there a way to request for an expedited investigation?
We can certainly do that. I can't make any promises, but I can certainly make that request.
Would the search be aided in expediting it in any way, considering the tribal affiliation in this case?
Possibly. That is possible. We certainly can explore that.
Thank you. Ms. Thomas?
I have nothing further.
Any questions based on my questions?
No.
No, thank you.
Okay, thank you for your testimony, Ms. Fullerton. So let's just go to Ms. Calyer for a minute. Ms. Calyer, if you could unmute Teams, if you could swear in.
Yes, Your Honor. Sorry, I'm having difficulty hearing. I'm actually, I traveled back home to Seattle because the place where I was staying.
Ms. Collier?
Yes, sir.
Can you hear me? This is Deputy Ames. Can you raise your right hand, please, and let me know it's raised so I can swear you in?
Yep, raised it.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Ms. Calyer, I'd like to know if you have received a copy of the petition.
I have not received anything, Your Honor.
Okay.
I'm sorry, I'm having technical difficulties today.
Okay, do you have an email address that we could use to, I have here Collier Carla65@gmail, is that right?
Yes, Your Honor, and I have not received anything from that email yet, Your Honor.
Okay, so Ms. Fullerton will ask you to go ahead and resend the petition, please, to that email address and give us a proof of service and a copy of the email, please.
Yeah, I believe that Mr. Kuzik already did that for I don't know if she thinks there's a different petition. Well, there will be another petition, but I'm pretty sure we have a proof of service for the first petition.
What I have is that she was potentially served by Mr. Kuzik at the Super 8 Motel in Adrian with a petition in order of removal.
That is correct. Yeah.
Okay. So Ms. Calyer, do you recall receiving that at the Super 8?
Yes, Your Honor. I wasn't sure if it was that or it was a different thing, Your Honor. I apologize for the confusion.
That's all right. And we've already determined that your child is eligible for enrollment in a tribe up in Alaska. Are there any other tribes that you think would be a tribe that we would need to inquire into?
Not at this time, Your Honor.
And are there any other cases concerning your child that you're aware of for child support, custody, visitation, et cetera?
Not that I'm aware of, Your Honor.
Okay, well, you have the right to admit or deny the allegations in the petition and to request placement of your child at today's hearing. I'd like to give you a chance to talk to Mr. McFarland about those options. Would you like to talk with him?
Yes, Your Honor, I'd be very appreciative of that.
All right, very good. And we're looking at coming back together on October 4th at 1:30. Would you be able to join us by Zoom at that time?
Yes, Your Honor.
Very good.
Yes, I
All
believe.
right. Ms. Calyer, do you know by any chance where Mr. Thomas would be at this time?
No, Your Honor. Outside of the threatening messages that I got and blocked him because of, I don't know where he's at. I try to avoid him for my own safety.
That's fine. I respect that. I just need to ask you that question. So thank you for answering. All right, attorneys. At this time, I'd like to recess, allow Mr. McFarland to talk with his client. What are your thoughts?
Yes.
I would agree.
Okay. Do we need the tribe to continue on?
I don't believe that's necessary if they're aware of our next court date. And we will do our best to make sure that they get a copy of the petition and notice of hearing as soon as
Okay.
possible.
Very good. All right, Ms. Melton and President Ballot, we will be taking a break to allow Mr. McFarland to talk to the mother here, Carla Collier. You're welcome to stand if you wish. But probably what's going to happen is we'll just be adjourning today and we'll come back together on October 4th at 1:30. That's all for today. Thank you.
Utica Collier, file 23168.
All right, we are back on the record on this file, still at the preliminary stage, still needing to hear from our qualified expert witness from the tribe. We were delayed in beginning today's proceedings to allow Mr. Brooks to chat with Ms. Collier, mother in this case, as well as to let Ms. Thomas talk with our tribal representatives and expert potential witnesses. I'm still waiting for Ms. Heist's device to successfully join our meeting. But something else came up as it relates to notifications on Mr. Thomas. So let's do appearances and then we'll catch everything else up. Ms. Heist, welcome. Thank you for your patience.
Yeah, thank you. Lee Heist, lawyer guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Cameron, go ahead and put your appearance on.
Cameron Kuzik, caseworker for the department.
Okay, two things. Number one, move that microphone a lot closer to you. It's the larger piece and it's Velcro to the table.
Give it a yank. Microphone.
Deputy Ames, would you mind arranging that for me?
What you're holding is a button that mutes.
Okay.
The other piece is the microphone.
Oh,
Yeah, move it nice and close to you because you're very soft from where I'm over here. And spell your name first.
Kameron.
Last name?
Kuzik, Kuzich.
Okay, thank you.
Michael Brooks, I represent the mother, Carla Collier. Ms. Collier, will you identify yourself, please?
Yes, Your Honor, I am here.
Who's I? What's your name?
Carla Collier, Uta's mother.
Thank you.
Very good. And from the tribe?
Yes, Percy Ballot.
Okay. All right, let's do that one more time. Percy, Percy, right?
Yeah, Percy. Ballot, B as in boy, ALLOT.
Ballot.
And Kiara Melton.
Okay, Kiara is Kiarah, is that right?
Yes.
And then Melton is Melton, is that right?
Yes.
Thank you. All right, Ms. Thomas, as it relates to efforts in the appearance of Mr. Sean Thomas, if I could hear from you on that officially on the record, please.
Thank you, Judge. At the last hearing, or during that last hearing, it came to our attention around that time that Mr. Thomas was incarcerated. And in part for the reasons why we filed a petition against him, we were unable to confirm how to secure his presence to participate in this hearing. We do have a proof of service that the petition, and I believe the notice of hearing was sent to the facility. I'm not sure, we don't have a proof of service that indicates he was personally served or actually received it. But he is not here today.
All right, and that's important because we've had an amended petition filed September 25th, which does indicate he is a respondent father. What the court would be inclined to do would be to adjourn only as it relates to Mr. Sean Thomas and set another date for his opportunity to have a full preliminary hearing, to be introduced to the petition and to secure him an attorney. But to proceed as it relates to the child as well as the mother for purposes of today's preliminary hearing, and of course, testimony from our qualified expert witness, unless there's any objections. Mr. Brooks?
No, I have none.
Ms. Heist?
No objection.
All right.
That was scheduled. What the hell is that? It's your government at work.
Okay. Anyway, don't worry. It informed us it was not actually an emergency. So we'll carry on. Mr. Brooks, let's run through a couple of preliminary things. I think we may have done this already, but do you? Oh, shoot. Holy cow. Okay. Can you confirm your client has received and you've been able to talk with her about the petition?
The answer is yes to both questions.
Thank you. We know she potentially has some Native American heritage, which is why our tribes are here. Are there any updates on any of that information?
No, Your Honor. My understanding is the connection is through the biological father, not the mother.
All right. Have you confirmed that she has or has not any other connections?
No, I have not.
Okay, so we'll ask her about that. And then finally, are there any other cases filed or pending that concern this child?
I did not ask the question.
How does she wish to proceed?
We would like a bench trial on the numerous allegations contained in this petition.
All right. And is she seeking placement today?
Yes, she has asked for placement.
Thank you. All right. It is a new amended petition. She has the right to have this read into the record. Have you talked with her about that? Do you know if she'd like to waive that right?
I didn't ask her that question either. I hate that question.
All right. Deputy Ames, would you swear in Ms. Carla Collier, please? While you're at it, maybe Mr. Cameron Kuzik. And I'm assuming we're going to be hearing from our QEW, Mr. Ballot. Is that right, Ms. Thomas?
Yes, Your Honor.
Okay, so if you could swear in, please, Percy Ballot, Cameron Kuzik, and Carla Collier.
Yes,
Can you hear me?
yes, I can.
Thank you. If you're on Zoom, I can't see you, but hopefully you can hear me. Can you raise your right hand, please, and let me know when it's raised?
Yes.
You have someone else on Zoom that needs to acknowledge?
Yes, Ms. Calyer?
Yes, Your Honor.
Is your hand raised, your right hand?
Yes, Your Honor.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes.
Yes. Thank you.
Thank you, ladies and gentlemen. Let's go to Ms. Carla Collier first. Mr. Brooks, would you like to do the inquiry?
Ma'am, you heard the judge's questions about any blood connection you have to any Native American tribe or band, did you?
I'm not native that I know of, Your Honor.
Any connection to do with Native American tribes would be through the child's biological father?
Yes, Your Honor.
All right. Do you want this 6-page petition read to you line by line?
I would like it sent to my email if possible, Your Honor.
Don't you already have a copy?
Yes, Your Honor, but I would also like a copy of the email to save digitally if possible.
Well, before we go any further, it would appear that there is a proof of service indicating that this petition was emailed to you at colliercarla65@gmail.com on September 26th.
I will recheck my email then, Your Honor.
It would have been from Mr. Cameron Kuzik.
Okay, thank you.
So
Finally, it is my understanding after talking to you that you and I have agreed we would have a bench trial on these allegations. Is that right?
Yes, Your Honor, that is correct.
I've also advised you have the right, if you chose to have a jury trial. Is that right?
Yes, Your Honor.
all right, thank you. If you change your mind, you have 14 days to file that jury demand in writing.
Yes, Your Honor.
Okay, very good. As it relates to the testimony of your witness today, Ms. Thomas.
Your Honor, I guess I'll defer to the court if you'd like me to call the qualified expert witness first, or whether Mr. Kuzik would be most appropriate given the amended petition.
Whatever you prefer, Ms. Thomas.
My concern about the new allegations on the amended petition are that the only amendment was to add allegations relating to Mr. Thomas. Mr. Kuzik has already testified to the petition as it relates to Ms. Collier. And I believe that the reason for the adjournments have been to allow for the tribe to have a qualified expert witness present and to testify. So I will leave it at that.
Did you want to elicit any testimony from him on the amended pieces of the petition?
From Mr. Kuzik?
Yes, I thought you wanted to call him first.
My concern is that the father is not present, and that is the only amendment is the allegations regarding him.
Well, last time we were here, there was talk of trying to place the child with him because he was not a respondent. So if the request is to continue placement rather than, or continue foster care rather than returning the child to him, I think we need to visit whatever facts you have in support of that. And then we'll make arrangements to secure his presence at a subsequent hearing as expeditiously as possible.
Okay, Your Honor, then I will call Mr. Kuzik.
All right, he has been sworn. Go ahead with any questions you may have.
Thank you. Mr. Kuzik, did you draft this amended petition as relates to this matter?
Yes, I did.
And generally, the amendment includes allegations against Mr. Thomas. Is that correct?
Yes, that's correct.
And generally, what is the substantial risk of harm if the child were to be placed in Mr. Thomas's care and custody today?
Mr. Thomas is facing CSC charges. I believe as we said before, he's incarcerated. The concern there is that there could be potential risk, as I believe the allegations in his separate case were that he sexually abused a 15-year-old child that was not his child, but was a child of somebody, a acquaintance or a partner along those lines. And so I don't think it would be appropriate to place with him. Mr. Thomas also, when before we knew about these allegations, he refused the home placement when we were considering placing with him.
And after Mr. Thomas was aware of these proceedings, correct?
Yes.
And he was aware that originally there was going to be an inquiry as to whether he could get care and custody of the child, correct?
Yes, he was aware of this originally.
And did he make any efforts to fly to Michigan to obtain a custody order or file for custody or anything of that nature?
He only told me he was trying to contact his attorney and that he did not have the custody order. He was contacting his attorney for that reason, but he never told me that he found the custody order, and no, he did not fly to Michigan or make any efforts for that.
And has he been cooperative since then with the department?
No, he has not.
What efforts did the department employ to prevent this new petition from being filed?
Could you repeat the question?
Just needing to know what active efforts were utilized by the department to prevent the need for this petition.
Efforts were made to locate the custody order for Sean Thomas. I also spoke with the CPS worker and local law enforcement in Washington, where these charges with Mr. Thomas are being investigated, to corroborate the allegations that CPS was investigating. So I asked law enforcement so that could be, their statement could be corroborated with CPS's in Washington.
Thank you. And at this time, do you believe that Ms. Collier, there's been any change of circumstance in which Ms. Collier could provide proper care and custody to the child that is adequate to safeguard her?
No, I do not. Ms. Collier has been transient, has a history of being transient. She's in past CPS records has failed to have medication for the child when going from shelter to shelter. As of right now, I believe she the last address she had was in Kentucky. I believe now she's currently no longer in Kentucky and is in Seattle. So I don't believe that she's wants reunification with her child, that she's taking it very seriously if she's not local where the child is currently and is out of state.
Your Honor, I have no further questions of Mr. Kuzik.
Mr. Brooks?
No questions, Your Honor.
Ms. Heist?
No questions, thank you.
Thank you. Your next witness, Ms. Thomas?
I'd call Mr. Ballot.
All right, he has been sworn. You may proceed.
Thank you. Mr. Ballot, can you hear me okay?
Yes, I can.
Thank you. For the record, can you please state your role and what tribe you are affiliated with?
I am Percy Ballot Sr., and I'm the president of the native village of Buckland.
I'm
And
sorry, I
was
couldn't
asking-
hear the last part of that. You're a president of what?
Agricultural expert.
Okay, I think I have that information somewhere else too. Is it the native, the native tribe, the native village of Buckland? Is that right, Mr. Ballot?
Yes, Your Honor.
Okay, and that's Bucklin.
Thank you.
And that's in Alaska, right?
Yes, it is.
Okay.
Thank you. Mr. Ballot, do you know when the tribe was first contacted about this investigation?
September 1, no, wrong there.
And are you aware of whether someone from the tribe did attend the initial removal hearing?
Yes, the administrators for Rico Grabman. I think Pierre was off sick then.
Okay. And since that hearing, have you had the opportunity to review any documents that pertain to this matter?
Yes.
And recently an amended petition was filed. Did you have an opportunity to review that petition?
Yes.
Okay. And to clarify, that would it consist of a petition form, something called a JC04B, and then an addendum, which would be written on like a Word document?
Yes, sir.
Okay. And because you were not at the preliminary hearing to hear about active efforts, based on what you read in the petition, do you believe that the department made active efforts to prevent removal of this child from her family?
Yes.
And based on your review of the file, what do you believe constituted the active efforts?
That they were trying to make effort to let us know that what's going on with the child.
Generally, would you agree active efforts include an extended period of time facilitating community supports between the mother and for the mother and child?
Yes.
And would active efforts also include assisting in funding hotel stays when there was no other shelter for the mother and child?
Yes.
And would you also agree that active efforts include collaboration with law enforcement and other government agencies to ensure the factual accuracy of allegations against Mr. Thomas?
Yes.
And are those efforts culturally appropriate as they aimed to preserve the family?
Yes, they are.
And based on your review of the record, do you believe that those active efforts were successful in preventing the child from being removed from the parents?
Yes, we do.
You believe that they were successful in preventing the removal?
Yes.
Or were they not successful in preventing removal?
You're breaking up a little bit on the
efforts that we just went over, would you agree that they were not successful in preventing the child from being removed from her parents?
Yes.
And because those active efforts were not successful, do you believe that today removal remains necessary to prevent physical and emotional harm to the child?
Yes, we do.
And to the best of your ability, what would be the physical or emotional harm the tribe is concerned about if the child were not, or I'm sorry, if the child were to be placed or returned to either parent?
Yes.
Do you, Mr. Ballot, the question was, what physical or emotional harm would the child be at risk for if the child were with either parent?
Well, with the father, possible sexual abuse, and with the mother, neglect,
Thank you.
psychological harm.
And does the tribe have any appropriate foster homes that are willing to take placement of the child right now?
No, we don't.
Do you believe that the current foster home serves as an appropriate placement?
Yes.
Can you offer any opinion or any recommendations for activities, services, or other things that would help ensure that the current placement is being culturally sensitive to the child's Native American heritage?
What are activities or services we have?
No, just what, if you could provide any advice to the placement to assist in ensuring that the child's Native American heritage is being supported, I guess.
We'd be willing to place the child where she is right now.
Okay. So there's nothing special that they necessarily need to do or should do for her?
I'd relate that to Calyer.
Okay, I can definitely ask her that at a later time. And do you, as the qualified expert witness, have any other or any additional thoughts or recommendations regarding placement of this child moving forward?
Just that we know that it's not good for her to be with her mother or the father, especially the father.
And does the tribe support exploring placement with relatives?
Yes.
And does the tribe have a preference as to whether the relatives, I'm sorry, I strike that question. I have no further questions for this witness, Your Honor.
Mr. Brooks?
No questions, Your Honor.
Ms. Heist?
No questions, thank you.
Okay, thank you so much, Mr. Ballot, for your testimony and your time. We appreciate that. Any reason that we should keep him, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
I have no problem with that.
Ms. Heist?
No reason to keep him today, thank you.
All right, well, Mr. Ballot, you're welcome to stay and listen if you wish, but if you need to get on to other things, you're also welcome to hang up. Once again, we appreciate your time.
I think I will listen in if I may.
Absolutely. You're more than welcome to stay in the meeting. All right, Ms. Thomas, where would you like to go from here?
Your Honor, I I don't have any further questions for our witness at this time. Our argument regarding removal remains the same, in addition to adding the fact that placement as hoped with Mr. Thomas is wholly inappropriate, and we are not able to do that. The agency continues to make efforts to explore relatives. Those requests have been put in with ICPC, or are in the process of it. One relative is in California and the other in Alaska, so the distance makes it quite hard. There are continuing concerns about Ms. Collier, and she remains unavailable to the child. So we would just request that this court continue or authorize the amended petition and continue placement of the child pending trial.
All right. Well, Mr. Kuzik, what is the status of the investigation into relative placement?
The placements have been sent, and we're waiting to hear back from both Alaska and California. Alaska, the father's mother, her name is Lily Thomas, and we have to hear back from each state as of right now.
Do you know when those were submitted?
September 19th, they were emailed.
And what is the typical turnaround, if you know?
I'm not sure exactly. I think it can be as many as, or as much as 3 months or so.
Is there anything that could be done to expedite that, or any resources that you have not looked at in order to expedite that?
I'm not sure if there's anything. I'll have to ask in my department.
So that was for Lily Thomas, the paternal grandmother in Alaska, and who's the other relative?
Teresa Bloom. She lives in Redding, California.
And how is this person related to the child?
She's Mr. Thomas's sister, biological sister.
Okay. I know we have Ms. Kiera Melton with us as well. Ms. Melton, can you hear me okay?
Yes, Your Honor.
Very good. Deputy Ames, would you swear her in, please?
Can you hear me, ma'am?
Yeah, I didn't understand her.
Can you raise your right hand, please? Let me know when it's raised.
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, good afternoon, Ms. Melton. This is Judge Sala. I'm wondering if there's anything on your end that could be used to help support this child. Would you be able to help with the investigation into the relative placement, or have any other suggestions for placement at this time?
Since I got caught up with this case late, but one of the family members did call my office number not too long ago. I forgot which day was that, but their names were Mark and Lily Thomas. Oh, Laverne. Yeah, Mark and Lily Thomas. They're related to Sean.
Yes. Do you or any officials from the tribe ever do investigations for, placements?
No, usually the caseworkers that we work with does that part.
Okay. Have you been able to be in touch with the family where the child is currently staying?
No, I didn't get any updates of where she is or anything.
Okay. Do we need to, after the hearing, perhaps provide that information to you? Would you like to be able to reach out to them?
If needed, sure.
Oh, okay. Okay. Questions based on my questions, counselors?
Ma'am, the child is located in Lenawee County, Michigan. Do you have some vague concept of where I'm talking about?
That question was for you, Ms. Melton.
Oh, sorry, I didn't understand his question. It's
The child is located in Lenawee County, Michigan, south of Detroit, about an hour. Do you have an idea how far away that is from where the relatives are?
No.
Do you know where the relatives live?
They didn't give me where they live. They just called on like to know when's like the next hearing and gave me their point of view of what's happening.
Where do they live?
They didn't give me a name or where they live. They just gave me their numbers and emails.
Where is your office?
Where's
Ma'am.
my what?
Where do you work? What's the location?
Buckland, Alaska.
Is that up in the Arctic Circle?
Yep.
Thank you. I have nothing further.
Ms. Thomas, any questions?
No, Your Honor.
Ms. Heist?
No questions, thank you.
Okay, thank you for your comments, Ms. Melton. Okay, anybody you would like us to hear from today, Mr. Brooks?
No, Your Honor.
Ms. Heist?
No, Your Honor.
All right, Ms. Thomas, any comments?
Your Honor, I'll rely on the statements that I made earlier during this hearing. Thank you.
Good. Mr. Brooks?
Well, I will certainly point out with this 6-page complaint that I will be requiring the court to adhere to the rules of evidence when the day comes we try this case.
Thank you. Ms. Heist?
I wanted to repeat that I have seen this child face to face and that she is settling well into non-relative foster care. She does have access to her mother through video visits. At this point, the child is well adjusted. All of her needs are being met in the current placement where she has foster siblings who are really close in age. I think there are 4 other children that when I saw. So she's doing well while we get all this process in place for her. Thank you.
All right, well, the court finds all interested parties were given notice for purposes of today's hearing, including as best as can be demonstrated for today as it relates to Mr. Sean Thomas. We will look for further proofs that he's been notified and served, as well as information from wherever he's incarcerated so that we can make sure we make those arrangements in the future, Mr. Kuzik or Ms. Fullerton, whoever wants to tackle that. For purposes of today's hearing, we did hear from the president of the native village of Buckland, Percy Valent Sr., who supported that as a result of the father's potential risk of sexual harm and the mother's potential risk for further neglect, that the removal of the child remains necessary pending the court's next orders. I do also find that the record supports that custody with either parent at this time presents a substantial risk of harm to this child's life, physical health, or mental well-being. For the same reasons, as well as some of the details that were offered by Mr. Kuzik today that further are uncontested and do support that that risk of harm remains. We have explored on the record whether or not there are any other services or other arrangement except removal reasonably necessary or reasonably available to adequately safeguard the child. That was explored at length prior to removal by way of some of those efforts that were given to provide financial support for a hotel and motel, and those were not successful. Relative searches are pending through ICPC, and there are no other arrangements at this point in time that would be reasonably available to adequately safeguard this child from risk associated with allowing her to remain with her parents. For those same reasons, continuing the child's residence in the home is contrary to her welfare with her mother. We did hear about reasonable efforts to prevent or eliminate the need for removal of this child, specifically as it relates to mother last time, briefly today, and then as well as the reasonable efforts as it relates to father. That does have to do with the investigation and the discovery of the current pending criminal charges. Prior to that, he was being explored for placement, and the department was reaching out very actively to try to secure his cooperation. I was aware of that as well. He was asked to come to Michigan at one point and pick up the child, and he did not do so. Conditions of child custody away from the parent are adequate to safeguard this child's health and welfare. She is doing well where she is at in her foster care placement, and that is meeting her needs at this time. The court does find that there is probable cause to authorize the second petition, but it's the first amended petition, and to authorize the child's continued placement in foster care. We will also find that our agency and the department proper has done their obligation to offer active efforts and to ensure that the ICWA and MIFA statutes are being followed. And we have confirmed that with our representatives of the tribe as well today. The court's decision is supported by the QEW as well as the guardian ad litem, Ms. Heist, who I also find in satisfaction of her obligations. Thank you for your diligence.
Thank you, Your Honor.
We will adjourn. Well, we'll conclude today's hearing as it relates to mom and set that for bench trial. And we'll schedule the father's preliminary hearing and look to make some additional arrangements for him moving forward. I have potentially as a backup to a trial that's set for its second day of jury on Friday, November 3rd, potentially sometime. Ms. Thomas, what are your thoughts on that day?
I am agreeable to that.
Ms. Heist, your thoughts?
I'm available, yes.
Mr. Brooks?
I'm not a part of that case, so I don't know anything about it,
All right. Well,
but I'm agreeable if it's open.
I like, thank you. November 3rd, if you could pencil it in, just in case Mr. McFarland continues to be unavailable for some reason, we'd appreciate it. But we'll set the bench trial as it relates to mother's case on Friday, November 3rd, commencing at 9 a.m. Let's go ahead and set the preliminary hearing for father to also take place that day. What state is he incarcerated in?
Washington.
All right, so let's set his for 1:30 p.m. to give them enough time to be open during business hours to attend the hearing if we're able to secure his presence. And please provide any information you can as soon as you can so that we can help from our end, try to make sure he's able to be here and have an attorney for him. All right. Child will remain where she's placed. That is the safest and least restrictive under the circumstances. Unless there's any questions, I believe that's all for today.
I have one issue I want to raise off the record, but with my client, and that is her address, phone number. She's a long way from here.
Very well. Any other questions for the record?
No.
Judge.
The court was presented with a request to immediately take jurisdiction and control of placement of the child subject to this jurisdiction, subject to this petition. The court reviewed the petition and did sign an emergency removal order based on the circumstances alleged in the petition. We are here at this moment for a preliminary hearing on that order. May I have the names of our participants, please?
Lee Heist, lawyer, guardian ad litem.
Cameron
Ms.
Kuzik,
Sasha
CPS
Thomas.
representative.
One moment. Ms. Sasha Thomas, counsel for the department. Go ahead, Cameron.
Cameron Kuzik, CPS investigator for the department.
Okay, would you spell your name for us, please?
Yes, Kameron.
One second. And your last name?
Kuzich.
Thank you so much.
Michael McFarland representing mother, Carla Calyer, who is present by audio only. Ms. Calyer, please introduce yourself to the court.
Hello, Your Honor. I am Carla Collier. I am Uta's mother.
Okay, all right. Ms. Collier, I have a number of preliminary things that I need to run through with you pursuant to MCR 3.965. Will you please raise your right hand and let me know when it's raised?
It's raised, Your Honor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You've had a chance to talk with your attorney today, is that right?
For a few moments, Your Honor.
Very good. Do you have a copy of the petition and the removal order?
Yes, Your Honor.
I understand that you or your child may be a member of a Native American tribe or band. Could you tell me about that, please?
My daughter is a quarter Alaskan Native, Your Honor.
All right. Is there a specific tribe associated with that heritage?
I think it's Inuit. It's Alaskan Native.
All right. Are you or your child currently enrolled in a tribe?
No, Your Honor. We're working to get her enrolled.
All right. Do you know who you were working with?
I was working with the family person that I consider to be family, but me and my daughter have known since she was born.
Was there an official member of the tribe or an eligibility office or anybody else affiliated with the tribe that you were working with?
I don't have those details at the moment because I'm currently using my only working phone to be here, and that would be in my notes, and I'm not able to. I can get that to my attorney at a later date, Your Honor.
All right, very good. Yes, because if there is eligibility for your child that could offer additional services and trigger potentially another caseworker to be involved to support you and your family throughout this process. So please make sure you get any and all information to the caseworker as soon as possible.
Yes, Your Honor.
Are you aware? Okay, so I should tell you this. You've got, I have a petition, right? And there is, it would appear to be a case, at least establishing paternity. Is that the only other case that affects your child, or are there any other cases open that you're aware of?
That is the only case that I'm aware of, Your Honor.
Right. So you have the right to an attorney at this hearing as well as any subsequent hearings, and that's why Mr. McFarland has been requested to join us today. If you ever choose to retain your own attorney, that's perfectly fine. That attorney will just have to reach out to Mr. McFarland and secure a substitution and all of the relevant documents.
Yes, Your Honor.
You have the right at this hearing to seek placement of your child and the right to admit or deny the allegations and make a statement of explanation to the contents of the petition. You also have the right to have the petition read aloud on the record, unless you waive it. You have that right. Would you like me to read the petition onto the record?
Yes, Your Honor.
I'm just gonna say, just for the record, I have it and I don't need it read unless you need that read.
No, I don't need it read. I just wasn't sure if anyone else didn't have it or whatnot.
Not a problem. I'll agree with her, Your Honor. We don't need it read.
Okay, thank you. Ms. Heist, do you have a copy?
I do, thank you.
Very good. I know Mr. McFarland does, and Ms. Thomas was generated from her office, so we know she's got a copy. All right, as it relates to the removal and the request, I would like to hear the presentation that you might have on that, Ms. Thomas.
Your Honor, if I might, just preliminarily, I have a jury demand request. If I can submit that to the court, to the bailiff.
So sir.
So we'll take it, yeah, you wish to effectively formally deny the allegations at
That
this
is
time?
accurate, Your Honor.
Put that up there. Okay, Ms. Thomas.
Thank you. And if Mr. Kuzik could be sworn in, please.
Contact names, Mr. Kuzik.
Raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Oh, yeah.
Yes, come on up to our witness stand. Actually, I think it'll be easier for everybody to see that. All right. Ms.
Mr. Kuzik, how are you familiar with this matter?
I'm involved in a CPS investigation with the family.
And as the investigator, how did you learn about the allegations that you put into the petition that you drafted?
Staff from Catherine Cobb Shelter, domestic violence shelter, informed me of allegations, and I called a separate intake to report the allegations.
And did you have an opportunity to interview or work with Ms. Collier?
Yes, I did.
And did you have an opportunity to speak with anyone else that may be related to the child?
I did not have a chance to speak with anybody else related to the child.
Okay. And during the investigation process, did anyone from the department make contact with the named non-respondent father or anyone in the paternal family?
Yes, someone from the department did have contact with the non-respondent father and talked to him about custody.
And to the best of your knowledge, has a custody order been presented to you or to the department?
No, it has not. We have the document that establishes paternity. However, we did not receive a custody order at this time.
In your petition, there are several allegations that allege the child is essentially at a substantial risk of harm and an imminent risk of harm. Can you please state what the risk of harm is to the child and how you became aware of the facts leading to the risk?
The child, I believe, is at risk for physical neglect, as Carla has lived in, from what I learned when I looked at past CPS history in a single state, that Carla has lived in several states in the past 4 years. I believe that was 10 or 15 states. So we had concern that Carla being in so many places with her daughter could be a definite risk for neglect. There was a case that was substantiated in Washington State, where Carla previously lost custody of Utica for 6 months due to a neglect allegation, where she did not have her child's medication on hand. And currently when Carla was staying at the shelter with Utica, there were various complaints from staff that Carla was not cooperative at the shelter, and that her handling Utah's behaviors was disruptive to other residents and made other residents uncomfortable based on the way that she was not cooperating with the staff at the shelter and how to handle Utah's behaviors. And lastly, the possibilities of where Carla will go next, we're unsure that can guarantee the child's safety or have a reasonable risk, could cause a reasonable risk depending on where she goes next, as she is no longer in the shelter and she was asked to leave with her child Utica and does not have a place to stay currently.
The behaviors that the staff at the shelter had indicated to the department, do you believe that those constituted either physically or emotionally, psychologically harmful behaviors towards Uta?
I believe they did cause emotionally harmful behaviors to Uta, yes.
What can you just briefly elaborate what some of those behaviors were?
Yelling at Uta in front of other residents of the shelter, telling Uta that the staff were bad and they were going to take her away. These sorts of things that would cause staff members to not trust Carla and vice versa. I know there had been several attempts with staff to accommodate Carla and help her handle her daughter. However, Carla, which I was told repeatedly by more than one or two shelter staff, various shelter staff, that Carla was not cooperative and was not trying to implement these suggestions that the shelter staff had told her.
And was there any indication that the mother was physically inappropriate with the child?
There wasn't substantial indication that the mother was physically inappropriate with the child.
I did not hear if that was a was or was not.
There was not.
Thank you.
Okay. And in your opinion, you stated that those are the reasons you believe that the child is at a substantial risk of harm?
Yes, in my opinion. And there is, like I was discussing before, uncertainty. I know Carla speaks about a family friend that she trusts in Canada. And I have been in contact with this person. I believe that Carla is getting advice and messages as to how to care for Uta that are misleading from this person. In fact, this person, which we have record on Facebook Messenger, told Carla that she could come pick Uta up at the Detroit Metro Airport and take her back with her so that she can enroll Carla in services where she was living in Canada, and she claimed that she was a social worker there.
And were you provided any proof of documentation that this individual, in fact, had secured actual travel documents or identifying documents or service enrollment documents or anything of that sort?
We have no proof that she obtained identity documents for Uta. I know this person had claimed that she was obtaining those. And as far as travel documents, there was a screenshot of flight information. However, it was just the pricing on the flight. So I don't know if those were actually booked flights that she was going to come down here and fly to the Metro Airport and bring her back to Canada.
What active efforts did the department make to prevent the request for removal?
I made several visits to the Catherine Cox shelter while Carla was staying there. I was able to make several referrals for Carla, two of them involving Orchard's Families First Children's Services, Families First, which works with Carla and Uta while they're at the shelter. Also, community mental health was referred for Carla so that Carla and Uta could engage in family therapy. And even after those were set up, I still got complaints from staff saying that there was no improvement in Carla's overall demeanor and behavior and how she handled her child, Uta. There was also a safety plan involved where I told Carla while she was at the shelter that she agreed to in writing on the Facebook Messenger chat that she would talk to staff that she trusted so that there wouldn't be any
personality clashes with staff when handling Utica and also handling Utica in a private place, so that this wouldn't disturb other residents of the shelter. So that safety plan was established, and those are the main active efforts that we had. We also had made contact and sent via email to see if there was any eligibility for Native American, Native Indian. We emailed Native Village of Buckland. They stated, and I actually called them on the phone, so that they would have access to this meeting today.
Thank you for that. And as relates to the non-respondent father, were efforts made to locate him or anyone in his family that may be able and appropriate to have custody of the child?
Yes, we were able to contact Sean Thomas. I did not speak to him personally. However, somebody else from my department spoke with him. He said he would be able to care for Uta, the child. He would be able to come down here and pick her up. We also spoke with Mr. Thomas's mother. I believe her name was Lily Thomas, who stated that she was a part of the Buckland tribe in Alaska. However, she was not enrolled, and that's why we were looking for further, see if there was any possibility that she could be enrolled with the tribe there.
And is there a reason that Mr. Thomas, that you're aware of, has not come to get Uta yet?
I just think it hasn't been enough time. He stated he would be able to come pick her up. We would just have to go through all of our options before that, and then he would be able to come pick her up via plane. So.
And does he have a custody order? And I believe your testimony before was that you hadn't been presented a custody order. Do you know if he is in possession of one?
He stated he does have a custody order, and we're currently trying to receive that or obtain it. However, we've not obtained it yet. What I have right now is the document that establishes paternity for Sean Thomas.
And has there been a courtesy home visit to his residence to just confirm that it would be appropriate for the child?
Not yet. However, I emailed Washington State, the local county CPS supervisor there, and she said that they would be able to make a home check on Mr. Thomas's home next Wednesday was the soonest that they'd be able to do it.
And as it relates to additional active efforts, how has Ms. Collier paid for the motel that she's currently staying in?
This was paid for by the department after Ms. Collier was asked to exit the Catherine Cobb shelter. The department agreed that they would temporarily fund for Carla and her daughter Uta to stay at the hotel, local hotel here in Adrian.
And currently the placement recommendation is licensed foster care until there's further order of the court or proof of a custody order. Is that correct?
Yes, that's correct.
And are you currently asking the court to continue authorization of this petition and continued removal of the child?
Yes, I'm asking the court for to authorize this petition and continue the plan for removal of the child.
Thank you. And I know that this might be outside your purview, but what would the recommendation for parenting time be?
Supervised visitation at the department's discretion.
And to the best of your knowledge, is Families First still providing any services?
I'm unsure if Families First is still providing the services. From what I understand, after
We spoke with Carla that Families First would cease services after that, after the child was placed somewhere else, but I'm unsure at this moment if they're currently engaging in services still.
Thank you. I have no further questions, Your Honor.
Cross-examination?
I'll be brief. When was my client asked to leave the shelter?
She was asked to leave the shelter. We announced it to her Tuesday morning on the 29th.
And you're still paying for her and her daughter to live in a hotel, correct?
We are not. We stopped paying on as of today. Currently, as far as I understand, Families First is funding it for the next few days.
Okay, so she's not homeless, correct?
Not as of yet, no.
Right, so this petition isn't because of what happened in Washington, because you've known that for a while, correct? About the prior case.
Correct, we've known it for
That's not the emergency, correct?
Correct.
And the emergency isn't because she's in a hotel, correct?
Correct.
You're claiming the emergency is, as you are alleging, that she wants an individual to take possession of this child who's a foreign resident who lives in Canada. Is that correct? I'm paraphrasing.
Yes, that's one of the emergencies.
Well, that is the principal emergency, correct?
And concerned that where she may go and where she has been, yes.
Okay, as my client indicated that she's going to go, that when you say she, who's she?
Carla.
And she told you she's going to go someplace?
No, she does not know where she's going to go, as far as I understand.
Okay. And as far as father, are you aware that he's not had contact with his child in a lengthy period of time? Are you aware of that?
Yes, I'm aware it's been over a year since he's had contact.
Are you aware that he does have the contact information for mother and has made no attempt to reach out to her? Are you aware of that?
That I'm not aware of. Carla has not told me that he's had her contact information.
Have you asked Carla if he's ever had any assaultive behavior against her? Have you asked her that?
She's told me he's had assaultive behavior.
And have you asked her about if he has any, let's say, alcohol problems and gets violent with alcohol? Has she told you about that?
No, she has not told me about that.
Are you going to be questioning her about her thoughts about her father picking up the child with any possible risk that might present?
We're going to be questioning the father and doing background checks on him.
You could deny this. Are you going to talk to my client about and then explore what she might reveal to you?
If that's what the investigation warrants, yes, I would be talking to Carla.
We would like you to do that, just so you know. Okay.
Okay.
And as far as my client, let me rephrase. My client indicates that she wanted a local church member to be explored for possible placement of this child so she could delegate her parental rights, and she was informed that that person would not be evaluated. Are you familiar with that?
I am familiar with a local church member that she had contact with, yes.
What would have been wrong with her delegating her parental rights to that church member?
We were informed by the Catherine Cobb shelter that somebody from the church, I don't know if it was that member, wanted to file a complaint on Carla to the shelter or to CPS.
No further questions, Your Honor.
Did you observe any concerning behavior when you removed the child?
Yes, when we removed the child today, Carla stated that CPS was going to kidnap. She was telling her child, Utica, that CPS was going to kidnap her. She said this several times. I believe this made Utica escalate in her behavior a little more when this happened.
You have had services, including Catherine Cobb, you've had Orchards Family Services, CMH. All those services were not able to successfully avoid asking for jurisdiction?
Yes, that's correct.
And how long about have you been involved with this family?
I've been involved with this family since early June on 3 separate investigations.
So when I look at your pleadings, it looks like there is a family friend who is outside of the United States. Is that correct?
Yes, it's correct.
And judging by the conversations, there's some kind of a, this person is inducing the child to come. There's talk of kittens and new clothes and new shoes. Is that true?
Yes.
That person is indicating that she's doing a home study and has health insurance, citizenship, daycare, all those kinds of things organized in Canada. Is that true?
Yes, that's right.
So then, does the story match up between the person in Canada and the mother about when they met or how they know each other?
The mother, I believe, stated that she met Carla when she was 16. I may be wrong on that. And that they met in the state of Washington, and they became friends because she liked her.
So they call each other, Carla calls this person mom, but there is no biological connection?
No, not that I know of, no biological connection.
Will you repeat for me the part about mother was planning to turn the child over at Metro Airport, and then there was going to be a schedule problem and the child was supposed to be left by herself or something? Would you tell me that part again?
So the friend in Canada, and she texted us on Messenger stating she could come and pick up the child from the airport through a guardianship program at the airport and bring the child back with her to Canada so she could provide this child all of these various social services. She stated this, like I said, on Facebook Messenger, and stated this to Carla.
So initially mom was planning to travel with the child up to this friend in Canada, and then something changed where now mom was just going to turn the child over at the airport?
Yes, something changed.
Thank you. I have nothing further.
Okay, could you repeat for me what's happening with the child's father and what the circumstances are there? Are you expecting him to come and retrieve the child?
Yes, at a to be determined time, we're expecting him, as he stated, he would be able to come via plane flight to retrieve the child. We're still working on obtaining the custody information for this person. However, he is the legal father, and we have those documents for that. And he was interviewed personally, I believe, on more than one occasion by somebody else from the department.
All right, redirect Ms. Thomas.
Regarding the concerns that Ms. Collier has of Mr. Thomas, has she provided any proof, like any police reports, or have you been able to look into that, like any police reports, protective orders, anything?
She has not provided any proof. She told me that he was abusive and that she was afraid of him. However, she has not provided any proof of that.
And generally speaking, has she been able to give you any good information about dates, times, places she's been, any details of her life that are significant?
No, I believe she's given me various dates that have changed. As far as the history of everything that's happened, she'll tell me something that happened on a certain time, and then I will notice when she brings it up a second time on a different occasion, she'll state that it happened on a separate date.
And is there anything else you think the court needs to know in order to make an informed decision regarding the relief requested?
No, there's nothing else I can think of.
Okay, thank you. I have no further questions, Your Honor.
Any requests?
Just very briefly, you think this individual in Canada is trying to dupe my client, trick her into getting the child? Is that the gist of it?
I'm not sure. There's always that possibility that she could be trying to do that. We have no proof of who she is.
You've been in contact with this person, correct?
I have been in contact with her, yes.
Did you request proof of who she is?
She usually is not able, she hasn't provided me any proof.
My question is, did you request that of her?
No, I did not request it.
Okay. Did you request any documentation or proof about this guardianship program that she mentioned?
We didn't request information about that from her personally.
Okay. So a lot of this sounds like speculation because you've not asked her specifically about these things, correct?
It could be speculation, yes.
So did you tell my client about any of your speculative concerns after you were concerned?
I felt that this client was so dead set on doing this that whatever we said, she would not be able to, would not agree with it.
So is that a no, you did not tell her about your concerns?
No, I did not.
Although you're not able to substantiate your concerns because you didn't explore that, correct?
That's correct.
Nothing further.
Any other requests, Ms. Heiss?
No, thank you.
All right, thank you for your testimony. May I return to your seat. Other witnesses, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
I'd like a brief breakup with my client, Your Honor.
Okay, we'll take a recess and allow that. Ooh, we have someone under tribal administrator. We're waiting. So before we do that, let me just let that person. So for the record, we have Sean Thomas logged in. Didn't give him a chance to introduce himself, but he has been present by Zoom. Okay, Mr. McFarland, we'll need the courtroom, so I don't know if you want to make some arrangements to chat with your client using our.
Well, if there's going to be any conversations, I'd like to be present and then
Yes,
converse with my client.
I'm just letting you know.
Thank you, Your Honor.
Our tribal administrators having trouble connecting to audio. All right, we'll go ahead and take our recess and.
Matter of Utica Collier, file number 23168.
Right, we are back on the record to conclude the hearing on the preliminary removal request in this case. We had adjourned at the request of the representative for the tribe to allow her some additional time to review the pleadings in the case. We were happy to do, and we have reconvened. May I have the names of our participants, please, beginning with our guardian ad litem? Oh, you know what? She might be in a breakout room still. So let's begin with, as we wait for her to return from the breakout room, let's start with Mr. Amadeo.
Good afternoon, Your Honor. William Amadeo, P76194. On behalf of the department, I consent and appreciate the opportunity to be here via Zoom. My worker is present. Cameron, please state your name for Judge Sala.
Yes, Cameron Kuzik, representative for the department.
Would you spell your name, please?
Yes, Kameron. Last name's Kuzich.
Thank you so much.
Michael McFarland representing Mother, and I was not placed in a breakout room with my client, Your Honor.
All right, yep, we'll get to that in a moment. Ms. Carla Calyer, can you hear us? Could you please give us your name for the record? Oh, well, I didn't hear you. Could you try it one more time?
My name is, yes, ma'am. Yes, Your Honor, I'm here, Carla Collier.
Thank you, thank you. All right, Ms. Heiss.
Lee Heist, lawyer guardian ad litem.
And we also have Mr. Sean Thomas with us. Welcome.
Yes, this is Sean Thomas.
Thank you. All right, well, do we have a representative from the tribe?
Morning, this is Frederica Gavin, native village of Buckland.
Great. Would you mind spelling that, please?
Frederica, last name Gavin, Gavin.
All right, and which entity did you say you're from?
Native village of Buckland.
Okay, native. I heard native and then Buckland, but in the middle it was a little garbled. I'm sorry.
Native village of Buckland.
Thank you. That makes perfect sense. Okay. I think that's it. So let's start with you, Ms. Gavin. When we left off, you were testifying as it relates to your opinion on the request filed by the department for removal and from a qualified Native American tribe expert opinion. Do you recall that?
I do.
All right, Deputy Ames, would you swear her in, please?
Can you please raise your right hand? Let me know when it's raised.
It's
Do you
raised.
swear or affirm? Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Ms. Gavin, are you prepared to continue your testimony today?
Your Honor, I contacted Jill Heilman and spoke with her about being excused as a cultural expert because I am related to the grandmother on this case.
And Your Honor, maybe more appropriate if we have a brief sidebar. I got some information today from my workers, and there was some confusion as the tribe had a power outage yesterday. I could make a record, or if we want a brief sidebar, I could do that.
Ms. Gavin, and perhaps you know the answer to this, Mr. Amadeo, but will you have anyone else that will want to weigh in then for the tribe?
I have spoken with the president of our tribe, and he is willing to step in as a cultural expert. I did give him the call-in number, but he's having trouble calling in right now.
All right. Well, I guess what we'll do then is we will take an opportunity for a brief sidebar so the attorneys can perhaps catch each other up on any other formalities, and we'll come back together in a few minutes, and that will give him some time to try that. And we can also verify the contact information with you as well. Back on the record in the matter of Utica Collier. May I have appearances, please?
Lee Heist, lawyer, guardian, litem.
Ms. Sasha Thomas, counsel for the department.
Cameron Kuzik, representative for DHHS.
Michael McFarland, representing mother. Could you please introduce yourself?
I am Carla Collier. I'm Uta's mother.
Thank you.
Michael Brooks, I represent the father, Sean Thomas.
Yes, primarily we're here today on your client, Mr. Brooks, and arrangements were made previously to have him produced to us from where he is incarcerated. We don't have him, but I'm hoping we just don't have him quite yet. So we have a contact we're reaching out to see if we can't bring him into the hearing for this entry. I'll let you know if I see him join the Zoom.
Thank you.
All right, and our representative from the tribe, if we could have your introduction, please.
Kiara Melton.
Okay, Kiara, Kiarah, is that right?
Yes.
And Melton is Melton?
Yes.
All right, and I understand you are the ICPA coordinator, is that right?
Yeah, for the native village of Buckland.
Yes, for the native village of Buckland. Thank you for coming. I'd like to start with you today. I need to let you know that we missed you this morning, understandably, because I think it was probably 3 o'clock in the morning or something crazy when we took up the matter of the adjudication of the child's mother this morning. She requested to enter a no contest plea, which, as the court informed her, would allow the court to review all of the facts in the petition as true. The reason for the no contest plea was potentially because there were some allegations that she had abused the child, and child abuse is against the law. So for purposes of the no contest plea, that can be justified by potential criminal charges being issued. So all of the other attorneys, with the exception of Mr. Brooks, were present, and she did request to enter that no contest plea. The court reviewed the petition and took notice of the hearing on September 1st, wherein Cameron Kuzik had testified, which I believe you were here for as well, or one of the representatives from the tribe was here and concurred at that time in support of the request for removal, that there had been a risk of harm to the child. So I'm telling you all of this, reiterating this, because I would like to know if you think, if you would agree that the no contest plea by the mother is appropriate. I have not actually entered it yet or received it because I wanted to make sure that you agreed, or if you disagreed, that I gave you the opportunity to tell me why you may disagree. So just to reframe the question again, does the tribe have a position on whether or not Ms. Carla Collier could enter a plea, essentially admitting to everything in the petition?
Wait, I'm unsure of what is she like? Is it
Your Honor,
against the child?
could she speak up a little? I'm really having a hard time hearing her.
Yes, Ms. Melton, it is rather difficult to hear you. Could you try again, please, a little louder?
Yeah, sorry, I'm having a hard time hearing you too from this side.
That was much better.
Much better. We heard that very well. What, I'm sorry, what was your comment or question that you said?
Sorry, what was the question? Yeah, I'm having a hard time hearing you from this side too.
Okay. The mother, Carla Calyer, would like to enter a no contest plea, which would submit her to the jurisdiction of the court. In other words, she wishes to essentially admit that the things in the initial petition were true. Does the tribe have a position on that?
No.
All right. Do you have any questions about that plea?
No.
All right. Well, the court then will accept the plea, and order of adjudication will be issued, indicating that Ms. Carla Collier is now subject to the jurisdiction and the supervision of the court for purposes of allowing her an opportunity to cure the issues that were identified in the initial petition, including her search for a home, employment, her need for parenting education to avoid not only the potential physical abuse of her child, but also to assist her in making sure that the child's needs are being met. And our next court date, as it relates to the mother, will be the disposition, and that has been set for November 17th at 1:15 p.m. At that time, there will be a case services plan entered as part of the court's proceedings that will outline those areas that need to be rehabilitated for Ms. Carla Collier. And it will serve as the guiding outline of whether or not she's made any progress on those areas for purposes of her reunification efforts. There was also raised at that time an issue around parenting time. And we waited for you, Ms. Kira Melton, so that you could hear and weigh in on the parenting time issue for Ms. Calyer. So unless you have any questions, then we'll go into the issue of visitation. Does that sound okay, Ms. Melton?
Yeah, no question.
Okay. Ms. Heist, we'll go to you on the issue of visitation.
Thank you, Your Honor. I have visited with the child face-to-face, and I'm familiar with her placement. I'm calling your attention to this because the placement is somewhat at risk. This child is placed in a home.
Can you move that microphone a little closer to make sure?
This child is placed in a home where she has approximately 4 foster siblings who are close in age, so that this home affords the child the benefit of mentoring by the other children, repetition of expectations and boundaries because she would be hearing for the other 4 children, the developmentally appropriate toys, games, structure of their day, and also normal holidays, normal experiences in a 2-parent household where all her needs are being met. This is a very advantageous placement. She's becoming part of a group and part of a she's very honored among this group. She's the only foster child in the group. So mother is doing a Zoom visit, and when those Zoom visits happen, I would ask you to consider that they need to be suspended until mom can come and visit in person. I believe that the detriment is outweighs any benefit to the child in these visits. So what's happening is this: during the virtual visits, there are some alarming and distressing behavioral changes in the child. So not only does this affect this child, but the other children in the household are affected because Uta will have self-harming behavior. So she will hit her head on hard surfaces, and it's distressing and dangerous to her. This behavior doesn't happen except surrounding these visits. So also after the visit, this child is physically aggressive towards the other children in the home and the foster parents. Unusual episodes that we don't see during the rest of her days. She is also, the night following each visit, the placement has told us that this child is experiencing nightmares that cause her to wake up multiple times, screaming and very distressed. So what I'd ask you to consider is that continuing to expose this child to the trigger of her trauma until services can be provided, I'm positing that the visits with her mother, that her mother is triggering her trauma. During the visits, the child is very reluctant to engage on the video, and many times she'll leave the room or she'll refuse to come in front of the camera. She's clearly showing indications of distress. I would ask you to consider that the mother isn't showing empathy for the child's needs and is disregarding what she's seeing, so that it takes the foster parent, myself, the social worker, Francesca Madrid is also working with the family to ask you to consider that mother's minimal commitment to services and the fact that she moved away so that we can't do in-person visits, that it isn't just a minimal effort to correct the bond between mother and child, if not improve or maintain a bond. It's just not working. I believe mother intends to come here for services. I would ask you to suspend these virtual visits. It has never been our wish to have mother out of the area. Mother did that after, sometime after our preliminary examination. So I would ask you to suspend those visits pending mother's comes back to the state, engages in services, and we can have a family team meeting about a schedule for visits. Thank you.
Has there been a difference noted as to her behavior if the visits are simply by phone without video?
I have not asked that. I also asked to watch, so the video visits are supervised. So I am allowed to zoom in and see them too. I was wondering if it would benefit the mother just to watch the child. The child wouldn't have to engage the mother. Does the child even have to know mom's watching? But mom can observe that her child is doing well. It doesn't really benefit the bond between the child and mom, although, so I was exploring that, but I had not explored whether just phone alone would work. I'm happy to explore that.
Does the child have a therapist?
At this time, I don't believe so.
This child is 8, is that right?
4.
4, I'm sorry.
The foster placement is a highly skilled person who is qualified as a counselor. She's not acting in that role. So when she tells me these things, I know it comes from a lot of experience. And she also has professional degrees, but whether there's a neutral counselor for the child, I just am not aware at this time.
Do we know whether or not the child is going to be submitted for a trauma assessment?
I believe that is on the, we didn't get a court report for today because we're so early in the case, but I believe that is the plan.
On the issue, Ms. Thomas.
Your Honor, I was not informed on anything until Ms. Heist brought it up today, so I'm not prepared to make any argument either way. Based on a brief review of one email, I believe that the agency in the department's position supports Ms. Heist's position as well. And we do not object to her request at this time.
Mr. McFarland.
Well, Your Honor, I did discuss this with my client. She is in agreement with this child receiving therapy. I know her intentions are to come to Michigan as soon as possible, but the goal is reunification. And I don't know how that can be accomplished if you're asking to suspend her parenting time. I think there could be ways to accommodate that, if not video, by telephonically. I'd like to get my client's opinion on how long it'd take her to arrive in Michigan. But I don't see suspension of a parenting time is necessary. If it maybe a therapeutic parenting time with a therapist until my client returns, I think that might be an alternative.
Ms. Kira Melton, do you wish to be heard on this issue?
No, yeah, I agree with him, not to suspend her visits, because she's the mother, and yeah, I agree with the therapeutic time.
So you would agree that therapeutic visitation may be appropriate, but not with the outright suspension of her parenting time? Am I understanding you correctly?
No comment, sorry.
Okay, all right. Very well. Ms. Francesca Madrid is with us. Deputy Ames, could you swear her in? She's with us by Zoom.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And Ms. Madrid, do you have anything to add to the conversation considering your role? As far as whether or not just simply telephone visits have been tried, or if the child has a therapist, or if there's a trauma assessment in the offing and initial screening, any of those things, would you be able to speak to?
Yes, Your Honor. She does have a trauma assessment scheduled with Samaritas on November 28th. And she was actually engaged in therapy with CMH prior to coming into care. So that has continued. She does have a therapist, Mia Hamden, through CMH. She participates in play therapy, and she will be starting EMDR outpatient therapy as well, through CMH as well. We have not tried phone visits, but I do believe once we get the trauma assessment going and get a better idea on Uta's needs, we should get a better understanding of what mom and Uta need as far as therapeutic visits. But I do think it would be in Uta's best interest to have mom face-to-face.
Have you talked with Mia Hamden, the child's counselor, about the issue?
I have, and she was not able to give me any kind of opinion.
Was she aware of the behavioral changes of the child around parenting?
That is why we kind of opted for a more intensive outpatient therapy that she's going to be starting. Her and her supervisor will be working with the foster parents and Uta to get that going. But she wasn't able to give me, she said she couldn't comment on specific parenting time.
If we were to ask an expert to weigh in, I know Ms. Brene Moore has done that in the past for purposes of determining a recommendation on parenting time. Is there someone associated with Ms. Hamden that could accomplish that, or would that be a separate referral in your opinion?
I can definitely try again. Maybe her supervisor will give me more of a statement regarding parenting time. But if not, we would have to make another referral because I don't think that they want to mix the two things.
Anyone else have questions for Ms. Madrid?
No, thank you.
No, thank you.
Ms. Madrid, I do have one question. Have you personally observed the behaviors so that you can say with certainty they are triggered by parenting time, or is that solely based on information you've received from the foster parents?
I have observed several parenting times, and Uta does struggle during the parenting times. She repeatedly yells she wants to end the call. She gives looks to the workers when we try to fix the phone for her to be able to see mom. She will purposely not answer. And then just even immediately after the visits, I struggle to redirect her and get her to settle down again. And then the reported behaviors from the foster parents in the home.
Okay, thank you. I have no further questions, Your Honor.
I have a follow-up based on that. I'm not sure, but are you familiar that in many domestic cases, such as divorce, after a visitation or before, during, children act differently and then they calm down? Are you aware of that?
In some cases, yes.
How might this be any different than that?
Well, it's still difficult to specifically say what Uta is struggling with because we haven't had that trauma assessment, but she is showing significant behaviors during the visit and after.
So a mother is not yelling at her, correct?
No, for example, Uta will say, I want the visit to stop. I don't want to talk right now. Can we end? And mom will not address it at all. She would just say like, I love you so much, and not even address Uta's feelings in the visit while it's happening.
You would understand that it would be natural for a mother to want to keep her visitation and not to just cut it off, right?
Yes, that is understandable. And I have expressed several times that we are more than willing whenever she is available to do face-to-face visits.
And redirection is also another technique, rather than taking on an issue head on, that might distract the child. Redirecting her is also another technique, correct?
Correct. The foster parents and myself do a good job of redirecting her. It's just those self-harming behaviors, outbursts where she's trying to hit her head on the wall, things like that that can be harmful.
Right, but with what mom is doing, that could also be redirecting, correct?
Through the phone?
Yes.
Yes, she can attempt to. She has not done that, but she can attempt to, yes.
Well, by saying I love you so much and things of that nature, she's redirecting her from the thoughts of ending the conversation, correct?
Yes, I would say I would think that it would be more appropriate to address her feelings, such as maybe acknowledging the fact that Uta wants to end the call and maybe exploring those feelings, why she wants to end the call and why she doesn't want to talk to mom.
How long are these discussions?
They go from 45 minutes to about an hour, depending on scheduling.
So do you think maybe it might be more beneficial for this child to have more frequent but shorter discussions, so she doesn't have to just drag on what might seem in a child's eyes for a long time?
Well, right now we had to move the visits from the foster parents to the office. So we have Uta transported to the office and we do the Zoom visits there and supervised. And then she's transported back to the foster parent. And we do that twice a week for an hour.
Well, can you tell me, since everything's on Zoom, like we are here in court right now, why can't this all be done remotely? Why does she have to be taken to the office? Why can't it be just like court where everybody could be remote, like yourself today?
Yeah, so the reason for that is because we were creating boundaries between mom and the foster parents. And they have also requested that visits be taking place in the office.
Okay. So it still doesn't state that we couldn't do visits more frequently, correct?
Correct.
And have you discussed what you've told the court that mother should do? Have you actually discussed that with mother?
I have not had the opportunity to have another family team meeting regarding parenting time, no.
So we're kind of critiquing her, but she's not aware of your perception of what she's doing wrong. Might that be accurate?
I wouldn't say critiquing. I would say we have been observing how she engages with her child, and she's specifically been ignoring what Uta has said during visits and her feelings. And we're still in the preliminary as far as like figuring out their bond and what exactly their needs are.
Does it take a family team meeting to call my client and just have this discussion with her?
I can have a family team meeting with her and let her know. I don't.
Hang on, my question was, does it take a family team meeting to have this discussion with her? In other words, couldn't you just reach out and call her rather than having a family team meeting with everybody involved and just get to the matter sooner rather than later?
Yes, my first priority was preserving Uta's placement and ensuring that she was safe and not self-harming. So that is the route that I took.
Understood. Nothing further.
Ms. Madrid, are you telling me that this 4-year-old child was trying to do an hour of video parenting time twice a week?
Yes, we have it set up for 45 minutes to an hour, where she comes in and she plays in the visit room, and we have mom observe her and try to engage with her while we're struggling the whole time.
Well, you're what?
Trying to re-engage her the whole time.
One of the things that Ms. Heist had remarked on, and I'm sure you heard her testimony, or not testimony, her comments, was the idea of simply allowing mom to be present on Zoom, not necessarily attempting to force the child to engage. Do you think that that could be effective?
We can definitely try that, yes.
Has it been an effort to simply allow her to speak to her child on the phone?
Not only phone calls, no. We sometimes the video will cut off and they'll speak only without video, but we try most of the time to let her see her child.
Well, I'm not talking necessarily about the mom seeing the child, but if the mother is potentially a trigger for the child, in your observation, when the video cuts out, does that seem to make a difference with regard to the child's participation or effect?
It does seem to make a difference as far as not knowing. As soon as she knows that the visit is taking place and mom is about to enter the call is kind of when she starts having a difficult time to redirect. So if she doesn't know that mom is on the call, that could work.
Questions based on my questions?
No, thank you.
No, Your Honor. No. Okay, thank you, Ms. Madrid.
Thank you.
Mr. McFarland, is there anyone you wanted us to hear from?
I'd like to call my client, Your Honor.
Deputies, if you could swear in Ms. Carla Collier, please.
Yes, Your Honor.
Ms. Collier, can you raise your right hand, please? Let me know when it's raised.
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, one moment, Mr. McFarland. It looks like we have your client, Mr. Brooks, by phone. Is there a chance you could retreat to the back room and see if we can't set you up to talk with him? While we're
Sure.
finishing this?
You need a laptop, Your Honor, or?
If you want to loan him yours, that would be great. Otherwise, I was going to count on my assistant to try to set it up.
I prefer to read my notes in court if I can.
Okay,
So,
Deputy Ames, if you could ask Mr. Powell to loan out his laptop, or you can use mine too.
Okay.
But whoever does it will need to log into Zoom and set up a Zoom breakout.
Very good.
You can just put him at mine if you want.
Okay.
Okay, all right. Go ahead.
thank you. Ms. Collier, how would you like me to address you today?
You can just address me as Carla. That's my name.
Okay, Carla. You've heard the concerns that the worker has, right?
Yes.
Okay. What are your thoughts about maybe having less lengthy visitations where your daughter's focus might be more directed? What do you think about that?
I'm not against that.
And I don't want to state
concerned. The issues that
Okay, speak a little closer to the microphone and slower if you would.
I am a little concerned about some of the behaviors I'm hearing about.
Is it correct that you are agreeable to your daughter going through therapy to see what's going on with her?
Yes, I am. That's something that I've been asking for the entire time I was at Catherine Cobb's, and I fully support it. The sooner the better for her well-being.
I know earlier today in court you indicated you're going to take the first flight possible to Michigan. I know we've had a little time, what is your position on when you can get to Michigan?
Well, right now I'm trying to find the means to get a
You are
flight out
breaking
there.
up severely.
As soon as I'm able to get the money in a Greyhound or by flight, I'm looking to get out there as soon as I possibly can.
You are breaking up severely.
I apologize for the connection issues I'm having. I am trying to get out there as soon as I possibly humanly can.
Thank you. Do you wish to continue to have visits by video or telephonically before you get here to Michigan?
I would like to have visits any way I can. The time that me and my daughter share together is very special and important to, I think, both of us.
Are there any restrictions on your time as far as when you cannot visit with your daughter?
Not that I can think of. I can get in contact with the courts and let them know when I will be able to travel out there. And during my travel time, it might be a little tricky, but I am more than happy to accommodate that as best as I possibly can. My daughter comes first.
I would ask that you reach out to your worker and not the courts to let the worker know your status. And maybe when we're off the record, we can get some type of contact information for the worker, okay?
Thank you so much. I appreciate it.
Nothing further, Your Honor.
Any questions?
No, Your Honor. Just briefly. Ms. Collier, you are currently in what state?
I am in Washington State.
Okay, you were here when this case started, weren't you?
Yes, I was, but I was having difficulty finding a safe place to stay out there.
So since then, you've lived in what, Kentucky?
I went to a friend out there when they realized my situation with my abuser. They did not feel comfortable having me there anymore. I have had a stable place to stay since I've been back in Washington, and
Is she still there?
Yes, but we didn't hear any of that, Ms. Calyer.
I'm terribly sorry. I said I have had a safe and stable place since I've been back in Washington State, and I have a possible job opportunity as well.
You gotta slow down. You gotta slow down, and it's breaking up. And the faster you go, the harder it is for me to understand you.
Okay. I have a possible job opportunity out here, and I have had a stable place to stay since I have been out in Washington State.
Yeah, we can't hear you anymore, Ms. Collier.
I have no further questions, but I would like to get her address when we're off the record to make sure she gets a copy of our order.
All right. I think we did address an email address for that purpose so that she can make sure she got it. The orders. Okay, wait. Yeah. Okay, you should have an invitation to join a breakout room. Mr. Powell, Mr. Brooks.
Nothing's happening.
Is there an invitation for a breakout room on the screen that you'll need to accept?
Says join.
Yes. Click yes, please.
Oh, I gotta do it with a clicker?
Yes. Success. Okay. Anyone else need to see her from Mr. McFarland?
I have no further witnesses, Your Honor.
Ms. Nice, is there anyone else you wanted us to hear from on this?
Your Honor, I believe the placement is available if, however, her comments would mirror mine. I would ask you to consider that my information comes from her as well as my own observation. So I won't call her, but I want the others to know that she is available.
Anything else? No, Your Honor. Mr. McFarland?
No, Your Honor.
Very good then. Any additional comments?
Your Honor, based on our petition, the discovery process and all of that, this child has been removed from Ms. Collier's care before. And I believe that the foster parent has the appropriate and adequate insight as to the child's behaviors, and that's supported by Ms. Heist, who has a great deal of education understanding when it comes to child development and trauma. And the agency really supports the suspension of parenting time based on the fact that it is causing the child severe emotional distress and physical harm as a result of that emotional distress. Until such time that mom can avail herself to be present in person where there could be a therapeutic parenting time to take place, we request that the parenting time be suspended. Thank you.
Any other comments, Mr. McFarland?
I do, Your Honor. As the tribe weighed in, they didn't say that mother needs to be here in person. They supported mom being having visitation in a therapeutic setting, which also could be by Zoom. Quite frankly, I've dealt with 3-, 4-, 5-year-olds. I don't know a 4-year-old who can be focused for 45 minutes on one subject. And we're asking her by Zoom to bear the burden of having to be there on a television closed circuit monitor 45 minutes. I can see why the child does not wish to do that. My client supports more frequent or shorter visits, which I think would be more productive for everybody involved and not stress the child, Your Honor. To ask that my client's visitation be suspended completely until she's able to make it to Michigan. We've heard her testimony. She's seeking funds to get a bus or a plane ticket to get here. Basically does not promote reunification if we're just going to suspend the parenting time without having any type of evaluation. Without my client being told that these visits or redirected, what's the purpose of having a supervisor if you don't politely redirect her or give her a call afterwards saying, you know, during the next visit, why don't we try this if she does that, rather than waiting for a family team meeting or bringing it up in court. If this is an issue, seems like it should, if it were truly an issue, this would have been brought up with my client contemporaneous with any incidents, Your Honor. So I support a family team meeting. I support child being evaluated as soon as possible, but like the tribe, we do not support my client parenting rights being suspended at this point in time. I think the tribe also said they took no position on anything other than therapeutic. I don't want to speak for the tribe, as they'll have their own opportunity. I don't know, now I have not heard what type of cultural sensitivities have been exercised during these parenting times. I have not heard that this child is being presented with any native culture, any native language, any native education. I've not heard any of that. I haven't heard any active efforts for this child to integrate into Native American cultural life. So I do have some concerns there, Your Honor. Thank you.
Ms. Kira Melton, would you like to say anything else today about the issues that have been discussed?
No comment. Yeah, we rarely ever got to know about this case until recently, so we're still trying to catch up on our side.
Okay, thank you. All right, well, Ms. Madrid, I think it could be useful to you as well as to Ms. Melton and the family if you could reach out directly to Ms. Kira Melton and try to stay in contact with her so that if there are any additional benefits that could be had for the child or the family, that's immediately available. And of course, also to keep Ms. Kira Melton appraised of what's happening with the family.
Yes,
Okay.
Your Honor. I have asked her, but if there's anything that she can provide to me to here today that I can do, that would be great.
Well, I think that it would be appropriate for you to reach out to her regularly to keep her updated on what's happening with your case and to continue to engage on those questions. Okay?
Yes, Your Honor.
Very good.
Can I
will
ask
also.
this is Kiara.
Sure.
So I will be on leave until I don't know when, but I mentioned this the last hearing that there is family on the father's side that is interested in being a placement, but I never heard from them since the hearing on September 25th.
That's a great question. Who can speak to that? Mr. Kuzik?
If she could repeat the question.
So the question is, what is happening with the request for placement with the relatives on the father's side?
The placement requests have been sent to the Interstate Compact for Alaska. That would be the father's mother in California. That would be the father's sister. And as far as I understand, that's still in the process of those states connecting with each relative so that that can be completed.
Do you know the dates that those ICPC requests were put in by any chance?
I don't remember the exact dates. I think it was in the middle of September.
Do you have a contact that you could check into the status of those requests and get back to us on it by the time we return for the disposition on the 17th?
Yes, I could look in for a contact to check in on the status.
Thank you, I appreciate it. Okay, anything else, Ms. Melton?
Yeah, about my leave, I leave for maternity leave soon. So if she needs to update somebody here in the tribe, it would be Frederica Gavin.
Okay. Frederica.
She's the tribe admin.
Is the tribe,
Frederica
I'm sorry,
Gavin.
Gavin, Gavin?
Yes.
All right. Did you catch that, Ms. Madrid?
Yes, I did, Your Honor.
All right. So, Ms. Melton, then we have been sending emails to the tribe to give you copies of the orders and let you know when the court dates are going to be. Is that working okay?
Yeah, to my email or to Ms. Frederica.
Okay, I just have ICWA at nunachiak.org. Is that correct, or would you like me to use a different one?
Yes. You can use both. She's usually on hers. The other one is tribeadmin@nunachiak.org.
Could you spell it for me?
TRIBEADMIN@nunachiak.org.
Thank you very much. We will mark that down and make sure that we use both addresses moving forward. Okay, well, and good luck to you on your leave.
Thank you.
Okay, on the issue of parenting time, I would like to have an expert. So if there is any possibility that Ms. Hamden would be willing to weigh in, or her supervisor, or who she's willing to work with to refer out on this, that would be great. There's a trauma assessment, but it's not scheduled until the 28th. Obviously, the bond between the mother and the child is evaluated during a trauma assessment, and that would be an important piece to shed some light on what's been happening with not only the child, but the parenting time. And Ms. Madrid, if you could ask our assessors to give us a recommendation on parenting time as well, as part of that, I would be appreciative. But we need some additional expert advice on this, please.
Yes, Your Honor. And if they are not able, I will get that in writing as well.
Thank you. All right. So in the meantime, I'd like you to try simply setting up the computer, but not necessarily requiring the child to participate, just making it an option to see if that will help. But I'm not going to ask you to do that more than once a week. So we'll reduce the parenting time to the minimum once a week until we get back on record for our disposition on the 17th. I don't think it needs to be an hour long. I would just say that you would have the discretion to terminate a visit if the child begins showing signs of stress around the contact. And we'll review the issue again on the 17th at 1:15 p.m. for non-essential disposition. And hopefully by then we'll have at least a preliminary comment from a therapy perspective on what could be done moving forward to avoid the harm that's being demonstrated as a result of the visits at this point. Any questions?
No, Your Honor.
All right. All right. Anything else?
Nothing further. No.
We're going
Thank
to
you.
take a brief recess. That will be all as it relates to Ms. Carla Collier today. But I'm going to check in here with Mr. Brooks and Mr. Thomas to see where they're at, and we'll come back on record if we need to with regard to Mr. Sean Thomas. So we're going to take a brief break. Thank you.
May I be excused, Your Honor?
Any objections?
No.
Thank you.
3168.
We are here this morning scheduled for a trial as it relates to the request for petition, or the petition, the request in the petition for jurisdiction over Ms. Carla Collier. I've had the pleasure of a couple of sidebars with the attorneys, and Mr. McFarland has talked with his client a couple of times, and as I understand it, Ms. Collier wishes to request to enter a no contest plea, which would mean that we would not have the trial. And I'll go through all of her rights on that. If she decides that's what she wants to do, that would also mean we wouldn't need our witnesses anymore, so we'd be able to let you go. But let's get to it. Appearances, please.
Lee Heist, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department.
Cameron Kuzik, representative for DHHS.
What, can you spell your name for us?
Yes. Cameron, K-A-M-E-R-O-N, K-U-Z-I-C-H.
Thank you.
Michael McFarland, representing the mother, Carla Calyer. Carla Calyer, please introduce yourself to the court.
I am Carla. I'm Uta's mother.
Thank you. All right, comments about the sidebar, Ms. Thomas.
Thank you, Honor. I will allow Mr. McFarland to fill in about his client's portion. I did raise a concern about the tribal presence today. Mr. Percy Ballot, who is the president of the tribe, was present at the last hearing. And I believe that Kiara Melton, who is also the enrollment specialist and caseworker for the tribe, was also present, and they had actual notice of today's hearing. So I just wanted to bring that to the court's attention and the other attorney's attention. It is my understanding that there will not be a trial this morning, and there will be a plea instead. At which point we would request to put on the factual basis, or ask the court to consider the factual basis that was put on during the preliminary hearing. But with that, I think that Mr. McFarland would be able to inform the record more.
Yes, I'm not sure if I heard correctly that you wish to place the factual basis on at 1:30 or right now. My understanding was right now is when we wish to put the factual basis on. We also had a discussion as to whether the tribe actually received a copy of the order. That was part of the discussion. My client is going to waive reading the entire petition. She's gone over that. I confirmed that with her, Your Honor. If we then pick this back up at 1:30 to see if the tribe's going to join us, since it's 6:30 their time right now. My client can appear if she wishes. I didn't have the discussion if she's excused, if she also wishes to. I believe that would be the case. And then we ask that the court schedule this for a dispositional hearing where all parties are ordered into a case service plan. So there'd be obviously a family team meeting to go over those components, Your Honor.
Ms. Heist?
Yes, and at the sidebar, I indicated I would not oppose a no contest plea so that the family can get into services towards reunification. And I think that concludes my part of the sidebar.
I'm not sure if I added the no contest reason is for possible assault against a minor child, which is alleged in the petition.
Thank you. Just of note, the preliminary hearing order, which contains today's date and time, was served by email to the tribe, which is the customary way that that is being completed at this time. And I do also recall that Ms. Kara Melton, as well as Percy Ballot, was present at the last hearing to hear the dates and times for today's hearings. But I would be inclined to accept the plea under advisement and then allow for them to weigh in on that this afternoon. I'm hoping we'll have them join us this afternoon for the proceedings that were scheduled as it relates to Mr. Thomas. Any objection to proceeding in that way?
No, Your Honor.
No.
All right, Deputy Ames, would you please swear in Ms. Carla Collier?
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Ms. Calyer, is it true that you wish to enter a no contest plea and that if we do that, you wouldn't have a trial?
Yes.
All right. The no contest plea would be because of the potential criminal liability associated with some of the allegations in the petition, specifically that you could potentially face criminal charges for child abuse. But the no contest plea, practically speaking, means that I would effectively consider the facts in the petition entirely. You wouldn't have to make an admission formally, but I would consider all the facts and circumstances in the petition. Do you understand that?
Yes.
Okay. I'm going to go over some of your rights that you'll be waiving, and I have to make sure that your plea is knowingly, understandably, and voluntarily made. So I'll go over those with you now. If I accept your no contest plea, you are giving up the right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand that we're giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition by way of no contest plea?
Yes.
In regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no longer any need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. With regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea?
Yes.
Do you have any questions about any of the information I've given you so far?
No.
Is anyone making you admit by way of no contest plea to the allegations in the petition?
No.
Has anyone threatened you in any way to get you to enter a no contest plea?
No.
All right. Has anyone promised you anything in order to get you to enter a no contest plea?
No.
Would you say that your decision to enter your no contest plea is one you've made of your own free will?
Yes.
Are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing right now?
No.
Thank you. Ms. Heist, do you find it to be in the best interest of the child for the court to accept the no contest plea?
Yes, Your Honor, I do.
Thank you. As to the factual basis, Ms. Thomas?
Your Honor, I would ask that if counsel is agreeable, that this court consider Mr. Kuzik's testimony at the preliminary hearing, which was held on September 1st as the factual basis.
I would, Your Honor, in addition to the petition itself.
I have no objection to that.
Very well. I will consider that then as a factual basis of the plea. And I do find, as I found at that point, that it does, there is a risk of harm associated with allowing the child to remain in the care of the mother as a result of the conditions that were in place at that time. We had, of course, the allegation of the child abuse, which forms the basis for the no contest plea. We had unstable housing and employment, parenting skills were very, well, the lack of parenting skills is a significant issue. And I would also note that at this point in time, Ms. Calyer, of course, is not available to her child, having relocated to, I believe, the state of Washington. Is that right, Mr. McFarland?
She is currently in the state of Washington on Zoom.
Very well, thank you.
But she is just hours away by a plane flight.
Fair, all right. Well, I do find that the statutory grounds for adjudication have been met for all of the reasons articulated at the former hearing, as well as summarized today, as well as the facts and circumstances in the petition, and that one or more of the allegations is true. As a result of that no contest plea. Jurisdiction is appropriate under MCL 712A.2B 2. And the court's order will reflect that. I also find the plea to be knowingly, understandably, and voluntarily made with a full understanding of the consequences. Mr. McFarland, are you satisfied with the advice of rights and the factual basis of the plea?
I am. I've also gone over the same with my client.
Ms. Thomas?
I am, Your Honor.
Ms. Heist?
Yes.
All right, Ms. Collier, I'm taking your plea under advisement, given that the tribe was unable to join us this morning, and I will be explaining that to them this afternoon. You're welcome to rejoin us for that piece. Assuming that they have no objection to the entry of the no contest plea, your next court hearing will be disposition. So that will occur. Let me give you the date. Let's set that for Tuesday, November 14th.
Your Honor, my only concern about that date is the turnaround time to have a family team meeting and get a case service plan if it's.
All right, well, if we go out past that, we have to go past Thanksgiving, which is outside of our 28 days.
All right, to have discussed that with my client, she would rather have the disposition sooner rather than later, so she can begin the reunification progress in earnest.
So we could go to Friday, the 17th? Would that help?
Sure, but also if we're unable to have the family team meeting in the next 7 days, will you waive notice defects for a court report and case service plan? If we can't get it out by the 10th.
You mean, will I waive having a later date? I haven't discussed it with my
No,
client.
because if we could, let's say that we give you a case service plan and a court report on the 14th, which is like 3 days before the hearing, is that going to be a problem?
I have not discussed that with my client, Your Honor, but I don't see that being a problem. May I ask my client, Your Honor?
Sure.
Carla, what they're saying, I know you and I spoke and you want to proceed with this as soon as possible. And if this means getting that potential case service plan and court report, not 7 days before our next hearing, but maybe just a couple days before the hearing, are you willing to do that just so we can get movement as soon as possible on your case?
Yes, I am, and I will be on the next flight that I can get out.
Thank you.
Thank you.
So that'd be a yes.
And I'll reserve, I mean, if you need more time, once you get a hold of the court report and case services plan, and you want a different date, obviously we'll
I understand.
be flexible with you on that. All right, Ms. Heist, any opinion on that issue that was just raised?
No, Your Honor.
All right, well, let's set the disposition for 1:15 on Friday, the 17th. So that would be November 17th at 1:15 p.m. Ms. Collier, will you be rejoining us this afternoon?
I just need to know what time, my time, that would be, Your Honor. I know you guys are 3 hours ahead. It's 7:46 right now. What time about would I need to relog in?
Well, it's at 1:30 here. So
around 12:30 my time.
That's approximately 3 hours from right now.
All right. Yes, Your Honor. I will be there.
All right. We'll see you then. Do you have any other questions for today?
No, Your Honor, thank you.
Very good. I'm sure Mr. Kuzik or someone from the agency will be reaching out to you to set up a time to talk about case services. So please make sure you're ready for that and be ready to cooperate with that process so that you can have input on your services. Okay?
Thank you, Your Honor.
You're welcome. Thank you to all of our witnesses who came so faithfully today and waited so patiently. But that's all. You're released from your service. You're back. Mr. Brooks is back. Your client is going to be joining us from the breakout room any moment. Have you had a chance to talk with him?
I did. He tells me that he is currently lodged in a jail in Washington State. He's charged with a felony of some sort, and that his next scheduled court date is in late November. But that, I don't know if that's a trial or just another preliminary hearing or at what stage of the process that criminal case is in. He and I both agree that he, at the present time, is in absolutely no position to add anything helpful to the custody of this child other than he would like his sister, who lives in California, her name is Teresa Bloom, and his parents, Mark and Lily Thomas, who live in Anchorage, Alaska, looked into as potential placements for this child. I don't have an address for either one of these parties, but I do have a phone number for Mr. and Mrs. Thomas in Anchorage, Alaska. Would you like to have it?
I think you can check with Mr. Kuzik after our hearing. I think he may already have that.
I should have that information already. Yes.
Mr. Kuzik, can you confirm that those two households are the ones that the ICPC has been sent to investigate?
Yes, those are the same two households, Your Honor.
All right, Mr. Brooks, they are currently being investigated and we're looking forward to an update on that from Mr. Kuzik on November 17th.
For the purpose of this court's information, I am told by Mr. Thomas that he is 50% Anupiac, and I'm spelling that ANUPIAC, which is probably wrong, but that's how I pronounce it and spell it. He is 50% Anupiac, which means his child is probably 25%. He is not currently a formal member of the tribe, but he is working on the application to qualify. And I suppose we should consider the same thing for this child. I don't know what benefits are available through that affiliation, but whatever they are, she certainly should be afforded the opportunity to enjoy them. Other than looking into his family's availability and willingness to take charge of this child, there's really precious little else that we can add to this process, although he does agree that the child does need intervention from this court to take care of her.
Thank you, Mr. Brooks. We have Ms. Kiera Melton, who is the ICWA coordinator for the village of Buckland, which is the tribe that is involved on behalf of the child, with us already. And we have addressed with the caseworker currently that we'll need to keep the tribe up to date on what's happening with the child and the family. And she has been able to ask questions today as well as she needed to along the way.
I don't have any questions for her, Your Honor. For the purposes of this hearing, I would like you to know that my client agrees. Well, he does disagree with the part of the report that says he is declining to participate. The more accurate answer would be he is unable to participate because he's incarcerated. And until such time as the criminal charges he's charged with have resolved themselves in some manner, he will not be in any position to participate in any meaningful way other than for his own information.
Mr. Brooks, can you confirm whether or not Mr. Thomas has received a copy of the petition that was filed against him?
Mr. Thomas, did you hear that question?
Yes, I did hear the question.
Did you get a copy of the petition that names you as the child's parent and a neglectful parent at that?
Not that I'm aware of. I was incarcerated September 14th of 2023.
All right. Well, I think for purposes of today, Mr. Brooks, we'll have to adjourn to make sure that your client receives a copy of the petition before we could move forward. Would you agree?
I do.
Ms. Thomas, would you like to speak to that at all?
But I don't have the proof of service pulled up in front of me, but I know that ensuring he dad received.
Hang on one moment, Mr. Thomas.
Okay.
From my understanding, the petition was sent to the facility where Mr. Thomas is incarcerated. And I, again, don't have that proof of service pulled up in front of me, but I believe I've received it in email because I've asked several times to ensure that he was served and that we could secure his presence today.
I see that a copy of the petition was mailed to him at an address that does not indicate the jail. That was from our clerks.
Your Honor, may I wander the client? I'm not sure he understands what we're asking him because he wasn't incarcerated early. And I think that if we were to ask him if he's read these factual allegations, I think he's familiar with them.
There was an amended petition that was filed against him on September 25th. And according to his testimony, he was incarcerated as of September 13th. So the one that he needs to see wasn't filed until after he was incarcerated, as I understand it. Is that correct, Mr. Thomas?
I believe so.
Okay, all right. Debbie Ames, would you swear in Mr. Sean Thomas?
Mr. Thomas, can you raise your right hand, please, sir, and let me know when it's raised?
It's Ray.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, I do.
Okay, Mr. Thomas, just to verify, you've been incarcerated since September 13th, is that right?
That's correct.
Okay, and no one has delivered you anything, any packets of paperwork since you were incarcerated?
Not for this case, no.
All right. Which facility are you currently located in?
Clallam County Correctional Facility.
How do you spell the county?
CLALLAM.
All right. Do you have the information for that facility, Mr. Kuzik?
Yes, Your Honor.
All right. All right, Mr. Thomas. Well, there has been a petition filed against you, and we need to get you a copy of it. And frankly, it's not fair to move forward on your case until you've received that. So what I will be doing is adjourning, or in other words, giving you a new court date. And hopefully in the meantime, you'll have received that paperwork and would be able to look through it. You're entitled to an attorney for all intents and purposes on these proceedings. So Mr. Brooks will continue to be provided for you to that effect. You're entitled to the petition. You're entitled to direct placement, and the 2 households that you have requested for placement are currently under investigation. We will have an update on that hopefully on the 17th, which is our next scheduled court date. I am also happy to schedule yours to commence directly after the hearing as it relates to Ms. Collier on that same date. So we'll ask you to rejoin us on November 17th at 1:15 p.m. our time,
Okay.
which is, I think, I'm sorry, I don't know what the time difference is, but you may.
3 hours.
Okay. Do you have any questions?
No, Your Honor, and thank you.
It's 1:15 Eastern Time.
All right, anything else for the record today? ladies
No,
and
Your
gentlemen?
Honor.
I assume this, a new PIAC is the same as the native village of Buckland because of the email address, I think is where I saw it. So I think we're all informed about the right things. Thank you. That's all I had.
Okay, thank you, everyone. Thank you, Ms. Melton. Again, good luck, and we'll see everyone on November 17th at 1:15 p.m. The child will remain in her placement where she is currently located. That is safest and least restrictive, as Mr. Thomas is incarcerated. Ms. Collier is unavailable to us in another state and still faces all of the challenges that were identified in the adjudication today. 8. All right, we are on record today for a review on mom's case and the initial disposition for the father of the child. We've had a bench conference, and I'll let the attorneys address any content of that if they wish to on the record after appearances.
Lead Heist, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Ms. Madrid.
Francesca Madrid, foster care worker from Fostering Solutions.
Michael McFarland, representing mother. Just introduce yourself.
Mother Carla Collier.
Michael Brooks, I represent the legal father, Sean Smith. Mr. Smith, are you available or present?
Deputy Ames, would you double check the hallway for us, please? We don't have
I
anybody
believe he's
logged in.
incarcerated in Washington State.
Actually, I think it's in Alaska, isn't it?
No.
But the name is Sean Thomas, not Smith.
Always empty, Your Honor.
Thank you. Okay.
Well, if I've got the last name wrong, it's Sean Thomas, and I'm sorry.
Okay, appreciate you correcting that, and we will try to, I guess, I don't know. What do you think, Ms.
The name on
Thomas?
the, Your Honor, in my own defense, the official report that I'm reading identifies him as Sean Thomas. You'll find that on the first page of the report.
Very good.
Oh, and I have him as Smith. So yes, it's Sean Thomas. I'll correct it.
Very well.
Request was made to the prison.
Okay, so we did put in a request for your client to be present, Mr. Brooks. My assistant is trying to contact them to see if we can remind them that we have requested his presence. In the meantime, why don't we do the review on mother's case? They have the right to have separate proceedings, and they are in fact quite dissimilar in their situations. So let's go ahead and take the review for mom, and then as soon as we get your client, we'll head into his initial disposition proceedings.
Point of order, Your Honor. Do you want us to put on the record the sidebar?
Yes.
Okay.
Do you want to start?
I can, Your Honor. I had mentioned some of my clients' desires about raising the child in a particular belief. She is not, I had a conversation with her, she does not wish to enroll the child in a Native American tribe, but she does identify as pagan, and she wants to know what, I'll be asking the question, what is being done to raise a child in that atmosphere that she espouses to. I think there is also a discussion regarding an allegation against my client threatening a worker. That will come out in testimony today. I think that's the extent.
Any comments about the sidebar, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
Can I inquire? Pagan is a pretty broad brush. What particular
Viking pagan. Norse pagan.
Norse pagan.
Correct.
Thank you. Thank you.
Any comments about the sidebar, Ms. Heist?
No, thank you. I think it's been covered.
All right, very good. May I have your report when you're ready?
Thank you. I visited with the child.
I'm so sorry to interrupt. I was wondering where the tribe was, and I double checked the proof of service, and it does not appear that the tribe was given notice of at least the report. I'm not sure if they have notice of the last hearing because I did attend, and so I just wanted to double check with the court's records that the court was able to give them a copy of the order so they knew about today.
Yes, on February 12th, 2023, there is a proof of service that indicates that the order of adjudication and the order of disposition was served on the ikwa@nunashiak.org email address that the Native Village of Buckland has requested us to provide that notification to you. Of course, the order of adjudication and the order of disposition would have had today's date and time in it. Does that help?
Yes, thank you, Your Honor.
Okay, so they have had notice. Anything
I
else
have
before?
I have a question, Your Honor, an initial question. In an effort not to say something that is politically incorrect, could I have the formal name of the indigenous Alaskan tribe so that I can reference it specifically by name?
It is the Native Village of Buckland.
The Native Village of Buckland.
With a B.
Buckland?
Yes.
Thank you.
And I do think that they should be served with the court reports as well. I think you have a good point there, Ms. Thomas. That would be on your workers to make sure that that gets done in the future. And in fact, you should probably send it along as soon as possible from this one.
Sure.
Anything else?
No.
Ms. Heist?
Thank you, Your Honor. I visited with the child face to face. She has her needs met in the current placement. It's a highly specialized placement that meets her needs. She is enrolled in a private school that is especially accommodating to some of her needs. I observed a visit between the child and mother, and the good news is mother has the parenting ability, which is one component of all of this. Some people get it confused with every component, whether she can manage a child. And it's really lovely to see a parent and child really enjoying their time together. As the case progresses, I would expect that first of all, the Samaritas evaluation will get it in full, and then mom will start to get some more education around this child's needs so that she can respond in a way that the child to help support the child's special needs. And I mean that with a small special needs. It's not, I don't mean it as a term of art that she has any disability. I don't mean that, but I think that she has certain responses will be productive with her and certain responses won't. So for example, to be more concrete, the child kind of runs the show in a visit. And I think that there will come a time when mother with the right tools will be able to structure the visit so that she can have the authority in the environment. And until then, the child is safe in her visits. I recommend we continue the visits, and as mom gets more stable with housing and her employment continues, I know she'll be able to do better about bringing the meals and that kind of stuff. I don't think there's a lot of pressure on mom, but I think we're really early in the case, and it'll be good to support these folks towards reunification. Thank you.
Ms. Thomas?
Thank you. If Ms. Madrid can please be sworn in.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Okay, proceed at will.
Thank you. Ms. Madrid, how are you involved in this matter?
I have been the foster care worker since removal.
And did you provide a court report for today's hearing? And what documents were also included in the court report?
The case service plan for Ms. Collier, the case service plan for Mr. Thomas, and the preliminary report from Samaritas.
Thank you. And what currently do you believe that there is a substantial risk of harm to the child if the child were to be returned to Ms. Collier's care and custody today?
Yes, there would be an exposure to parental instability, improper supervision, safe and stable housing, and additional abuse and neglect.
In addition to that risk of harm, are there any other barriers to reunification?
At this time, we are working towards emotional stability. She does have a CMH caseworker, and she is taking medications that are prescribed through CMH. She will be starting individual therapy through CMH very soon. She does participate in EMDR therapy every other week through CMH as well. She just recently started a trauma-informed parenting class that is about 8 weeks. And she just recently secured employment and housing.
What active efforts has the agency made for this family to help address the barriers to reunification?
Yes, so I have created an extensive assessment of the circumstances for Utica and her family, and we are focusing on safe reunification as the goal. I have identified appropriate services in helping Ms. Collier. We have transported Ms. Collier to the trauma assessment. We have transported her to the psychological assessment. The foster family has purchased several books for Utica specifically from her tribe. And we are working towards the ICPC requests.
So I do have an update from my assistant. He contacted the prison or the jail where we last knew Sean Thomas to be located, and they reported to him that he was released yesterday. So that's all the information we have at this point about your client, Mr. Brooks.
Thank you.
Go
Thank you,
ahead, Ms.
Judge.
Thomas.
Ms. Madrid, how would you describe Ms. Collier's level of compliance with and benefit from her case service plan?
During this reporting period, she is compliant with her case service plan. She has engaged in services and completed intakes to begin working towards benefiting from those services. And she secured employment at the end of January. And she also secured housing. I just have not been able to verify if that's safe housing.
In your report, you indicate that she was living at Share the Wealth, I believe. Is that, so that's changed?
Yes, she moved in with a friend, and that is the only adult in the home currently.
Oh, I'm sorry, waiting for background checks or something, correct?
Yes, I have not done that.
I'm sorry, did you say she's the only adult in the home?
No, her and another individual.
Okay.
There's 2 adults in the home.
Thank you.
There's only 1 other adult in the home.
Thank you.
Thank you. Do you believe that the child's placement in foster care is necessary to continue to safeguard the child?
Yes.
And do you believe that the current placement is meeting the needs of the child?
Yes, yeah.
And you indicated that placement has made an effort to purchase books regarding the child's tribe. Are there any other activities or materials that are in the home that help the child remain connected to her cultural roots?
Yes, it is my understanding as well that during Ms. Collier's parenting times, she is working on teaching Utica her native language.
Wonderful. In your report and in your testimony, you've made a comment of parental instability. Can you explain what you mean by that?
Yes, she has had appropriate interactions with Utica. There's just that concern of her ability to manage all of Utica's needs as well as her needs with her instability.
I'm not sure that was an answer to my question. I'm more curious what you mean by her instability. Are you talking about her emotional instability, her transient lack of housing instability? I'm just curious what you mean by that.
So by instability, I mean her emotional instability as well as being transient, leaving very early in the case or fleeing the state, as well as the instability of being able to manage appointments and things like that. We did provide her with a planner, so that is helping, but we're just monitoring her ability to be able to manage all of those things.
Thank you. Overall, how would you describe her ability to work with you?
Very well.
Okay. And do you have any concerns about, actually strike that question. Thank you. As relates to the preliminary letter coming from Samaritas, have you been able to start on any of those referrals recommendations? I believe the trauma-informed parenting was one of them. Is there anything else from that?
Yes, the foster parents have created a safe space in the home surrounded by books and pillows and blankets in order to give Utica a comforting and soothing space. That was one of the recommendations, as well as she is already engaged in occupational therapy through IV rehab. That was another recommendation. So they are working towards benefiting and working on her fine and gross motor skills. And then she already is engaged in EMDR therapy as well through CMH.
Thank you. Your Honor, I have no further questions of Ms. Madrid and would move to admit the court report with the attachments.
No objections.
I have no objection.
I take no position at this point since I don't have a client.
Thank you. I will receive the court report and the attachment. Do you have any questions for this witness, Mr. Brooks?
Well, I think I do. Ma'am, the mother, Carla Collier, is she a member of a recognized Native American tribe or band?
No.
She is not.
Correct.
Do you know whether her daughter is eligible for membership in a Native American Indian tribe or band?
Yes, it is my understanding she is eligible, and that is something that Ms. Collier was working towards with her CMH caseworker.
What does it mean she's working towards it?
I believe they had to fill out an application, and she can maybe give a better update on that.
She being whom?
Ms. Collier.
And would that be through her father or her mother's heritage?
Mr. Thomas.
Mr. Thomas. Not Mrs. Collier.
Correct.
There are some pretty serious charges alleged against Mr. Thomas in your report. But apparently, we've just found out he's been released. And I really don't expect you to know the answer to this right now, but could you investigate and find out if those charges are still pending or not?
Yes, I will.
And let me know.
Yes.
That's all I have. Thank you.
Okay, when, if any, what if any contact have you had with him?
I have not had any direct contact with him. I have had direct contact with the jail where he was residing, as well as the attorney that was prosecuting his case. But they just informed me that there was a trial that started on the 12th, and I have not had an update since then.
Oh.
That was just 2 days ago?
Yeah. So I believe there must have been an outcome from that trial. I'm not sure. I will get an update to the court.
May I have a follow-up question, Your Honor?
Yes.
do you have the name and phone number of this prosecuting attorney?
Yes, I do. I can get that to you.
All right. Your Honor, does the court wish to wait until the no longer on Zoom or whatever to get the information?
Yes, please.
Then I have no further questions.
Mr. McFarland?
My client indicates she's had some difficulty navigating the process for registering the child with the tribe. Is that something you could perhaps sit down with her and assist her through that process?
Yes, I can. And I can work with her CMH case manager as well.
Okay. My client also indicates that she was raising the child in a particular religious belief, which is Norse paganism. What steps have you done to maintain the child being raised in that belief?
I was just made aware of that today, so I will be looking and exploring that and making sure that we address any things that we can address.
Let me ask you, when did you reach out to ask mom what belief she practiced with the child?
I did not.
So when a child is placed, how do you know what religious belief to raise them in if that question's not asked? Just curious.
I do not have an answer for that.
Okay, so you'll get with her to find that out, correct?
Yes, I will.
That means maybe online or through books, or you'll contact mom to see how she does that, right?
Yes, and I mean, she's the expert, so I'll rely on her to get that information.
Okay. I know mom moved here from out of state, correct? Because she was not living in state when this case was open. Do you agree with that?
She was here when the child was removed and then she
Okay.
fled.
Well, she returned to the state, correct?
Yes.
And she now has a job here in Michigan, I'm told, correct?
Yes.
And she's now asking, you're now doing an investigation on a place where she's living, so she's living here in Lenawee County, correct?
Yes.
So what is your belief that she might be a flight risk? I thought I heard that.
Just based off of her history, and she was staying at the shelter during the majority of this reporting period, but then just recently secured that housing, so.
Okay. If this house turns out to be appropriate, what does that mean as far as the case?
If it turns out to be appropriate and it's something that she can demonstrate over time, then we can look at exploring visits there, as well as, taking Utica there and spending time there over time.
Okay. It was brought to my attention that it's alleged my client threatened maybe perhaps a child protective services worker. I don't see that in your report. Would you agree with that?
Yes.
Do you know anything about the allegation?
It's my understanding that a police report was made on February 9th based off of something that she reported to her case manager as regarding the CPS worker.
So it was a discussion that my client had with the case managers. It was something that she reported to the case manager. Is that what you're telling me?
That's my understanding, yes.
Okay. You've not had any issues with my client in the way she interacts with you. Would that be correct?
Correct.
Okay. I know there's quite a lot of things to do on her case service plan. So if we could prioritize, where do you think her priority would best be spent if you could assist us?
Yes, so the best thing would be to following any and all of the recommendations that are going to come from the psychological evaluation, and then as well as beginning and engaging and benefiting from her individual counseling that she'll be getting through CMH, continuing working on the attachment therapy through CMH for Utica, and then maintaining her employment and housing.
I don't see this in your report, but my client visited me in my office, which is great because most don't, but she reported that Linda Edwards took her to a doctor's appointment for the minor child, but nobody informed Ms. Edwards or my client that the appointment had been canceled. Are you aware of that?
I am not aware of that, no.
Do you have any reports from Linda Edwards regarding her transporting your visits or anything?
I do not, no.
Okay. I guess what would be the procedure going forward so my client and Ms. Edwards, apparently she doesn't get paid if there's no appointment at the other end, that this doesn't happen down the road?
We could definitely put in more communication lines in order for Ms. Collier to get information directly, maybe from the caregiver. So there's no lapse in time and she's receiving that information directly.
Okay. No further questions, thank you.
Ms. Heist?
In my experience, CMH won't prepare a letter for our regular reviews. Would you be willing to get a release from mother so that we can look at her raw records from CMH so that she can have credit for EMDR and her medication compliance and her attendance and all those kinds of things?
Yes, and then I believe she would be willing to sign a release as well.
Okay, and then, that concludes my questions. Thank you.
Any redirects, Ms. Thomas?
For your honor.
Any cross-examination, Mr. Brooks, Mr. McFarland?
No, thank you.
I think I asked you, did I not, ma'am, if you had any home address information or phone number for Mr. Thomas?
I do not have that information for him, no.
Thank you.
Okay, thank you for your testimony. May you return to your seat. Any other witnesses, Ms. Thomas?
No, your honor.
All right, Mr. McFarland?
We don't believe there's a need for my client to testify. She understands what's required of her in the plan.
Very good. Mr. Brooks?
I have no clients. I have no witness.
Ms. Heist?
No witnesses today, thank you.
Very well. Well, Mr. Brooks, your client was here at the last hearing. He was given verbally on record notice of the initial disposition set for today.
That's an
obvious
statement, Your Honor.
I'm sorry?
Your statement is accurate.
Thank you. I appreciate you confirming that. I raised that point because his initial disposition is set for today, and I would be inclined to proceed in his absence, given the fact that he has notice, unless you have any objections.
I don't know. Does he have notice? Would he have any evidence? Well, the notice would be his presence at the last hearing, wouldn't it?
Yes. And there was a copy of the order setting the date. Let me double check that, but I think that got emailed over to the jail too. Now, I don't have proof of service that he received it. But he was certainly here at the last hearing to hear this date.
Maybe when I get a hold of the prosecutor in Washington State, I'll find out how to contact him.
All right. Ms. Thomas, any objection to proceeding with the disposition?
No, your honor. I would just call Miss Madrid back to the stand.
All right, Ms. Madrid. Mr. McFarland, any objections?
No.
Ms. Heist?
No, thank you.
Very good. All right. You have been sworn. You remain under oath. Go ahead, Ms. Thomas.
Thank you. Ms. Madrid, as relates to Mr. Thomas's case service plan, have you had the opportunity to discuss that with him?
I have not.
Okay. And when you developed that case service plan, what tools or information did you use to develop it?
I primarily use the removal petition.
And do you believe that as it's written, it would address the barriers to unification with Mr. Thomas at this time?
Yes, I do.
Okay. Go ahead. I'm sorry. Go ahead if you have anything else.
The only thing is that it was divided into two parts. One part is during his incarceration, and then the other part is if he's released. So now that he was released, I will need to change that.
Okay. And I guess we don't really know what's happening with the case, but apparently he is released. So, okay. And during this review period, have you been able, or since he was adjudicated, have you been able to start any voluntary services with him or send any information to him?
The only thing I've been able to send is the case service plan and then the updated court reports to him.
Okay. And as it relates to reunification for him, that's also a permanency goal for the child, and that includes father, correct?
Yes.
Okay. And you, in your earlier testimony, stated that the agency is working with ICPC for placement inquiries in, I believe it would be California and Alaska. Is that correct?
Yes.
And that's through Mr. Thomas's family, right?
Yes, an aunt and grandparents.
And you still don't have any updates from ICPC on those points?
I do not. I have maintained contact with the relatives.
Okay. All right. Do you believe that it's appropriate for the court to adopt the case service plan for Mr. Thomas at this time?
Yes, I do.
Thank you. Your Honor, I have no further questions for Ms. Madrid.
Cross-examination, Mr. Brooks.
Absent any direct contact with my client, what is the benefit, other than building up a case against him, of adopting a case service plan that he knows nothing about?
I do believe that the case service plan addresses all of the reasons that Utica came into care, but I did not have a chance to review that with Mr. Thomas. No.
Which leaves my question unanswered. Do you agree with me? He knows nothing about this document?
Yes.
So how can he either A, obey it, or B, disobey it if he doesn't even know it exists?
I don't have an answer to that question.
I have nothing further.
Mr. McFarland?
I don't think the question's been asked. Do you believe that you're taking active efforts as is required in this case?
Yes.
Is there anything other than what you've testified that would consist of active efforts?
No.
Nothing further, Your Honor.
Ms. Heist?
The case service plan for Mr. Thomas also includes commitments by the agency, is that correct?
Yes.
And so in the end, we can change the case service plan at any time that Mr. Thomas starts participating and seeking benefit services, is that correct?
Yes, it is.
So if he reaches out to you for visits and that kind of thing, we would have a guideline to support him in a potentially reunification, correct?
Yes.
Thank you, nothing further.
Any redirect?
No, Your Honor.
No.
Thank you for your testimony. You may return to your seat. All right. Any other proofs as it relates to the disposition today?
No.
No, Judge.
Nope.
No.
Very well. Comments on the review as well as the initial disposition, beginning with Ms. Thomas?
Thank you, Judge. At this time, we are asking the court to enter in the initial disposition order for Mr. Thomas. He has been adjudicated. And the case service plan as written allows for the agency to provide services that are required or that would help address those barriers to reunification with him. And when he avails himself or when he is located, then he can also be made aware of those and continue to move forward. As stated on the record, he did have notice of today's hearing. As it relates to the review, we're asking for a standard 90-day review. I don't think that this case is calling in asking for anything special here. You know, I think parenting time as is appropriate. We are still waiting on the formal results of the CTAC and of mom's psychological evaluation, at which point we will have more information and how case management may be affected by that, including things like parenting time. But for now, we are asking that the parenting time continue to be supervised. And we have a standard 90-day review. Thank you.
Any comments, Mr. Brooks?
I can't have too many with no input from my client. I really want to make sure that Ms. Madrid doesn't forget to give me that name and phone number in Washington. I think once I've talked to my client, I may have some comments, but not yet.
Well, Mr. McFarland?
Well, we appreciate that the worker is going to assist my client in enrolling the child in the tribe. It can be sometimes hard to navigate these things. We also sense now that the worker is going to be sensitive to the cultural, religious doctrine and beliefs of my client. The child will be raised in those in foster care, as I believe is the norm. My client has a clear path of what she has to do. Will be clear once we have the psychological evaluation results. I would hope that if the house checks out fine, that what the worker described as progressing to visits at the home and perhaps expanding to unsupervised will indeed be incorporated, maybe even within this next 90 days. Thank you.
Yeah. Ms. Heist.
I have no comments. Thank you, Your Honor.
Well, the court finds all interested parties were given notice for purposes of today's review hearing. I was able to obviously listen to the testimony of our witnesses today, as well as review the court report and attached information. For purposes of establishing the initial disposition and the case services plan for Mr. Sean Thomas, I do concur with Ms. Heist. In addition to my prior ruling that an adjournment is not necessary, given the fact that he was told about the date for today, but also that it continues to be pertinent for the department to understand and abide by their obligations, and that as soon as Mr. Thomas either reaches out or is found, he would have the opportunity. I'm confident Ms. Madrid would work with him to tailor a plan that would best suit his circumstances once we find out what those are. So for those reasons, the initial disposition order will be issued today with the case services plan. We will attempt to serve it to Mr. Thomas at the last known address, but if we can find an email address for him to, Ms. Madrid, if you could pass that along to the court as soon as possible so that we can start utilizing that to make sure that wherever he's at, he may have access to that, at least digitally. I really appreciate that. We still have Ms. Collier's email, and she was served as well. And with a copy of the proposed exhibits for today, she had access to her attorney as well. Thank you to our advocates, by the way, for your work on the case and with the parents as much as you can, especially Mr. Brooks in that situation. We appreciate you taking the time to try to reach out and locate your client as well. And Ms. Madrid will be doing that, I'm sure. There are active efforts being made in this case. Active efforts versus reasonable efforts would include things as tailored to the case as possible, which includes the information from the tribe as they're able to give it, and the materials that the foster placement, and I'm sure the foster care caseworkers are helping find on the native village of Buckland. We will continue to keep them updated on our court hearings, and Ms. Madrid will also pass along a copy of this latest court report to them as well at the address, at the email address that they requested us to send that to. The additional examples of active efforts would also include meeting with and helping Ms. Carla Collier schedule appointments, offering those transportation services to and from different things, even though unfortunately we had a little bit of a lapse in communication about doctor's appointments, but those extra services like transportation, the planner, the materials for the online parenting class, all of those things are examples of active efforts. It's going the extra mile, if you will, for a parent. A foster care caseworker really only has an obligation to make referrals and to check in with the parent on a monthly basis. So Ms. Madrid is making active efforts above and beyond that. And those are exemplified in her witness testimony, as well as examples of that contained in the court report today. The child is in the safest and least restrictive placement at this time. We would need Ms. Calyer to establish stable housing, show us that she's able to maintain that employment and housing. We need to find the results of the psychological evaluation to make any additional referrals. Congratulations on getting into CMH services and EMDR therapy. I know that can be challenging. So it takes bravery to do that, and I want to commend you for that today. Keep on with those services and engagement with your daughter, who is also undergoing those services, so that we can see that you would be able to present a home for her that would be alleviated from the risk that we've seen in the past, that a child needs a stable, safe environment where she can have her needs met. And so that's what we're asking you to establish before she can be returned to you full time. For the other additional reasons that I don't want to explore on record today in light of wanting to simply commend Ms. Calyer on her progress. The child will remain in services until she's been able to reach those goals for some of the reasons that were explored on record as far as Ms. Madrid looked at those issues that would continue to form the risk of harm associated with allowing the child to return to her mother full time. Our next review hearing I would like to offer to you for both parents at this point would be mom's second regular review and dad's first regular review would be April 30th, 2024 at 1:30 p.m. That's an afternoon hearing set so that if the tribe is able to or prefers to engage from Alaska, and if Mr. Thomas is available to us, the time zone change would make that easier for them to participate in the afternoon. So that's another way we're trying to reach out to the tribe and to Mr. Thomas to engage them. So we'll see you back here on April 30th at 1:30 p.m. for our next set appearance. Any questions?
So my client wait out in the hall for.
Excuse me.
On record for a review in this matter. Names of our participants, please.
Carson Howard, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Ms. Madrid.
Francesca Madrid, foster care worker from Foster Youth Solution.
Michael Brooks, I represent Mr. I believe his first name is Thomas.
Sean Thomas.
Sean Thomas, that's it.
Mr. Thomas, are you here with us this afternoon?
Yes, I'm here. This is Sean Thomas.
Thank you.
Michael McFarland representing mother. I've checked out in the hall. She is not here. I've checked with my office. We have heard and received no contact from her, Your Honor.
Carla Collier. We're looking for Carla Collier. I don't see anybody logged in under that name, nor do we have anybody in the waiting room. I just want to say for the record, this has also been set for permanency planning for today. And then do we have a tribe representative here today?
Joe Washington, ICWA coordinator.
Great. Did you say Joe?
Yes.
Perfect. Got it. Welcome. It looks like this is our fifth review. Does that sound right, Ms. Thomas? I'm just getting this case back from Judge Costello, who had a number of hearings in this case. Mr. Howard's also relatively new on the scene at the beginning of the year, so get a little fresh perspective, but if there's anything that comes up, please don't hesitate to ask or let us know. Mr. Howard, did you get a chance to meet with the child?
Yes, I met with the child and her foster mom in my office on December 20th, 2024. I was able to observe the child play with a few toys that were in my office, and she reported that she had just come from her school Christmas party, so she was in pajamas and outside of her normal school uniform. The child's needs are being met. Her foster home provides stability and a family-like atmosphere. She reported that she really enjoys playing with her foster siblings and that they have a large play space at the home where they can all, hang out and play together. The child's foster mom demonstrated a deep understanding of the child's needs. Specifically, the child suffers from seizures, and she is well aware of the signs to look for and in very open communication with her medical providers. And she can get guidance at a moment's notice if necessary. The child appears to be very bonded with her foster mom, referring to her foster mom as, mom. And I was impressed with the foster parents' respect for the child's biological mom's wishes to enforce the Norse pagan religion as part of the child's life. When we discussed it, the foster mom was able to talk to the child about it in a very, simplified way for the child to digest and really understand and have it be part of her life. I cannot report on the child's best wishes as she is fairly young, and I'm still working to, familiarize myself with her and, create a comfortable relationship with her. But I do believe that this placement fits her needs and is in her best interests at this moment.
Thank you. All right, testimony today, Ms. Thomas.
Thank you, Honor. Ms. Madrid can be sworn in to provide her report.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Whenever you're ready, Ms. Thomas.
Thank you. Sorry, Ms. Madrid, I was just looking at your court report again, so I apologize for that. In the court report you provided the beginning of the month, you included the court report, the case service plans for Ms. Collier and Mr. Thomas, and then also a discharge letter from ACPC regarding Ms. Collier. Are there any other documents that have been circulated since filing this packet?
Not at this time, no.
Okay. And at this time, would you consider Ms. Collier to be an absent parent?
Yes.
Your report does not have any information regarding that. I'm guessing in part because at that time she was not absent or not considered absent, but can you please provide us with some efforts that you've made to contact her or locate her?
Yes, I haven't had contact with her since the beginning of December. I have attempted to call and text. Her phone is not in service, so it doesn't even ring. I've attempted to email her as well. I've attempted to ask anyone that I know that might have association to her. I also went to her previous employer. I went in to ask if maybe they had updated contact information, and they stated that they had no updated contact information and that she was not employed there. So they did confirm that for me. That's all.
Yeah. To the best of your knowledge, did she receive this court report and notice of the adjourned hearing?
To the best of my knowledge, I do believe she received this court report. I am not sure if she knows about the adjournment.
Okay. Did the email address that you sent her the court report in, is that the one that you've used since the onset of this case? Okay. And during this review period, so since November 14th, since sort of a shorter review, what would you, or how would you describe her compliance within benefit from her case service plan?
She has not been compliant with her case service plan during this reporting period. She was discharged from her individual therapy back in December due to lack of communication and attendance. She was discharged from the family assistance program with Orchards in November due to lack of communication and attendance. She lost her job. She has not secured safe and stable housing. And she also has decided to stop communication with the agency, specifically myself. I did include some communications that she sent to me directly, just stating that she didn't want to work further with the agency after several accusations that she made against the agency, theft and human trafficking and things like that. We haven't had communication.
And then it just briefly, as it relates to Mr. Thomas, I know that it's a little difficult with him being so far away, but have you had any updates on any services that he might be engaged in?
Not at this time. I know the only update is that he did move to Alaska with his parents, and he might be able to provide more of an update if he engaged in services, but I did research some services in Alaska and sent him contact information for that, for him to get started. I don't believe he has done so, and he has still maintained that he wants to release his parental rights.
And I know that this has been an ongoing topic at many reviews since the beginning of this case. Is the child, do you have any updates on the child's enrollment in the tribe?
Yes, so I didn't get a chance to speak again after the last review, but the eligibility paperwork was sent to the tribal administrator that we had previously. It was sent back in August, as well as her birth certificate and social security card. And then when we got the new administrator, it was resent to him in November. So I didn't get a chance to tell the court after it was discussed whether or not it was sent, but it was sent in August and it was again sent in November, and he is connected, so he can confirm that.
But you don't have any further updates from the tribe itself?
Not regarding the actual process or where we're at, no.
Okay, that's fine. Okay. And during this review period, I guess, or in general, as relates to permanency planning component, do you believe that there's sufficient progress to consider or to continue towards the goal of reunification?
Not at this time, no.
And what is your recommendation for permanency for this child?
We are asking for the goal to be changed to adoption.
And I know that this is addressed in your report, but for the record, is the current placement willing to provide permanency through adoption?
Yes, they are.
Okay. And is there are there other family members that may need to be considered as competing parties through the adoption process?
Yes, it's my understanding that the paternal aunt would like to be considered for permanency.
And is the child still receiving visits with the paternal aunt?
Yes, we do Zoom visits about once or twice a month.
And how are those going?
They're going well. She's able to talk with her cousins and able to share about her day in school and things like that. They're going really well. She spends most of the time talking to her cousins.
Okay. And how would you, I guess, how would you describe or identify how the agency is complying with the active efforts standard in this matter?
Would you like me to read them off?
Well, I know that they're in your report, but if you can just summarize, particularly in this last review period, the concentrated efforts to achieve the permanency goal.
Yes, so we did attempt to meet with Ms. Collier several times face to face. I offered several times transportation to her and bus tokens and gas cards. We submitted the travel application back in November as well. The biggest barrier I would say to the efforts has been her returning the contact and meeting with me, or when we do schedule her showing up. I've offered to pick her up from wherever she is, but she has not been willing to give me an address. Yeah, those are my active efforts have been a bit limited due to her contention.
And then as it relates to services for the child, I would say that you have active efforts there as well. Or can you just briefly highlight that for the court?
Yes, Utica is doing really well. She is still engaged in EMDR. She does have a neurologist to address all of her seizure concerns. Although she's doing really well in that area, it's being monitored. She's doing really well in school. We have updated monthly meetings with the school staff to ensure that all of her needs are being met. She's doing really well in the foster home. Is very bonded to her foster siblings in her community, and all of her needs are being met.
What would the risk of harm be to the child, or maybe it's better asked what the barriers to reunification are for Ms. Collier? I know that you've briefly touched on that. If you can just reiterate that for us.
Yes, so it would be emotional instability, lack of safe and appropriate housing, and being in financial crisis at this time.
Is there any indication that is still in Lenawee County?
There's not. I did speak to her therapist, and she stated that she wouldn't give her location as well. I have no indication that she's still at Adrian.
In your report, there's an indication from, or an accusation that she was beaten by, it's not Mr. Thomas, but his cousin or his cousin's family. Do you have any additional information on that?
I do not. I'm also not exactly sure who it is. She says her child's father's family. She didn't provide any documentation when I asked for it, or even what hospital she was in. So I don't have any further information on that.
There anything else you'd like the court to know just from your court report or your knowledge of the case?
Not at this time, no.
Okay, thank you. With that, Your Honor, I have no further questions of Ms. Madrid and would move to admit the court report and the attachment.
No objection.
No position without a client.
No objection.
Okay, Mr. Washington, do you have any objections to the admission of the court report or the discharge letter for Ms. Calyer?
I have no objections, Your Honor.
Thank you. They are received and will become part of the file. While we have you, do you have any questions for Ms. Madrid?
No.
Okay, questions, Mr. McFarland?
I do. Have you talked with the tribal representative on what impact it would have if father released his rights before the tribe made a decision on eligibility?
It is my understanding that she would keep her eligibility, her Native American eligibility, whether or not Mr. Thomas releases his rights.
Who did you speak to on that?
Mr. Washington.
Thank you. As far as active efforts, I know my client, when I had represented her in the past, she was concerned about raising this child in Native beliefs and also some particular beliefs that she had. What active efforts are we using to keep her involved with her Native American culture?
Yes, so we have been able to get a lot of information from her paternal aunt, who has provided us with pictures of her grandparents, her genogram, family tree. All of that information has been provided to the foster parents in Utica. And we have been provided with books from the paternal aunt. So this reporting period, we have been able to get a lot of information from her in regards to the Native Village of Brooklyn. And we have been able to provide that to her. However, I haven't gotten anything from the tribe itself. So they will be providing me info. I spoke to them today. So if there's anything else that I can do, they'll get that to me.
Current foster placement is a non-family member, correct?
Yes.
So there is a possibility that if the permanency was adoption with this non-family member, the family member could choose to cut her off from her aunt and her cousins. That nothing would prohibit that, correct?
I know that that wouldn't happen because the foster parents have a child that they previously adopted whom they still keep in contact consistently with the biological parents.
There's nothing in the policy that says that they have to do that. That's just their word, right?
Correct, yeah, based off what they've done.
I understand. Email, you emailed a copy of the report to my client, is that correct?
Yes, I did.
Did it come back undeliverable?
No.
Email her any type of notification that we had a hearing today?
I did not send her anything besides a text and a call.
It showed that, well, the call, I think you mentioned, did not go through, is that correct?
Correct.
And the text was to the same number?
Yes.
That did not go through either?
Well, I didn't get a not sent, but yes.
Okay, guess I'm confused. When you text, what happened?
It didn't give me like an error red message or anything like that. It showed that it sent, so
Okay.
I mean,
Fair enough. Okay. Her last known whereabouts was in Lenawee County, is that correct?
yeah.
If she's listening on YouTube, we're on YouTube, Your Honor?
We are.
If she's listening on YouTube, what would be her priority to re-engage in this case?
Her priority number one would be to contact me or to contact you and re-engage in any part of her case or span, whether that be to recontact her therapist at ICPC and get re-engaged in that just due to the recent concerns we've had.
Probably a good thing for her to reach out to you and to have maybe a telephone or a Zoom or in-person meeting. Is that what I'm hearing?
Oh yeah, absolutely. If she reaches out to either one of us, I'm available for a meeting at any time.
Okay, nothing further, Your Honor.
Any questions, Mr. Brooks?
You are, as I heard your testimony today, recommending eventually here a release of termination of parental rights. Is that correct?
That's what he's maintained, yes,
And you support that?
yes.
When can that process begin to prepare the paperwork to accommodate Mr. Thomas?
Well, I prepared the paperwork back in August and it was sent to him and his attorney. But I can resend that
You sent it to who?
to you and him.
That's all.
Any questions, Mr. Howard?
No, Your Honor.
All right, Ms. Thomas, any redirect?
I have none, Your Honor.
Any other questions, Mr. Washington?
No, I do not, Your Honor.
Mr. McFarland?
Did you send the release paperwork that you prepared to the tribe also?
I'm not sure if I included them in the email. No.
Okay, nothing further.
Thank you for your testimony. You may return to your seat. Thank you. Anyone else you'd like us to hear from, Ms. Thomas?
Not at this time, Your Honor.
Okay, Mr. Washington, would you like to give us any update as far as the tribe is concerned with what's being requested here today or hear from any witnesses?
But she is enrolled into our tribe.
That's great. Would you be able to forward copies of whatever you have that confirms that over to Ms. Madrid?
Yes, I will send you an email.
Great. And then as I understand, the department is asking us to consider changing the goal to adoption for this child, which would mean looking at terminating the rights of Carla, Calyer, and I understand Mr. Sean Thomas wants to release. Do you have any thoughts on that request at this time?
Not at this time, no.
All right. I would assume that the tribe would be investigating that and making a recommendation one way or the other between now and when we come to our next review. Is that a fair assumption?
Yes.
Very well, thank you. All right, Mr. McFarland, anyone you'd like us to hear from today?
If tribal administrator wouldn't mind, I have a question for him. Sir, I represent mother. Does the tribe have a position on the child being placed with family, the aunt, or with a non-family foster parent? Does the tribe have a position?
Would you like to go to the podium?
Yes, let me do that so you can see me, sir. There. Sir, does the tribe have a position on the child being placed with a non-family foster parent or with a aunt who is a family member?
Not that I know of.
Okay. Would you think, will it be expressing an opinion down the road or does that not involve the tribe?
I don't think it involves the tribe.
Okay. Did I hear that you have no objection to Mr. Thomas releasing his parental rights, even if it were maybe today? Is that what I'm hearing?
Yeah, no objections.
Okay. Do you feel that this child is receiving sufficient material regarding her indigenous culture?
Yes.
Nothing further?
Thank you.
Okay, Mr. Brooks, any questions? Anyone you'd like us to hear from?
Mr. Thomas.
Deputy Ames, if you could swear in Mr. Sean Thomas, he joins us.
Mr. Thomas, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, would it be possible for us to facilitate this release by my client today or not?
Typically, if I accept a release, I have to have a copy of the signed documents in front of me.
All right, thank you.
Given the child's enrollment in the tribe as well, I would think Ms. Madrid may have to revise the documents that she prepared to adequately accommodate the considerations required under ICWA and MIFA.
Thank you. Mr. Thomas, Ms. Madrid, the Department of Social Services worker, indicates she mailed you copies of a petition and proposed order to release your parental rights. Did you get them?
Yes, I received them by email.
And have you reviewed them?
I reviewed a little bit of it.
What does that mean?
I skimmed through the first page of what was on the email.
Have you signed it or not?
Not yet.
Obviously, you haven't mailed it back to Ms. Madrid, have you?
That's correct.
What is your position today with respect to releasing your parental rights?
I still have the same position of releasing my parental rights.
Are you aware, based on what you just heard the judge say, that there isn't much she can do till we get this done?
That's correct.
So are you going to sit down and look at them again?
Yes, I'll take a look at it today, and if I'm able to do an electronic signature, I'll get it signed and have it sent to you and Miss Madrid.
You have our addresses.
Yes.
I have nothing further.
Thank you. Any questions for Mr. Thomas from our other attorneys or our tribal representative?
No, Your Honor.
No, Your Honor.
Thank you for your testimony, sir.
Thank you.
Anyone else, Mr. Brooks?
No, thank you.
Mr. Howard?
No, Your Honor.
Comments in closing for today then, beginning with Ms. Thomas?
Thank you, Your Honor. If the parties are agreeable and the court is agreeable, I have the capabilities of getting certified electronic signatures. I would just have to be the one to send them to Mr. Thomas. And so I would ask Mr. Brooks permission to have that communication with his client if that's easiest for everyone to achieve his release at this time. And then other than that, Your Honor, thank you, Mr. Brooks. And then other than that, Your Honor, we are just asking for a 90-day review, at which time we would anticipate a termination hearing for Ms. Collier. I think that the goal for adoption is the most appropriate at this time. It's been over 2 months that she has tried to engage in any type of communication. And I think that by the time we file this petition or have the hearing, she would have effectively abandoned the child if she does not avail herself to the agency for services. I think that there are definitely active efforts being made on behalf of this family through the agency. And then also I'd like to commend the foster care family for really respecting. I think that Mr. Howitt put that really nicely, that there's a lot of respect for the child's birth families as it relates to ensuring that material is introduced to her in an age-appropriate way for the Norse pagan religion as relates to mom, and then also her native roots. So with that, I think that the child is in the least restrictive environment, that there are still significant concerns as relates to Ms. Collier, and that placement is necessary. Thank you.
Any further comments today, Mr. Washington?
No, Your Honor.
Mr. McFarland?
My only concern, Your Honor, I take no position because I do not have a client, but it'd be proof of service. I do have a copy of the order of adjournment. I don't have a proof of service. And it doesn't sound as though my client was, at least I haven't heard testimony, that she was served notice of today's hearing. So I'm not sure if we could really proceed on her portion if she wasn't served. That's my only commentary. Thank you.
Yeah, I would offer to you also, Mr. McFarland, that the email address that has been used for Ms. Calyer successfully to notify her of past court dates and adjournments and hearings and court reports has since come back undeliverable. So I think what we're seeing here is, despite best efforts, Ms. Calyer is bound and determined to sever communication with the agency, which I think will probably pose a challenge for purposes of any termination petition set. to be heard on her case. But I don't think it's for lack of trying to let your client know what's been happening.
Your Honor.
Any comments, Mr. Brooks?
No, Your Honor.
Mr. Howard?
Yeah, I fully support the change the permanency planning goal to adoption. That's
Thank you. All right, the court finds all interested parties were given notice for purposes of today's review hearing. I do find efforts towards the goal of reunification were made by the department through the efforts of Ms. Madrid at the agency. I'm glad Mr. Thomas came today to let us know what his position is, and so he understands what's going to be happening in the next hearing. I am directing the department to file that petition for termination of parental rights as it relates to Ms. Collier, and to prepare the release documents for Mr. Thomas that he's requested. I do that after consideration number one of his request, and of course Ms. Collier's very open decision to abandon efforts towards reunification and termination of contact of her. She hasn't seen the child. She's been in contact with Ms. Madrid. So on top of what we've seen as the challenges Ms. Collier was looking to overcome at this point, she has stepped affirmatively towards abandoning her child, as Ms. Thomas pointed out. The second piece is the fact that this child has been removed from her care since September 1st of 2023. A child at her age with special needs, including seizures, needs all of the support that she could get. When she was removed, she was underweight, she had significant issues, and her mother's frequent moving and unstable mood swings and instability in providing for her certainly affected her to the extent that it was visible physically in her development. She's doing very well now where she's placed. She's well bonded to that placement. They are honoring her ties to the tribe, and the tribe is honoring its ties to her as well, which is excellent. So not only do we have reasonable efforts, but certainly active efforts have been made in this case, thanks to Ms. Madrid, the efforts of the foster placement and the tribe, which we're glad to see that the child will have that support moving forward, regardless of what happens with her mother. So for all those reasons, I am authorizing the goal change to adoption and ordering the department to file that termination petition. I think it certainly serves the best interests of the child at this point in time. The child will remain in her foster placement. Again, she's doing well there. They are taking care of her needs, especially vigilant of her heightened needs, given her condition and diagnoses for seizures, as well as enjoying sharing with her about her heritage. And we'll have our next review, which will also be a permanency planning hearing. And if the petition is timely filed and served, we'll conduct the termination petition on the same day, April 21st at 2:30 p.m., assuming everyone is available for that. April 21st at 2:30 p.m. our time, Mr. Washington. So hearing no objections to that date and time, then that will be the conclusion for today's hearing. And we'll see you all in April for our next phase. Okay, April 21st, check on record. Do we have a representative from the native village of Buckland?
Yes.
Thank you. Your name for the record, please.
Frederico Gavin.
Thank you. And what is your formal title, if you could tell us, please?
ICWA coordinator.
Very good. Would you be the designated qualified expert from the village of Buckland as well as the coordinator?
Yes.
Thank you for confirming that. All right, we have all of our same parties and attorneys that have rejoined us. And I'm glad to see the tribe is here as well. All right, let's begin with a report from Mr. Howard, whenever you're ready.
Your Honor, I don't have an updated report. This was a continuation.
Can you speak up a little, please?
Sorry, I don't have an updated report. This was a continuation, so I did not see the child since the last report I gave.
Okay, would you mind refreshing the record as to how he was doing when you met with him last?
Yes, I was able.
Her, I'm sorry.
Sorry. She was doing pretty well. She was attending some summer camps. She was struggling behaviorally with some of the summer camps. And she had some evaluations for autism, but they didn't think that it was autism. And they were really working on getting her medication in the right spot to address some of the behavioral issues she was having. I have not heard of any increased concerns from the foster parents since my last meeting with them. And I believe she's doing well and getting ready for the school year to start. I know from talking with the worker today that she just completed a family trip up north, and just working on getting ready for school and getting into that swing of things.
Thank you. All right, Ms. Thomas, I believe we had most of or all of you have testimony from your witnesses. Is that accurate?
Yes, Your Honor, the only thing, if the court would like, Ms. Beach did provide a brief memo about any updates since our last hearing. I don't know if it's necessary, if fellow counsel would just stipulate the admission of the report. It really just highlights the contact efforts that Ms. Beach put forward to communicate with Ms. Collier and her attorney.
Yeah, I have no objection to that being here.
No objection.
Very well. The court accepts the stipulation and will receive the court report into the record. It contains the attachment of the case services plan, of course, from Ms. Calyer, and the email thread consistent with Ms. Thomas's presentation. All right. I believe we had all testimony as well from you, Ms. Sador, is that right?
No, we had, I'm not sure, we had not finished with the IGWA representative, so we had one witness testify.
Did you have any witnesses other than the IGWA witness?
I may not, I just need to hear from the IGWA witness to know for sure. If so, it would be one witness and that's it.
All right, well, the IGWA coordinator and the expert would have to make a recommendation as to whether or not termination would serve the best interest of the child. So I would prefer that the coordinator be able to listen to all witness testimony before making that determination. So I prefer if your witnesses went first. Do you have anyone else you'd like us to hear from?
I'm not sure she's present via Zoom. The witness would be Rebecca Sullivan, but I guess since we have admitted her updated case services, not case services, but her updated information within the report, if that can be taken into consideration in terms of what's going on. If no one has an objection, that was mainly what I wanted to ask her about, is Carla's current status with all of the things: housing, therapy, job, health, mental health, all those things. So I would ask to admit that specifically.
Do you have an exhibit in addition to the court report? Is that what you're saying, or?
It's part, she put it in as part of the Ashley Beach's report.
Part of the email exchange?
Yes, there's one from dated July 3rd from Ms. Sullivan. I have another copy. It's got something on the back, but if Your Honor needs it, I can mark that and have it.
Yeah, I'm not quite sure what that is. I recall that one from our last hearing, but there's also an update from Ms. Sullivan within the email exchange that is provided on page 10 of the report, the updated memo that Ms. Beach, that we just submitted. I believe that would be, is that the same? Is that this one?
So let me review what I have. I have a one-page MDHHS 5964 cover letter, followed by the case services plan agency agreement from Ms. Calyer, and then an email chain that's 5 pages. So I also have the DHS 69 documenting changeover from Ms. Madrid and Ms. Beach, but that's it for what I have. So
correct. It should be, it is the same email on page 5 of that. Well, the email threads is at page 5. It states, it starts the page before I sent it to Ms. Beach, and it's from Rebecca Sullivan. It says, as for Carla, I wanted to update you, and then the second page has the updates from her. And that what from her was dated July 3rd of this year.
all right, but the email reflects Tuesday, August 12th.
Correct. I'm just clarifying when the email was sent to me. It was July 3rd. So.
Well, that's not documented really on this page.
Well, I'm happy to admit then. I'd mark and admit the one page when I have that is the original email.
doesn't matter to me. I just wanted to clarify what I had. Are you moving for the admission of that separate exhibit? I'm sorry?
Sure, yes, I can just admit that one. Is respondents A or one, whichever you need to do.
Any objections?
I have no objections, Your Honor.
No, Your Honor.
Thank you. Tiffany, would you mind passing that up? We've received this. His response exhibit A. All right, I do not have anyone under Rebecca Sullivan logged into the Zoom meeting. So I just would like you to confirm one more time, Ms. Sidor, do you have any additional witness testimony for today? No. All right, so that takes us to Ms. Frederica Gavin. I think you'll probably have some questions for this person, Ms. Thomas, if I had to speculate. Ms. Gavin, and in your capacity as the expert in this case, I'd like to have you sworn as a witness. Do you have any reason to object to being sworn?
No.
Deputy, your name is Frederica Gavin, please.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Gavin, before we subject you to questions, do you have any comments about the case you'd like to make today?
No.
Questions, Ms. Thomas?
Okay. Good morning to you, Ms. Gavin. Thank you for joining us. Ms. Gavin, are you a member of the native Buckland, the native village of, I'm so sorry.
Native
Ms.
village of
Gavin,
Buckland.
what is your affiliation? Are you affiliated with a tribe?
I am.
And
a
what
tribal
tribe are you?
member.
I'm sorry, what tribe are you affiliated with?
Native village of Buckland.
And how long have you been a member of that tribe?
About 30 years.
And in your tribe, are you recognized as someone who is knowledgeable in tribal customs?
Yes.
And do you believe that you're knowledgeable as to how those tribal customs pertain to family organization and child-rearing practices?
Yes.
And Ms. Gavin, have you served as an ICWA coordinator in the past?
No.
Were there any requirements for you to be hired or appointed as an ICWA coordinator for the tribe?
The requirements were just experience.
Can you elaborate a little bit more about what experience?
Experience in working with OCS and understanding the tribal membership process and working with tribal members.
Ms. Gavin, you just used an acronym OCS. Can you tell us what that stands for?
I'm sorry, Office of Children's Services.
And does that mean that you would have experience in working with children who are in foster care?
When we have to deal with OCS and they come to our village, we're present when they have to visit families and be a representative of the tribe and just more on the protection side of the tribal member.
Thank you. Have you had any training related to being the designated ICWA coordinator for the tribe?
No.
And how long have you served as the ICWA coordinator?
It's only been a month.
Okay. Ms. Gavin, my notes indicate that you've also participated in these proceedings at the very beginning, which would have been about 2 years ago. Do you have any recollection of that?
A little bit. At that time, I was the tribal administrator.
Okay. And how does your role differ now as the ICPA coordinator from the tribal administrator?
I'm more involved with the tribal members.
Okay. Have you had the opportunity to review the case file related to the subject minor?
Yes.
And in your opinion, do you believe that continued custody of the child or returned custody of the child to the respondent parent, Ms. Carla Collier, would result in the child being seriously, emotionally, or physically damaged?
And I'm sorry, I'm gonna object. She hasn't had her qualified as an expert. I'm not objecting that she would be an expert, but I would ask you qualify her before you ask her.
I don't think that it's on the department to qualify the tribal expert. If the tribe has produced an expert that meets their expectations of expertise as it relates to their tribe and their
I wasn't
customs.
clear from her testimony if I understand the question was asked and a yes was given. I just want to clarify for my client, I'm doing my job to make sure that she's allowed to give expert testimony at this point. So.
Do you have any objections to her being the expert for the tribe?
If I could, before that question is asked, yes, if I could hear her on some questions about what she's reviewed before she makes that opinion.
Objection?
Your Honor, just brief, I don't have an objection to that at all. I just want to briefly highlight that the applicable statute is MCL 712B.17 subsection 1, in which there are 2 categories of individuals, and it is providing an order of preference as who can testify as a qualified expert witness. The first definition is a member of the Indian child's tribe or a witness approved by the Indian child's tribe who is recognized by the tribal community as knowledgeable in tribal customs and how the tribal customs pertain to family organization and child rearing practices. And then second, in order of preference would be a person with knowledge, skill, experience, training, or education who can speak to the Indian child's tribe and its customs and how the tribal customs pertain to family organization and child rearing practices. And so I believe that my hope was that the court would recognize that Ms. Gavin is a member of the Indian child's tribe and as a member for 30 years would be recognized and appointed as an ICPA coordinator would be recognized by the tribal community as knowledgeable in tribal customs and how they pertain to family systems and child rearing practices.
All right, thank you for that guidance specifically. So I maintain then, Ms. Sador, that this is a person who has been offered up by the tribe as their expert, and the court will certainly recognize that. I think at this point, your request of voir dire would be better suited to cross-examination.
Thank you. Ms. Gavin, with Ms. Sador's commentary in mind, though, I think it is a good question to ask. When you reviewed the case file, in your case file, what did you read? What types of documents?
I reviewed the latest status of the child, that she's still in foster care, and read upon the medical section and also the progress of mom.
I'm sorry, the what? I didn't hear that last part.
Progress of mom, is that what you said?
Yes.
Thank you. Okay, and did you have an opportunity to review any prior court reports or documents pertaining to the family over the last 2 years?
I didn't go that far.
Okay. All right. Do you believe that you've reviewed enough information from the case file that you are ready to make a recommendation about the child's needs as relates to tribal expectations?
I believe I've read enough.
Okay. And based on your review of the record that you've had opportunity to look at, do you believe that if the court were to return the child to Ms. Collier, that it would result in serious emotional or physical damage to the child?
Yes.
And can you briefly elaborate as to why that would be your opinion at this time?
From the reports that I read, housing is not stable. And from the medical standpoint, she needs to be taken care of with her medication and all that.
And currently, I guess from the tribe's perspective, how long would you anticipate a parent living in one place, even if it's just one general location, to make a determination if that person is now having stable housing or a stable life?
I would believe about 6 months.
Okay. What other elements of stability would you, or did you consider?
On the medical side, I believe that she needs more participation in the doctor visits and any kind of special needs programs.
Can we just clarify when she says she needs, who is she referring to? The child, the mother, it's unclear.
Mom.
Ms. Gavin, are you? So Ms. Gavin, I just want to follow up on that. Your testimony is that mom's medical attention needs to be addressed, or mom's medical needs need to be addressed, or that the child's medical needs need to be addressed consistently, and mom needs to be more active in that participation.
Mom needs to be more active.
Based on tribal customs and child rearing practices, why does, or how does instability, I guess, translate to tribal practices, and why is it important that this child have that stability?
Repeat that again.
Through the tribal lens, why would it be important for the child to have stability and have ongoing medical treatment and ensuring that the caregiver is following through with those things? Why, what tribal customs or child rearing practices does that speak to? Can you make that connection for us?
In our village, we all take care of each other's, and I don't know very much about city life, and taking care of a child means taking the responsibility to make sure things are taken care of, medical, nurturing. That's our belief.
And does the tribe value parenting that presents information in a way that's child appropriate and doesn't instill fear, or I'll just stop there. It doesn't instill fear in the child?
I'm not understanding you.
based on tribal values, does the tribe believe that parents should raise their children in a way that promotes safety rather than fear?
Safety would be our concern.
Okay. And what are some values that the tribe has to ensure children are safe?
In our community, we are really small and like we all take care of each other's. We see something wrong, we're so close knit, we call parents to notify of something going on. I don't know how else to explain that.
Does the tribe value kindness and gentleness in parenting?
Yes.
Does it value honesty?
Yes.
Does it value consistency?
Yes.
Other than moms, what you've seen as moms in stable housing, are there any other concerns that you believe would pose a risk to the child's emotional state or her physical state?
I don't have no other comment.
And at this point in time, do you think that it would be in the child's best interest for the mother's rights to be terminated and for her to be adopted and potentially by her current foster care givers?
From the record of participation that I read, I believe that she is in a better place and that the attention that she's receiving emotionally, medically, I would say yes.
Okay. Thank you, Ms. Gavin. I don't have any further questions for you, but if the other attorneys will, okay? Thank you.
I don't know.
Like you go next.
Okay, that's fine. Thank you.
Hello, Ms. Gavin.
Hello.
I'm the attorney for Carla Collier in this matter. Can you please clarify the dates of the updates that you said you read before coming to your conclusions? Was it just one report and what date that was reported?
I kind of browsed through the whole file just here and there, and then the last comments of participation. I don't have the file in front of me right now.
Okay, who gave you the file that you were reviewing?
It was in the file where the previous ICWA coordinator kept cases.
Okay, can you tell me if you read the original petition?
You mean the records from the beginning of the case?
The original petition to remove the child initially, yes.
When the case first started as the administrator, I reviewed that.
Okay, have you reviewed the amended petition supplementing that?
I believe I did.
Are you sure if you did or if you didn't?
I'm not sure.
Okay, all right. So are you aware of what the reason was for the child being removed? What the allegations were?
Yes.
And what were those?
lack of housing, the medical instability.
And that's it?
Yes,
Okay. Do you know when the child was removed from her mother's care?
I would have to look at that file.
Do you know approximately how long it has been since the child has been removed from her mother's care?
I believe a couple of years.
Do you have nothing more substantial than that? A couple of years
No.
is the best guess? Okay. Do you know when mother's rights to visit with her child were suspended by the court?
No.
Okay, you testified that mom needs to be more participating in the child's medical care and things like that, correct?
Yes.
Would it change your opinion if you knew that she wasn't allowed to participate in those things with her child at this time due to the court?
Yes.
Okay, how would that affect your opinion?
Well, if I didn't have very much time to review it, I'm sorry. But if she were participating in her rights to see the child, that would change my view.
Okay, do you know where Carla Collier, mom, where she lives at currently? What state?
No.
So if you learned that Carla Calyer is currently living in Alaska and has been living in Alaska for the past several months, would that change your opinion about where the child would be best?
I don't know. I can't answer that.
Okay. If you knew that Ms. Collier was in a place where she could let the child visit with native tribes of Alaska, including possibly the village of Buckland, but also in general in the Alaska area versus here in Michigan, would that change your opinion about where is best for the child?
If there was documentation stating that she was participating with the child, I believe so.
And do you know where the child is living now, other than with foster parents? Do you actually know anything about her current placement?
I have a little idea, but I can't say the state right now or.
Okay. So you don't know what state they're in?
Without looking at the file, I can't say that.
Okay. Do you know how much or if any interaction has gone on from the tribe in Buckland or from Mr. Washington, Joe Washington, who was previously involved in the case regarding any kind of cultural sharing and things like that with the child and her foster family?
I don't know.
When you say that the medical needs of the child are important for the mother to be involved in, which medical needs specifically are those?
The seizure disorder, and well checkups is my opinion.
Are you aware that mom, Ms. Collier, now has been living in the same apartment in Alaska since at least 5 months ago, if not before that?
I wasn't aware.
Okay, does that change your opinion?
My opinion is that she needs to be involved with the child.
Right, but I just asked you that you said that it would be different if you knew that she wasn't allowed to be directly involved with her child by the court, correct? I guess my question to you is, if mom is not allowed to visit the child, to call the child, to have any video conferencing with the child, and mom does not live in the same city as the child in the foster family, does that change your opinion about mom's behavior? That caused you to say that you think it's in the child's best interest to keep her away?
I don't want to answer that because I need to see the reasons why she was not allowed.
You don't know the reasons why the court suspended her parenting time. Is that what you're saying?
Yes.
Okay. Are you aware of, just one moment. Do you know the child's biological father?
I've read the name.
Is he also a member of your tribe?
No.
How is Uta then a member of your tribe?
From descendancy.
Through which line, mom or dad?
Dad.
Does he have direct ties to the village of Buckland?
Descendancy. He's eligible to enroll.
Okay. Have you ever spoken with him before?
No.
Are you aware that he gave up his parental rights voluntarily?
Yes.
Have you discussed anything to do with Utica Collier or Carla Collier with anybody within the Buckland, Native Village of Buckland community who may be a relative of the child's father?
No.
Okay. If you learned that the mother is now involved with some therapy for herself and to help her become a better parent, would that, and she's been doing that for a while, would that change your opinion about the child's best interest?
Yes.
Okay. In what way would it change it?
If she's doing whatever it takes to be involved with the child and to have her rights.
Okay. You testified that it's your opinion that the child would be, if the child was returned to Ms. Collier, that she would likely suffer serious emotional and physical damage or harm. Is that your testimony from earlier?
Yeah.
Okay. What specific emotional or physical danger and harm are you referring to? Or what are you basing that on?
I'm thinking that the medical, taking care of the child with the disorders that the child has, the involvement is not there. The child needs to be taken care of medically.
Correct. If you heard that mother has always taken care of the child medically, with the exception of one noted example within the possible file record from a whole other state from years ago, would that affect your opinion?
Say that again.
If you were made aware that the mother had been taking care of her child's medically, her seizure disorder, giving her the medication, having the medication on hand with the exception of one documented time when that is alleged not to have happened, would that change your opinion?
If there was more documentation to show it, I think that would change my opinion.
And did you hear the testimony of Carla Calyer during the proceedings of this case at all in the last 3-4 months?
No, I've just become the coordinator, so
Right, I understand. I'm not trying to blame you. I just need to get these legal issues out there, okay? Do you, can you even tell me what you have reviewed regarding exactly what it is that you're referring to when you say, Mom, is it participating enough?
the latest reports of her involvement, no
Dated when?
contact. I
Dated
can't
when?
tell you that. I don't have
Do you
the
know how
file.
many you've read?
Probably a couple.
Probably a couple. Does that mean probably two?
I saw the report of where they would try to contact her and she wasn't able
And
to be contacted.
what date would that be from? Do you know?
I don't have the file in front of me, so I can't tell you that. I'm sorry.
Are you aware of any physical charges regarding anybody with Carla against the child in any way? Any child abuse charges? Okay. Are you aware of any proven allegations of actual abuse by Carla to the child?
No.
Are you aware that Carla left the area where the child is in foster care due to her own concerns for her health and safety that are separate from the child?
No.
Are you aware that Carla Collier had lived in Alaska previously?
I am aware that she lived in Alaska previously.
And are you aware that she had dated people from the Alaskan native village of Buckland tribe, including Utah's father?
I know that she dated her Utah's father. That's all I know.
Are you aware that she is aware of cultural significance of the Alaskan native, native village of Buckland tribe and their culture and the things that they do? For example, she's gone on caribou hunts before herself. Did you know that?
No.
Okay. Do those things change your opinion of what mother's ability to parent this child will be?
No.
And why not?
What does hunting a caribou have to do with raising a child?
It is something that you are supposed to be reviewing as the representative of the tribe for the ICWA coordinator. Has to do with the reason that the prosecutor asked you all those questions about your familiarity with the cultural norms of the tribe. That's the same kind of thing that I'm trying to ask you about. Is it better, in your opinion, for the child who is of Native descent and is registered with the Native tribe of Buckland? Is it better for her to be involved in someone's, with a parent who has knowledge of Buckland's background and their culture and their history than to not?
I don't believe who she dates or whether they're of our culture. It's, I believe in I can't put it into words. I believe taking care of the child is what matters.
That didn't really answer my question. Are you aware that Ms. Calyer made all of her parenting time visits when she was allowed visits with the child after the child was removed and before they stopped her visits? That she made those visits?
I'm going to object to that question because it's factually inaccurate.
That she made I'm sorry, I will restate. That she made the majority of the parenting time visits with her child, that she did do that until her parental rights, up until that time. That they took away her ability to visit the child.
Yes.
Okay, so that goes to the mom's participation, does it not?
Yeah,
So that should go in her favor in your book, should it not?
yes,
Okay, and the fact that mom didn't have housing when the child was removed or soon thereafter, that being a long time ago, compared to her having the same stable housing that she can continue to have from at least January or late January of 2025 forward in Alaska, doesn't that go for the mother in your book in terms of what you think that is important for a child?
I didn't know that she had stable housing.
Okay, well, again, if all you've read, you can't even tell us what it is that you specifically reviewed, it's very hard to believe your opinion has a lot of weight behind it, other than what you've been told to respond.
Your Honor, I'm gonna object to this line of, that wasn't even a question, that was argumentative in general. I mean, at this point, I believe that Mr. Doerr's presentation or conduct towards the witness is becoming hostile, and I would ask the court to instruct Mr. Doerr accordingly.
Would you like to respond?
Yes, I don't believe in becoming hostile. I am asking valid questions of an expert witness about things that she can't tell us about because we don't know what she's reviewed. It's not on the record what she has reviewed. We don't know how much information from before this last report, if that's the report she's referring to, that she did review. And I don't think it's appropriate to have a witness who is unaware of the actual factual situation go with what the other side tells her is going on as what's happening, and that being the only thing that should make her expert opinion.
Mr. Doerr, that's a perfect example of an argument, as was your last comment or argument to the witness. So I will ask you to simply ask questions of Ms. Gavin and not argue or review your arguments for us by way of your cross-examination.
Thank you. Ms. Gavin, did you review the psychological evaluation that was done of Ms. Collier throughout this case?
No,
Did you review the updates from a person named Rebecca Sullivan from Love Alaska program regarding Ms. Collier?
no,
Did you review the child's trauma assessment?
no,
If you were made aware that the child's trauma assessment stated that one of her strengths was attachment relationships, would that affect your opinion about this case?
if I reviewed it, it depends on what it said. I can't, without reviewing it, I don't want to make a statement.
Just one moment. Just one moment, Judge. I'm trying to find the relevant portion. So you don't have any paperwork before you that you could look at right now, is that right? Ms. Gavin?
No,
Okay. Judge, I don't know how best to do this. I would like to have her refer to what it says in the child's report about her attachment situation to help form her real opinion of what is best for the child, and she doesn't have that before her.
I don't know, Ms. Sador, this is your cross-examination.
It's part of the record though, Judge, and she's supposed to have reviewed the record.
Well, I cannot instruct you on how best to navigate what you're trying to do without giving you legal advice. So you're welcome to take a moment to try to figure that out. And I'm not going to instruct you on how to do that.
Thank you. Can I have a 5-minute recess, please?
Any objections?
No, Your Honor.
Take a brief recess. Thank you for your patience, Ms. Gavin. As well, our file 23168NA. All right, we are back on the record. Ms. Sedorn asked us for a brief recess. Are you ready to resume cross-examination on Ms. Gavin?
Thank you.
Ms. Gavin, I just want to remind you, you do remain under oath.
Thank you. Now, Ms. Gavin, if you heard that a March 11th, 2024 psychological evaluation of the mother, Carla Collier, was done during this case, and that the diagnostic impression regarding parenting was that there is no direct evidence she will become physically abusive in a parenting situation. She is, although unlikely to admit problems and difficulties if she views it as affecting her ability to get her child back. Her history reveals a vulnerability to negative relationships and impulsive decision-making patterns. Despite this, she is willing to engage in services and wants to be a good parent. Would that change your opinion as to any possible harm that might come to this child if returns to her mother, Carla Collier?
That would change my opinion if she participated.
Okay, and what I read to you there, does that also, not regarding participating, that's not the same question, but what I read you about her basically likelihood of causing physical harm, correct? If you were to read the trauma investigation about the child, Utica Calyer, that was done on, I believe, January 9th of 2024 for this case, and that the child showed a strength in the attachment/relationships area of her development that says this is the result of the child's strong, healthy relationships. A baby learns to feel good about himself and trust people by the way he is taken care of. This strength is also the key to how the child feels about himself. It opens him up to try new things and look to others for friendship or help. Scores in the strength range indicate that a child is showing many positive behaviors in this area, and we should continue to encourage these behaviors.
What was your question?
My question is, does that, when that happened before the child was removed from Ms. Collier, I'm trying to find the basis, the causal basis of your statement that it is, you have concerns that the child would be likely to receive physical or emotional harm if returned to her mother. So why are you saying that?
Probably because I only read the report of non-participation.
Okay, so you read a report of non-participation of the mom, is that what you're saying?
Yes.
And you haven't, we've already asked you that, you haven't read those. Do you know how old Uta, the child, is?
I believe she's about 4.
She is 6 years old, 7 in November. Would that change your opinion?
No, I don't believe in what age she is.
Okay. How many other children are in the foster family that she is living with currently?
I don't know.
If there are 3 other children in that foster family outside of Uta, and her mother does not have any other children living with her, does that change your opinion in terms of what's best for the child?
No.
Can you define what active efforts are under the ICWA law? Do you know what those are?
Reuniting parents with their children, if that's not possible, reuniting with family.
Are you aware that Carla Collier, living in Anchorage, Alaska, has access to the Native Hospital there that has a program for pediatrics that Utica could be seen at if she lived there with her mother?
Yes, I'm aware.
Okay. Does that change your opinion about her being better in place of the foster care family that you don't know where they live versus where mother lives?
I don't know how to answer that.
You testified earlier that you thought the child had been removed from her mother for a couple of years. I thought you said maybe 2 years. Do you know if that's accurate?
I don't have the file in front of me.
Okay.
And all the reports that you are reading from may be missing from the file that I read. So
you don't know if those even exist in your file?
I haven't really gone through all the files that the previous ICWA coordinator had. So he might have misfiled them.
The removal of the child, if it happened in around March 21st of 2025, how long would that mean that the child, if she's not been reunited, how long would that mean the child has been outside of her mother's care?
Your Honor, I'm gonna just object, that's factually inaccurate as well.
Okay, I'm sorry, it's the petition, I'm sorry, I'm getting it mixed up. All right, never mind, I'm sorry, I withdraw that question, my timeline brain got, pardon me. She's been removed since September 23, is that right? She's been removed since September 1st of 2023. And you have been saying that what's important to you is mom's participation, correct?
Yes.
With the child? And that if the mother was not allowed to participate directly with the child, then that changes your feeling about mom's ability to parent of the best interest of the child for your testimony. Right?
My opinion is based on what I read.
What conditions currently in Carla Collier's home cause you to have concerns for the child's physical safety or well-being, emotional well-being?
Having a stable home.
Okay, and you defined a stable home earlier in your culture as within 6 months or so of being in the same general place, is that right?
That was my opinion.
Okay, so if she's been in the same home and hasn't had any issues with that for 6 months, would you say that that no longer exists?
Having a report of the condition of the home would help.
Right, but if she lived in an apartment on her own, not with other people, and she lived there for that amount of time, that would be in her favor, correct?
Yes.
Okay, anything other than the stability of her home that causes you your concern in your opinion, because it has to be linked to a specific condition. So is there anything else that causes you to form your opinion about the child being likely to receive physical or emotional harm if returned to the mother?
Only on the medical side.
Can you clarify more for me what you specifically are saying? What on the medical side? What condition still exists regarding the mother?
I don't know what conditions still exist, but from the report that I read earlier, in the beginning, she had a disorder that needed medical treatment, and that medical treatment wasn't provided.
Do you know when that alleged to have
I
happened?
can't tell you the date because I don't have the file in front of me.
Do you know what state that's alleged to have happened in?
In the beginning, when she was removed from her mother.
In this case?
Yes.
Do you know if there have been any other issues with medication?
I haven't seen any reports on that.
In your culture, in your tribe, you said that everybody takes care of each other, correct?
Yes.
So if you had a parent, hypothetically, who did not have stable housing but had a child, what would you do to try to fix that in your culture?
In our
What's an
community,
appropriate
we have,
response?
in our community, we have family close by.
So in your
And
opinion, is it best for the child to be nearer to the family that she lived with while that issue is being worked on?
if she has family close by, that's what my opinion would be.
And in your community, have you ever come across parents who have their own trauma from past issues, such as sexual abuse, drug abuse, anything? For example, that they have their own trauma issue, which may, in some respects, affect their parenting at times. Have you ever seen that before?
I'm new to this position.
Okay.
And
As a member of the tribe, have you ever seen that situation happen before?
with trauma,
With a parent having their own trauma that may cause them some problems while they also have a child in their care?
I would say no. I haven't
You've
seen
never
that.
seen that? Okay, so you're not qualified, you don't know how the tribe handles that?
No.
Are you aware that Carla Collier doesn't have any reported issues of alcohol or substance abuse?
I'm not aware.
Okay, so you didn't know that?
No.
Just one moment, Judge. Just a few more questions. In your culture, if a parent has their own medical issue, for example, they need surgery or something, okay, and it affects their ability to participate in a lot of different activities for a number of months, is that something in your tribe you've ever seen as a parent have?
If that were to happen, family usually steps in to help out.
Okay, and if there wasn't family to step in to help out, what would be the next reasonable reaction from the tribe?
I don't know.
Don't have anything further, Judge. Mr. Howard, questions?
No, Your Honor.
Redirect or any other questions? I should just say, Ms. Stotts. One moment here. Sorry. No, Your Honor, no further questions. Okay, thank you for your time and your testimony, Ms. Gavin. Did you have anybody else you wished us to hear from by way of rebuttal witnesses or anything else, Ms. Thomas?
Not this time, Your Honor.
Ms. Sedor? Mr. Howard?
No, Your Honor.
Comments in closing, beginning with Ms. Thomas?
Your Honor, I would actually request the court to accept closing by written statement, given the nature of the case with all of the equal requirements. I believe that I'm happy to do it verbally. I just feel that it would be better suited for the record if we were able to set closing in writing.
Ms. Fedora, would you prefer to give us your closing orally today or by in writing?
I have no objection to in writing, that's fine. It's a long couple of days of testimony.
Mr. Howitt?
Your Honor, I'd be in favor of submitting in writing as well.
Very well. How long would you like in order to complete that assignment, Ms. Thomas?
And I think it'd be reasonable to request our arguments be filed within 7 days. I can do that.
Mr. Howitt?
I would just ask by the end of next week, so this.
Well, let's round it off and say by August 31st. I'm sorry, file it as soon as September 1st. So that's on Monday. So closings, I would like them by September 1st.
And then, Your Honor, would you then rule via writing, or would you have us back in court? I don't know if there's another review date we have to set or what.
I suppose some of that will depend on what I receive in closings. So what I would be inclined to do is I'm going to set another review just to keep the case on track, regardless of what happens moving forward. So that we're able to make sure that the case stays active. I'm looking at Monday, November 17th at 1:30 p.m. I think there's a time change for you, Ms. Gavin, but that would be 1:30 our time. All right. All prior orders will remain in full force and effect pending the reception of those results. You would also be inclined to issue a review order based on the information that I've received today. Any objections to that?
No, Your Honor.
No, Your Honor.
All right, very well. So the court will take the information I have here under advisement. I'll cut a review order, permanency planning order, and have that to you relatively quickly. And that will also document our next review and permanency planning hearing November 17th at 1:30 p.m. Unless there's any questions, that's all for today.
Just one more request on behalf of Carla Collier. Would she be able to have telephone contact with her daughter at all?
Ms. Thomas? There was a suspension of parenting time issued at or around the time the petition for termination of parental rights was filed. Generally speaking, I would be inclined to extend that unless you have any opinion that would be different than that. Mr. Howard?
No, Your Honor, I would wait until the conclusion of the trial before the changes made.
Ms. Thomas, any other comments?
Your Honor, I wanted to ensure that the child was still in therapy should the court rule otherwise. But at this time, this court had ordered the department to file that termination petition based on mom's lack of engagement and lack of progress. We've also alleged that she's abandoned the child. I think that adding any contact would further confuse the child and cause some emotional and psychological harm. However, if the court is going to allow that contact, we would just ask it be dependent on the child's therapist recommendations.
Just to briefly review the file on those points, the court received the file back from Judge Costello at the end of 2024, at which time parenting time was essentially at the discretion of the department. At the first hearing in January of 2025, Ms. Calyer did not appear. There had been no progress made on services. She had not had contact with the child, and the department was ordered to commence the petition to terminate parental rights. And as a result of that, actually, in January, she did have supervised contact allowed by court order. And the petition was filed March 21st, 2025. Utica Collier was unable to be located. We were even looking at an order for alternative services at that point, continuing the absence from services, contact with the department, as well as from the child's life. We had, of course, the appearance of Ms. Sador, Carla Collier back again in April. So based on the history of the disappearance of the parent, disengagement with the department, and the pending termination petition, as well as the historical and current challenges and behaviors that the child is experiencing, I can't find that it would serve her best interests to allow parenting time despite the directives generally to suspend pending resolution on a petition for termination for all rights. Also, the extensive absence from Ms. Calyer from her child's life, which is another reason the court has to consider, and the mental health of the child. It would not be in her interest to challenge that, given the challenges that she's already undertaking. So for those reasons, I'm going to deny the request to re-engage with parenting time. Any other questions? No, thank you. All right, thank you everyone for coming. We'll look forward to those comments, and I'll see you all in November. First on a termination request, took those as well as issued an order asking the attorneys to do their closing arguments and received those. But we've had a bit of a time frame between that last review hearing and today. So I went ahead and allowed for production of a court report and updates just in case anything had changed from the last time we were here. And I would like to ask the parties to simply consider today an additional extension on those issues, review, permanency planning, and termination as we review what's happened in the last report period. And I will certainly be giving you a decision today on the request for termination. I have the names of our participants, please. And Ms. Collier, if you could take your hat off, please. We can't allow hats in the courtroom, and this is a courtroom even if it's virtual. Thank you. Go ahead.
Carson Howard, lawyer regarding that litem.
Ms. Sasha Thomas, counsel for the department. Ms. Beach.
Ashley Beach, I'm the foster care worker from Fostering Solutions.
Betsy Geyer-Sador on behalf of Carla Collier.
I'm Carla Collier, Uta's mother.
Thank you. Do we have a representative from the tribe, native village of Buckland here this afternoon? Okay. Do we know if, do you want to cover that in your testimony today, Ms. Beach, as far as efforts to reach out to them, or what do you think?
I can.
Okay.
I can do that or give an update now, whatever you prefer.
All right. Ms. Thomas, do you have a preference or any direction for us on that?
Your Honor, just because of the ICWA implications, I would prefer if Ms. Beach could just give us an update as to the efforts she's made to ensure their attendance today.
All right, yeah, I think that's great. Dr. Nias, if you could swear her in, you can just stay where you are for now.
Okay.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead. Or Ms. Beach, if you want to tell us about what's been happening with the tribe, if you know.
Yeah. So I have emailed the tribal representative a few times, well, more than that, probably 5 or 6 times since the last hearing. I've gotten some responses, but I did send emails on October 7th, October 10th, with no response. And then I sent the court report on November 10th, and then a reminder email on Friday about the hearing today with the Zoom ID. And then I also emailed about an hour and a half ago to the representative and the tribal admin email address with the time, date, and Zoom ID, and I have not heard any responses.
Is that Ms. Gavin that you're talking about specifically? Frederica Gavin, I think, was the last one that was here.
Yes.
Okay, thank you for clarifying. Any questions, Ms. Thomas?
No, Your Honor.
Ms. Sador?
No.
Mr. Howard?
No, Your Honor.
Very well. All right, let's get into the review then. Mr. Howard, whenever you're ready.
Yes, Your Honor. It's been I would say, a very tumultuous reporting period for the minor child. She really, in the beginning of October, was experiencing some pretty severe behaviors. They were aggressive and towards the family and teachers. It was mostly in the form of like temper tantrums, but I mean, that's kind of limited way of explaining it, as it's much more severe than that. They got so bad that they had to take the child to the ER to just search for some sort of answers to get some sort of help for the child. But she was discharged. They put her on a medication that didn't really work out. But over the last few weeks, and I met with the child on last Monday, the 10th, we had some really positive updates on the current medication she's on. And they, you know, from talking with everybody, they seem to feel like they're getting her at like her baseline and starting out there. And we're hopeful that, you know, they can continue on this medication and continue with some different service providers. They're in the process of getting her a new, you know, specialized trauma-based therapist, as well as she was diagnosed with autism, and getting her into some ABA therapies to really just continue to work on herself and stabilizing her. When I met with her, she was with her foster sibling, her older foster sibling, and this foster family has a lot going on. And they are kind of very, you know, nice that they're able to prioritize and make time for all of their children in their home. And I think they have 4 kids who are all 7 years old right now. So as you can imagine, and they're all involved in different extracurriculars. And this minor child specifically is started playing ice hockey this reporting period. So I think that's just a really good outlet for her to kind of, you know, get into something else and deal with some of her aggression and behaviors that way. She claimed that figure skating was too boring for her. So, but, you know, it's, like I said, a very up and down reporting period, but the most recent update is that it's very positive, and this foster placement is doing a really good job of taking care of this child and prioritizing her as if she was, you know, one of their own. So I'm really happy to see that. And it was really nice to see her on last week and get to see those positive updates. Thank you.
Thank you. Testimony today from anyone, Ms. Thomas?
Thank you, Your Honor. I'll ask Ms. Beach to be sworn in to just briefly provide her report. Thank you.
Ms. Beach, come on out to our witness stand. Remain under oath. Ms. Thomas, whenever you're ready.
Thank you, Your Honor. Ms. Beach, you've provided a court report for today's hearing. It has several attachments, but I just want to double check to make sure there are no updates or modifications that need to be made to the report or any of the attachments.
Not at this time.
Okay, and I know it's kind of been a different type of reporting period because we have already made arguments as relates to the termination request. But during this reporting period, can you just briefly summarize your communication efforts with Ms. Collier and ensuring that you're continuing to comply with the active efforts requirement of this case?
Yes, so I have tried really hard to maintain weekly or every other week contact with Ms. Collier and her attorney via email due to Ms. Collier living in Alaska. The distance to have any in-person contact is obviously a barrier. I've included our email threads as an exhibit to the court report, just showing that I'm continuing to make efforts to engage and get signatures on required documents and such. We did have a family team meeting that occurred virtually on September 19th, where we were able to discuss the services Ms. Collier was participating in, and she showed me her house virtually. So that was able to occur. And then I continued to maintain contact with the tribe, or attempt to, and make sure that they're staying up to date on the child's needs and any concerning behaviors or changes in her behavior or care that I think they need to be made aware of. And then I've also invited the tribe, and Ms. Calyer has been invited to participate in meetings with the school to discuss the child's behaviors and educational needs. So those are things that have happened this reporting period.
Thank you for that update. And has there been any significant change of circumstances as relates to Miss Collier or the child that the court should be aware of that might make the agency or the court reconsider the request for the permanency goal to be adoption at this time?
I don't believe so.
I know that in the report, there was some indication from Ms. Collier's, I'm not clear if it's her therapist or a service provider liaison individual regarding her physical health and that being addressed more recently. Have you been able to get any of those medical records at this time?
I have not.
Okay. And has there been any change to the stability of the child's placement?
No, the placement remains committed to the child and has shown that they are able to meet any needs that arise.
Okay. And I know that in the report, Ms. Bloom has also indicated several times if, adoption is in fact what is going to happen for the child, that she would like to be considered. Is there any movement on an ICPC request at this time, or have you been waiting for the court's opinion?
We've been waiting for the court's opinion just because there is an extra box that needs to be checked for adoption when making that referral for ICPC. We did previously make an ICPC referral for placement for that relative, which was denied because she said she was no longer able to accept the child. So we'll make another one and check both placement and adoption boxes if she becomes available for adoption.
I don't have any further questions related to your court report, but if there's any information that you'd like to highlight from it or your knowledge of the case, please go ahead and do so at this time.
Just that I have maintained contact with Rebecca Sullivan through Love Alaska this reporting period. She's a case manager for Ms. Collier, but I haven't been able to get in contact with her individual therapist because I don't have a release signed. And then I also haven't gotten any medical records this reporting period to be able to see what Ms. Collier has been experiencing medically. But other than that, I don't feel like I have anything else that needs to be highlighted verbally.
Thank you. And then just briefly, as relates to the child's well-being, I know that we've heard from Mr. Howitt on a few of the issues that she's been experiencing this review period, but is there anything else that you would like the court to know about how the child's doing?
Just that since I submitted the court report, she is doing better. It's been kind of up and down in general this reporting period, but she is meeting with a new psychiatrist, and CMH felt that she had maximized therapeutic benefit. So foster parents have located a different therapist that she's on the wait list for. And since her current medication regimen seems to be working for her, so she does appear to be stabilizing, which is good news. And the school has been working, they developed a formal behavior management plan that's been implemented, and we meet as a team once per month to discuss how she's doing in school and any concerns and how to address them. So everyone is being very proactive and meeting her needs and making sure that we can help her stabilize.
Thank you so much. I have no further questions of Ms. Beach, Your Honor, and would ask the court to accept the court report at this time.
Any objections?
No, Your Honor.
No.
Thank you. They are received. Questions for this witness, Ms. Sador?
Just briefly, you were in contact with Ms. Calyer regarding her health, her own reported health update, though, correct?
Correct.
Okay, and that she had surgery and was recovering?
Yes.
Okay, and that you also received a box she had sent for the child for her birthday?
Yes, I just received that on Friday.
Okay, all right. I think that's it. Thank you.
Questions, Mr. Howitt?
Yes, has Ms. Collier or her attorney reached out to you for an update, or do you typically give them updates?
I typically give them updates in an effort to maintain regular contact with them.
Nothing further.
Any redirect?
No, Your Honor, thank you.
Any other witnesses?
No, Your Honor.
Thank you for your testimony. We return to you. Ms. Dorr, anyone you'd like us to hear from today?
I'd just like to briefly call my client.
Deputy Ames, would you swear in Ms. Carla Collier, please?
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
She's got to unmute. There you go.
I apologize. Yes, sir.
Thank you.
All right. Hi, Carla. Just want to update the court since there wasn't a release signed in time to get medical records or anything. Can you please tell the court what your current health status is?
Currently I am almost fully recovered after having a hysterectomy. Not something they do often for someone my age, but it went well, and I am working through cleaning different people's homes and the churches, something that I couldn't really do very well before. So yeah, I had a hysterectomy, and they were able to correct internal damage caused by my abuser.
Okay. And then in terms of working, has your doctor limited your ability to do regular work while you're recovering?
I am able to do basic stuff. I still can't lift anything heavier than 10 pounds or whatnot, but within the next 2 to 3 weeks, I should be cleared to work fully.
Okay. And you sent a box for Uta's birthday, is that correct?
I did.
And what was in the box?
In the box was, because her thing is, you know, we love moose. That's a part of our family thing. A moose purse so she can hold things as she goes and plays. A book that we used to read together. I can't remember exactly the name of it. Stellella, I think, or something. Stella Luna, I believe it is. And an outfit that I thought she would enjoy having, you know, because we enjoyed clothes shopping. And just a bracelet with a moose on it that says how strong she is and how much she's loved by everybody, not just me, but those who are caring for her now. Yeah.
Did it have a quilt as well, or no? Are you still working on that?
I'm working on the quilt.
Okay.
I'm
in
taking.
I'm sorry, in terms of the meetings that Ms. Beach had testified about, the one with the school, were you able to attend that meeting virtually?
I was never sent a link, and I can send you proof of that after, you know, whenever is convenient if needed.
Okay, so you didn't attend that one, but you wanted to, is what I'm
I
asking.
very much wanted to. I'm very grateful. The school has done a wonderful job in helping her.
Okay. All right, thank you, that's all.
Any questions, Ms. Thomas?
No, Your Honor, thank you.
Mr. Howitt?
No, Your Honor.
Any other witnesses, Ms. Sador?
No, sorry, thanks.
Mr. Howard, anyone you'd like us to hear from?
No, Your Honor.
Very well. Comments in closing, beginning with Ms. Thomas?
Your Honor, we are just requesting or renewing our request for the relief put in our petition. I think at this time, the child has waited a significant amount of time to achieve permanency and finality. And I'm grateful for Ms. Collier taking the opportunity to give the child what sounds like a really meaningful gift basket for her birthday. And that mom's able to address her own physical health needs at this time. However, given the length of the time that this case has been open, the active efforts that were employed, I don't believe that there's a significant change of circumstances in which we could, in good faith, ask the court to withdraw our request for termination to allow the child to be adopted. And so we are just asking the court to issue its ruling so that this child can move forward. Thank you.
Mr. Howard. Oh, I'm sorry. Let's go to Ms. Sador first in case there's anything you want to respond to. Ms. Sador.
We would still rely on our closing statements that were written that we submitted after the trial. We are awaiting a ruling. And again, we would ask that you deny the termination petition. Thank you.
For purposes of the review and permanency planning hearing, the court finds all interested parties are given notice for purposes of today's hearing. The hearing is consolidated and continued termination consideration request as well. The child continues to be in the safest and least restrictive placement with the necessary and appropriate goal of adoption in this case. She continues to struggle mightily with some of the diagnoses that she suffers, some potentially identified as genetic at this point, but many more that have been documented by different service providers and analysts, including through trauma assessments, psychological evaluations, IEP evaluations, and just regular interaction with her, as certainly being outgrowth of the trauma that she suffered before being removed from the care of her mother September 1st, 2023, just before the age of 4. So the lack of progress on the case services plan continues to be persistent. The active efforts of our agency are certainly above and beyond even, I think, what has been considered in many other cases. And so I do want to take a moment to recognize those efforts. A good example that Ms. Beach highlighted in her testimony is that weekly or bi-weekly reach out. Typically, last time I checked, at least the foster care manual indicates once a month reaching out. Certainly not weekly or bi-weekly, certainly not emailing updates and invitations at the frequency that the department has done so. And especially in this case where we had a significant period of complete disengagement, I just want to say that I really think that the professionalism of this agency has really been highlighted in this case by their willingness to re-engage. Francesca Madrid and some of the other caseworkers, I'm sure as well, suffered through a lot of accusations and very difficult parenting time sessions. And I'll go as far as to say punishing and humiliating episodes in attempts to try to move this case along and fulfill their obligations to provide active efforts in this case. And they certainly have done that, and the child has benefited from that at least, but there has been no significant benefit that would allow me to find that the risk of harm associated with returning this child to the parent has been alleviated. And I'll articulate more of that in the written opinion that I have before me today, but that I will read onto the record so that you all won't have to wait for this to come to you by email or by mail, and you'll have a thorough decision on that point. So I'll go ahead and get into that now. The court's been asked to consider termination of parental rights pursuant to MCL 712A.19b, subsection 3A(ii), CI, and subsection J. In short, the first section considers abandonment. The second considers progress on case services. And the third considers the risk of harm, which is similar to what the court has already and has articulated on at each review hearing. The case concerns Carla Collier and her daughter born November 9th, 2018. The Illinois County Probate Court received and granted a petition for emergency removal and jurisdiction from the Department of Health and Human Services on September 1st, 2023. The child was 4 years old. Actually, I think she was 3. She turned 4 shortly after that in November. The preliminary hearing was conducted over several dates, September 1st, September 25th, and October 4th, 2023. The caseworker testified. The case was immediately recognized for ICWA MIFPA considerations, and the native village of Buckland, Alaska was asked to join. The QEW for the tribe agreed that removal was appropriate, of paramount importance for the following issues. And I just want to pause for a moment here and say, I understand the tribe's not with us today. But there was extensive cross-examination of the QEW, the same qualified person. I'll note, Ms. Gavin was the QEW at the outset of this case and also was present at the last hearing. And there haven't been significant changes in those circumstances that would require me to require the tribe to reappear to articulate the same findings, because nothing's really changed. So I'm moving forward even without the tribe today because of those reasons. And I think the comments by the tribal representative last time that are considered later on in this opinion also support that, which is, in her opinion, 6 months would have been sufficient rather than the nearly 25-month mark that we are at now. So back to the findings. Of importance were the following issues. 1, transience and homelessness. The September 1st, 2023 petition indicated that Carla Collier had lived in 10 states in 2 years, had gone from shelter to shelter, and was even attempting to turn her child over to a person in Canada whose identity was unable to be confirmed. After the filing of the petition, this pattern continued. At the September 1st, 2023 preliminary hearing, Carla Collier was found in Adrian at a hotel funded by the MDHHS on a temporary basis, since she had been asked to leave the local domestic violence shelter. At the continued preliminary hearing on September 25th, 2023, she appeared from a campground in Kentucky. At the second continuation of prelim on October 4th, 2023, she was somewhere in Seattle, Washington. At the time she entered her no contest plea, she was still somewhere in the state of Washington. There was no city or address specifically offered at that time, and that was November 3rd of 2023. Paragraph 2, child abuse concerns. Both while she was at Catherine Cobb Shelter in Adrian, Michigan, as well as when the child was removed in the state of Washington, there were concerns for physical discipline that was abusive, including things like food deprivation in response to trauma behaviors, inappropriate discipline for trauma-related behaviors, and mental health issues, including potential sexual abuse at a very young age, when she, quote, left the child with her ex-partner at his residence in Alaska for 2 weeks, with 16 other individuals coming in and out of the house who were alleged to have sexually abused her while Carla was staying at a local hospital. And that was an excerpt from the petition, which was drawn from the records in Washington. 3, child neglect concerns. Records reflected removal for 6 months in Washington state for these and other concerns, including failure to ensure seizure medications for her child. 4, improper parenting. When mother and child arrived in Adrian, she was reported for concerning parenting while staying at the local Catherine Cobb domestic violence shelter. MDHHS attempts to prevent removal included programming called Families First, as well as support from the staff at the Catherine Cobb domestic violence shelter in Adrian, Michigan. Despite these efforts, she was asked to leave, having refused to cooperate with the rules of the shelter, refused to change any dangerous parenting patterns, and even referring to another resident's Black child as an animal at the end of her stay. On November 3rd, 2023, Respondent Carla Calyer asked to enter a no contest plea, asking the court to take judicial notice of the testimony offered by the department at the preliminary hearings and effectively admitting the facts outlined in the petition. At that hearing, the tribe did not appear, despite notice, so the court took the plea under advisement. Even at this early juncture, however, parenting time had to be reviewed and reduced due to behaviors triggered during and by mother's virtual visits. Observations of the child included, quote, she repeatedly yells she wants to end the call. She gives looks to the workers when we try to fix the phone for her to be able to see mom. She will purposefully not answer, and then just immediately after the visit, I struggle to redirect her and get her to settle down again. And then there are the reported behaviors from the foster parents in the home, end quote. The child at age 4, at this point, expressed self-harming behaviors and struggled with even seeing her mother on the screen without a negative reaction, both visibly and audibly. She would repeatedly slam her head against a wall, tantrum, refusing to allow anyone to help her. Compounding frustration from caregivers and the child, mother simply ignored her child's feelings expressed during these visits. The foster care caseworker was already acting quickly on referrals for the child. Trauma assessment was scheduled for 11/28 of 23. The child was already being seen by Mia Hamden of Lenawee Community Mental Health Authority for play therapy and scheduled EMDR. But this professional did not want to weigh in on parenting time. The court confirmed the worker should find another professional to weigh in to assist in addressing future parenting structure. But to preserve the child's mental health and physical, the court reduced contact between mother and child. On November 17th, 2023, a disposition order entered with a case service plan for Carla Collier aimed at reunification. Carla Collier had returned to Adrian and was staying in a homeless shelter. She continued struggling with transportation, housing, employment, and had not engaged in voluntary services as of yet. The child remained eligible for enrollment in the village of Buckland with her father's family out of Buckland, Alaska, and efforts to complete registration were underway, as well as out-of-state relative placement inquiries. Mother was asked to undertake psychological evaluation to help discern and overcome the reasons for her failure to benefit from prior services in parenting education and to help stabilize her own life. She was asked to establish a safe and stable environment for herself and her child, including housing, employment, parenting, education, and other services. Regular quarterly reviews were conducted until the supplemental petition for termination of parental rights was filed on March 21st, 2025. Initially, Carla Collier was engaged in making efforts to undertake difficult therapeutic work to reunify with her daughter. At the first regular review hearing in February of 2024, she was still in Adrian, living with a friend, working at Chipotle, and seemed to be safe during parenting time and bonded with the child. She was engaged in CMH therapy, including EMDR, trauma-informed parenting classes, and participating in Utica's trauma assessment. She even completed her own psychological evaluation February 5th of 2024. There were still significant concerning incidents, however, including threatening to kill Cameron Kuzik, the Child Protection Services investigator, and another CMH caseworker. She was also insisting she wanted the child raised Norse pagan and wanted her child singled out against Christian prayers and chapels at school. The tribe was also, unfortunately, continuing to be absent for reviews, but it was clear that foster care caseworker was using active efforts in engaging mother, providing transportation, ensuring frequent and regular interaction with mother, hands-on assistance in applying for housing, employment, and other referrals. Meanwhile, the child's story continued to unfold, only to demonstrate increasing special needs and complicated trauma-based behaviors. She was reportedly doing well in her placement, despite a PTSD diagnosis from the trauma assessment initial analysis. She continued to frequently demonstrate aggression towards others, becoming easily overwhelmed and needed regular use of isolated safe spaces. Supported in visitation using family therapy, including a referral for attachment therapy with mother. She was engaged in occupational therapy for sensory processing work and work on fine motor skills for delays, for developmental delays. At the second review, May 16th, 2024, mother remained living with a quote support person. Yes, quote, we weren't sure how many people were living there or who was living there. She was still employed part-time at the local Adrian Chipotle, exercising limited supervised parenting time. There were uncommon concerns about a quote support person quote for mother who had to be delivered a cease and desist letter from the department, and I think it was actually the agency, for hundreds of accusatory text messages, complaints, and harassment. This person, unsurprisingly, was prohibited from being around the child. It was further noted that this appeared to be an extension of a pattern already noted by the prior caseworker in the Washington State case interventions, specifically the observation that mother tended to, quote, make quick connections with support people who may not be appropriate for her child to be around, end quote. Of additional note, mother had voluntarily terminated services through Laramie County Mental Health Authority, citing her dissatisfaction with the, quote, professionalism, quote, of her caseworker. Her psychological evaluation revealed significant trauma in mother's past, which appeared to continue to interfere with her overcoming the barriers to reunification. A psychiatric evaluation from Adrian Counseling and Psychiatric noted, quote, she has the following diagnoses: major depressive disorder, recurrent, moderate, generalized anxiety disorder, attention deficit hyperactivity disorder, combined type, and post-traumatic stress disorder, chronic, end quote. Several medications were indicated. It was clear she needed to continue and even double down her efforts. Despite her child removed from her care September 1st, 2023, by May 16th, 2024, she still had no independent housing, no income sufficient to support herself without an arguably dangerous support person, and no regular or sustained individual therapy progress. She had no transportation, and a strange and continuing pattern of involvement with people who compromised her progress with caseworkers, therapists, and referral service providers. She also seemed to be fixated on ensuring the child was safeguarded against understanding or practicing Christianity, effectively undermining the placement's efforts to provide private Christian school education for the child and participation in foster family activities like church on Sunday mornings. There were concerns about her referring to someone her child never met as daddy during parenting time, and use of some language she claimed only her and her daughter knew. Mother had demonstrated stability in only one area in this extended review period, maintaining part-time employment at Chipotle. Her efforts to undermine the stability of her child's placement with special requests to change school, daycare, and avoid church were not enough to distract the court from recognition of her lack of progress during the report period, and the child remained in foster care. The trauma assessment indicated, quote, an insecure, ambivalent attachment style, quote, between Carla and her child, which did seem to reflect the very real pattern for Carla of being radically present in some ways and radically unreliable in others. Relative placement investigations through ICPC were denied for non-participation by potential placements. The tribe did not appear. At this review, a deluge of information about the child was available and reviewed. The child's trauma assessment indicated indications for neglectful home environment, emotional abuse, exposure to domestic violence, impaired parenting due to mental illness, prenatal exposure to alcohol or drugs, and or maternal stress during pregnancy, lengthy or multiple separations from a parent, placement outside of a home, and frequent multiple moves and homelessness. A bonding assessment for mother and child indicated that based on the observed interactions between them, they were determined to have an insecure, ambivalent attachment. The assessment indicated PTSD in a child under 6 with a possible overlap in symptoms indicating autism, which has not been confirmed. There were developmental delays, indications of sexual trauma, memory and emotional control difficulties, significant needs. It is clear any caretaker would have to have elevated skills, tools, and flexibility to address the symptoms identified. Carla was referred to Brene Moore for therapeutic parenting time with her daughter to work on attachment and bonding therapy, among many other referrals from the psychological assessment. As of the hearing, she had not made any contact with Ms. Moore. August 15, 2024 marked the third review for Carla Collier, 7 months after Utah's removal. Carla remained living with a support person who passed clearance. However, someone new had moved in shortly before the review who still needed to pass clearance. She was no longer working at Chipotle, claiming to be part-time in a new job. She was attending individual counseling, but the counselor reported she was still working on Carla's defensiveness and understanding why her child was removed from her care. Carla still had not reached out to Brene Moore for attachment therapy with her daughter, despite repeated reminders from the caseworker. Her previous request for email delivery of information only was now a problem in communication. She also claimed a traumatic brain injury and a hospitalization in the last report period. She also continued to try to interfere with her child's foster home practices, asking to change to public school, despite her child's clear need for stability. She also indicated on the record that she had not even read the court report. Issues with mother's housing, employment, sustained mental health treatment, and parenting education remained significant barriers, and the child remained in foster care following the hearing. The child went her first full report period without a seizure. She was in 2 kinds of therapy pursuant to the trauma assessment recommendation. Once for individual therapy, twice weekly in-home. She underwent a psychiatric evaluation, including several diagnoses, such as ADHD, PTSD, and disinhibited attachment disorder, and was prescribed medication for the ADHD symptoms. She was using ankle braces to assist in walking and stability and attending OT-PT therapy as well. That's no less than 4 appointments weekly, not including T-ball, dance, or tutoring to get her ready for kindergarten. November 12th, 2024 marked the 4th review hearing for Carla and 10 months of foster care for her child. Carla Calyer was, quote, couch surfing after being kicked out of her support person's apartment and had no verifiable employment. She appeared to be decompensating in her mental health, demonstrated by accusing caseworkers of stealing her belongings, being threatening and aggressive to her. She missed appointments for the child. At one point, the caseworker had to take an emergency call to consent for services for the child to get necessary medications. She was dropped from the supportive visitation program for lack of participation. She had attended the intake appointment with Brene Moore for attachment therapy, and I'll note here that the caseworker drove her to that appointment. But when she got there, she stated she did not know why she was there and never followed through. That was from the report period. Most painfully, she stopped visiting with her child abruptly as of October 21st, 2024, claiming, quote, that if she didn't get a new caseworker, she wasn't going to be working with the agency or visiting with her child, end quote. The court report contained many other examples of Carla's intentional negative commentary, and even one episode of complete emotional dysregulation and screaming at caseworkers. The caseworker had to ask for her visits to be suspended due to the effect these behaviors and missed visits were having on the child's mental health. The child made gains during that report period, transitioning into kindergarten well. She had reduced reliance on her ankle braces and only had 1 non-emergency seizure that report period. She still attended weekly PT, OT, and individual therapy with psychiatric supports and had her educational IEP in place as well. The agency was asking for a goal change to adoption, which was not addressed on the record that day. The order reflected continued placement in foster care appropriately due to lack of housing, financial support, and other circumstances reviewed by the court constituting substantial risk of harm in returning the child to Carla. The January 27, 2025 review and permanency planning hearing was the 6th review for Carla. Unfortunately, she appeared to be in the downward trend of stability. With unknown housing, no employment, and a complete disengagement from services, and no contact with the department or her daughter after some very vitriolic text messages sent November 14th and November 30th, 2024. The goal was changed to adoption for the child. She was 6 years old and had been living with her foster family for 16 consecutive months. She appeared to be still gaining progress due to the stability and service supports in place. She had only a singular seizure, was still participating in OT, PT, psychiatric care, and therapies through CMH. She missed her mother and openly spoke about it at school. The school continued to support her as well with IEP reviews and accommodations for behaviors when she struggled. The department was ordered to file a termination petition at that review. The petition was filed March 21st, 2025. By the time the supplemental petition was filed, in addition to the issues identified at adjudication, the child's father had released his parental rights and her mother had effectively abandoned her. Following the filing of the petition for termination, respondent parent Carla Collier resurfaced from a church in Alaska that had allowed her to reside in an apartment on the grounds, provided her retained legal representation and even transportation from Alaska for hearings. She reemerged on the back of this new support system for the remainder of these hearings, starting with the April 21st, 2025 hearing. Carla Calyer reappeared in person with a retained attorney from this new set of, okay, that's good. She came in person for at least one of the hearings. The April 21st hearing was also the one scheduled for the termination petition to be heard. Her attorney requested to adjourn, and the court granted that request to allow the attorney to review the file and try to assist Carla in preparing for that termination trial. The 7th review and permanency planning hearing, combined with the hearing on the March 21st, 2025 petition for termination of parental rights filed against Carla Calyer, recommenced on May 30th, 2025. At that hearing, Carla Collier's complete absence from her daughter's life and services was documented from October 21st, 2024 through to the appearance and request for adjournment on April 21st, 2025. She produced a letter from Love, Alaska with a case management plan that documented she was due to engage in therapy, but had not yet done so. Her mental health did not appear to have improved. Strangely, she claimed she had vertigo, bleeding episodes, and even that walking was hard for her due to issues with the way my heart pumps blood through my body, quote, and that she had 2 older children, 8 and 12, whom she had not seen since they were infants. Carla continued to insist that her child was taken from her based on lies and that the caseworker was intimidating. She went on to include her first therapist, apparently from 2023 as well, in accusations of intimidation in her testimony. Her attorney had to redirect her more than once during her direct examination to get Carla to answer questions that she'd been asked. The child remained steady during this report period, still in her therapies and supported at school. The native village of Buckland was noticeably absent at the outset of that hearing, and without a QEW, the court continued the hearing as to the termination trial, but conducted the review. Carla was provided with another copy of the petition requesting termination for review and preparation. An 8th review and continued termination trial commenced July 14th, 2025, some 23 months after the child's removal from her mother, and still nothing had changed. At this point in the case, the main worry with completing the termination proceedings was ensuring that the department had met their obligations under ICWA and MIFPA. The tribal representative had changed for the village of Buckland several times. Joe Washington appeared, but was unwilling to express an opinion as to whether or not termination served the best interests of the tribe. Of the child. The department requested a continuation to explore if further input could be had from the tribe. Carla had been offered assistance in searching for services in her area in Alaska, but had declined. She also remained unengaged in any services voluntarily, even though the Love Alaska group that offered support for her, at least through had offered support for her, at least through individual counseling. The child seizure disorder remained well supported, as well as her special educational needs and her behaviors, but her behaviors and self-harm began to truly plague her during this report period. The foster family and the department were supporting for additional autism testing, including for genetic markers and abnormalities. She continued to ask for her mother, despite her mother's 6-month absence at this point. The 8th review recommenced August 20th, 2025, just 11 days shy of 24 months after removal. Native Village of Buckland Representative Frederica Gavin appeared and testified in the capacity of qualified expert witness. She confirmed she too supported termination of Carla Collier's parental rights. Of note, she was the original KiwiW testifying at removal and indicated she would have expected this parent to remedy the issues within 6 months of removal. A July 3rd, 2025 email update from Love, Alaska Representative Rebecca Sullivan indicated Carla was being tested for the same rare heart condition Ms. Sullivan suffered, called postural orthostatic tachycardia syndrome. She indicated this may be the reason Carla had yet to begin her counseling or make any progress in obtaining regular employment or transportation. The child was reported as doing well in placement. Remarkably, towards the end of this hearing, an unidentified person present by video with Carla Collier offered the camera her middle finger. Frankly, this was consistent with Carla's involvement with the Michigan courts and the agency, but still surprising. Due to the attorneys in the court engaged in conducting the hearing, the gesture initially went unnoticed. The court allowed the parties to submit written closing arguments and indicated a written opinion would be forthcoming, but scheduled the next review and continuation of the trial as well. This final review is held November 17th, 2025. Altogether, Carla Calyer was given over 25 months to rectify the conditions that brought her daughter into foster care. She remained without employment, wholly dependent on the goodwill of the church in Alaska for housing, and without any engagement in services in the last report period. The child still struggles mightily with the effects of her mother's parenting in the first few years of her life. Her seizure disorder is well maintained, but treatment for delays and trauma behaviors continues to be a winding maze for her and her foster family. Upward progress is significant for her and requires enormous support, analysis, and services from all the people in her life. Return to Carla Collier, who has made no progress and his sister daughter was taken from her based on lies, would most certainly put her in harm's way again. Very real physical, mental, and emotional danger. The court is asked to consider termination of parental rights pursuant to MCL 712A.19B3A2, 3CI, and 3J. The court may terminate a parent's parental rights to a child if the court finds by clear and convincing evidence that the child's parent has deserted the child for 91 or more days and has not sought custody of that child during that period. Carla Collier refused visitation and abandoned her child effectively October 21st, 2024, and truly remains gone. Engagement with the court resuming at the April 21st, 2025 hearing seemed to be at the insistence and facilitation of mysterious support people from Alaska. Even recognizing her re-engagement at court hearings in April of 25, the statutory 90-day period to measure abandonment was already met by the substantial 182-day timeframe she was completely disappeared. Re-engagement did not mean into services either, which left all risks associated with parenting time continuing to prevent her from even visiting with her daughter. So there is clear and convincing evidence of abandonment under 3AII. 3CI the court has asked if the parent is a respondent in a proceeding brought under this chapter, 182 or more days have elapsed since the issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds either of the following. The applicable subsection is I. The conditions that led to the adjudication continue to exist, and there is no reasonable likelihood that the conditions will be rectified within a reasonable time considering the child's age. Hand in hand is section 3J, which is whether or not there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if the child is returned to the home of the parent. Carla Calyer has been a respondent subject to case services planning, offered active efforts towards reunification for nearly the entire 25 months her daughter has been in care. She hasn't seen her daughter since October 21st, 2024, nor ever engaged in any real way with services to truly benefit herself. The pattern of depending on others noted in the Washington case persisted throughout the case in Michigan and continues for her in Alaska even now. Her brief engagement in services saw Carla's best efforts early on in this case. But even then, the biggest problem was her inability and unwillingness to recognize how her behavior and choices affected her child. She has never truly taken responsibility for the trauma and injuries to her child, nor engaged in any therapy that may have truly allowed her to do so. By way of example, the attachment therapy. She simply left in November of 2024 and has not returned. It seems the support people she has now are more interested in her appearance and participation in these proceedings than she is, receiving very little cooperation from Carla in their own attempts to support her in individual therapy services. Given that this is the pattern that has been in place for over 25 months in this case, and then 6 months in Washington before that, and likely many years before that even, especially if it's true that there are 2 other children out there, it is clear and convincing that there is no reasonable expectation she will remedy these risks in a reasonable time considering the child's age. Return to Carla Collier, who has made no progress and insists her daughter was taken from her based on lies, would most certainly put her in harm's way again. Very real physical, mental, and emotional danger. If the child were returned to Carla, she would have no reassurance that the home that they are in would be stable. Even Carla's Love Alaska support person referred to the apartment as a temporary solution. The child would have no guarantee she would have the food and clothing she needs because Carla remains unemployed. She would be unable to rely on Carla for transportation to the many appointments for physical therapy, occupational therapy, trauma therapy, or even education she needs, as Carla still has no driver's license or reliable transportation. And worst of all, there's no guarantee that Carla would not expose her to physical abuse at her own hands, sexual abuse at the hands of others, or simply just neglect her needs on a global basis. There's no question that there's a reasonable likelihood, based on the conduct or capacity of this child's parent, that the child would be harmed if the child is returned to her own. The best interest considerations. The court considers a number of factors as to the best interest determination to conclude that there is a preponderance of evidence supporting termination of parental rights in this case. A summary in the November 10th, 2025 court report highlights important considerations as to the child's special needs. And I'm quoting, presume this speech here. The current placement is in the child's best interest, as it is the least restrictive and most family-like placement available to her at this time. The foster parents are committed to meeting all of her needs, and they have an understanding of the child's trauma history, as they have had placement of Utica since she entered care over 2 years ago. In addition, the foster mother is a trained therapist with knowledge and education regarding how trauma impacts the child's development and behavior. The placement is willing to provide her with permanency through adoption if reunification with mother is unable to occur. The placement continues to meet all of Utah's physical, medical, developmental, and emotional needs. End quote. The lawyer guardian ad litem offered support for termination in his closing arguments and in support of the goal change many months ago. Finally, the QEW for the native village of Buckland also supports termination, rounding out all available experts considered in this case. There's also the matter of the parent-child bond to consider. The attachment between this mother and child was characterized early on, quote, an insecure, ambivalent attachment style, quote, between Carla and the child, signaling the child and mother did have affection for one another, but it was characterized by mother's inconsistency, danger during periods of untreated mental health, lack of parenting skills for her special needs child, and even her negligence in allowing sexual trauma against her daughter in the past. The child seemed unfazed by some of her mother's very real emotional outbursts behavior during visitation, further supporting this court's conclusion that the bond between mother and child caused more harm than good for Utica. She refers to her biological mother as Carla and to her foster parent as mother. She looks to her foster mother to provide the many services, both regularly and extraordinarily, and the foster home has gone above and beyond to secure evaluations, therapies, extracurricular activities, and even private school education for the child, welcoming her into their family, never giving up on her when her behaviors make it heartbreakingly difficult. They have introduced her to Native traditions, maintained connections with her family, Native family members, secured as much information about her heritage as possible, and even honored Carla's request to introduce her to Norse pagan practices, hanging Native and Norse pagan prayers up and engaging with her to ensure she understands them. She has bonded with the sibship she's a part of in her foster home, a stark contrast against the opportunity to attempt to engage with her own biological siblings mentioned by her mother, if it is really true that Carla Calyer has two other older children. She had no information as to their whereabouts or family for the department to even explore for placement. There is no question this child is in the best placement for her to continue her trauma recovery and work on meeting her developmental milestones and where she is now. She's been living in this home since she was 3 years old and is now 7. She has a heightened need for stability and permanency that has been delayed far too long by these proceedings. Therefore, it is the order of the court, parental rights of Carla Collier to Utica Calyer are terminated effective immediately. There will be no more efforts towards reunification or to prevent removal. I'll set a post-termination review hearing. Ms. Collier certainly has a right to appeal, and all of that information will be sent to her, as well as the information as it relates to how to continue to keep her information updated should she choose to do so with the department in the event that her child wants to ask for that information when she hits the age of 18. Unless there's any questions, that's all for today. And I'll go ahead and give the review hearing date after we're offline, because we'll be proceeding under the adoption code from this point forward. The child's father has released his parental rights, and the child will be committed to the Department of Health and Human Services for purposes of adoption, and all proceedings under the adoption code are confidential.
I believe my client is raising her hand. I don't know if the court would entertain a question.
I would invite you to speak with your client, Ms. Sedor.